Federal Court of Australia is now in session. Please be seated.
Yes, call the matters for judgment, please.
NSD 1590 of 20.
Yes, call the matters for judgment, please.
NSD 1590 of 2012, Catherine Gill and others, and Ethicon Sarl and others, and NSD 310 of 2021, Lisa Talbot and Ethicon Sarl and others for judgment.
Yes, I appreciate there'll be a number of group members watching, so let me say something briefly before I identify the orders. The reasons for the orders are set out in detail in writing, which will be available very shortly on the Federal Court website. I'm not prepared to make orders initially proposed by the applicants in these proceedings, as I'm not convinced the proposed payments out of the fund on the current material would constitute just payments, and this issue has been deferred for further consideration. I am prepared, however, to approve the headline or gross settlement sum under Section 33V(1) of the Federal Court of Australia Act, which settles the Ethicon proceedings for a sum of $300 million and the Boston Scientific proceedings for $105 million. In Fowkes and Boston Scientific, I make the following orders. 1. Pursuant to Section 33V(1) of the Federal Court of Australia Act, the settlement of these proceedings between the parties on the terms set out in the settlement deed executed on 12 July 2022, as varied by the deed of variation of settlement deed executed on 26 October 2022, is approved. The settlement approval in Order 1 is subject to the separate and later determination of what orders should be made as are just with respect of distribution of the money paid under the settlement pursuant to Section 33V(2) of the Federal Court of Australia Act. Within 7 days, any party opposing the appointment of a referee to put the administration of the settlement to tender, file and serve submissions, and 4, the proceeding be stood over for a case management hearing on a date to be fixed. And I publish my reasons. In respect of the Gill and Ethicon Sarl proceedings, I published 2 judgments. The first, I make the following orders. Pursuant to Section 33V(1) of the Federal Court of Australia Act, the settlement of these proceedings between the parties on the terms set out in the settlement deed executed 10 November 2022 be approved. 2, the settlement approval in Order 1 is subject to the separate and later determination of what orders should be made as are just with respect to the distribution of the money paid under the settlement pursuant to Section 33V(2) of the Federal Court of Australia Act. And I publish my reasons for those orders. And I publish a separate judgment dealing with the proposed appointment of a referee and a rejection of the applications that were made for intervention in the proceedings by tenderers. 1, all applications for intervention by the existing tenderers in relation to administering just distribution of payments from the settlement fund approved in these proceedings be dismissed. 2, the proceedings be listed for case management to make orders as the determination of just distributions from the approved settlement fund, including as to unpaid costs and disbursements, and further as to the appointment of a referee to conduct an inquiry and report into the appointment of a scheme administrator on a date to be fixed. And I publish my reasons. Yes, call the matter for interlocutory hearing, please.
NSD 103, 2023, Lehrmann and Network 10, and NSD 104, 2023, Lehrmann and News Life Media for interlocutory hearing.
See ya.
Perhaps if the parties can come to the bar table, please.
Didn't realise you were still there, Your Honour. Good morning, Your Honour.
Would the parties in the Lehrmann matter be so kind as to come to the bar table to commence the application, please?
Do you want to sit here? Renee?
I don't mean to unduly hurry up the applicants, but I wonder if they would come to the bar table and commence the application.
Sorry, Your Honour, I wasn't sure if this matter had been called yet.
It has been called.
Wybrow on behalf of
Yes.
the applicant.
Thank you.
With my junior, Mr. Olsen.
Thank you.
May it please the court, I appear with my learned junior, Mr. Senior, for the first respondent in the Network 10 matter.
Yes, Dr. Coles.
May I please the court, Your Honour, I appear with my learned friend Mr. Dean for the second respondent in the Network 10 matter.
Yes, Ms. Chrysantha.
May it please the court, I appear with my learned friend Mr. Mukherjee on behalf of the respondents in the news matter.
Thank you, Ms. Endom. Yes, Mr. Wybrow.
Your Honour, we're here today to move on the application for the extension of limitation period. There's been quite a flurry of paperwork in the last even 24 hours. Mr. Svillens is here. He's been asked to be available to give evidence or to be cross-examined.
Can I ask, can we proceed this way,
Yes, sir.
please, Mr. Wybrow? Without yet reading your evidence, I wonder if you could just identify, and I'll ask the respondents to also identify, the material they propose to rely upon in relation to the application. I'm not going to take objections now, nor do I ask you to read the material. I just want to make sure that I've got all the material because, as you correctly say, there's been somewhat of a tsunami of material that has been sent through.
Yes, Your Honour.
Not all of it appears to me to be apparently relevant, but in any event.
Your Honour, the applicant relies in its application on the affidavit. There's 3 affidavits from the applicant's instructing solicitor, Mr. Svillens, spelled S-V-I-L-A-N-S, dated 1 March 2023, dated 10 March 2023, dated 14 March 2023.
Yes, all right, thank you. And that's the universe of material?
The evidence for the
Yes.
applicant.
And yes, perhaps I can go to you next, Mr.
Yes,
Dr. Collins.
Your Honour, the parties have put together, albeit hurriedly, a joint court book. I don't know whether Your Honour has access to
I don't have that, no. Well, I don't have it in paper. I think I...
Your Honour, I'm told I have a hard copy for Your Honour.
I've got a copy. I thought that had been put together by my associate, but
Your Honour,
there's
be assisted
no...
by a hard copy.
Thank you. I don't have extra.
So, Your Honour, there's an index to that document, which
Oh, that's
may be
useful.
a convenient way of talking Your Honour through it. For our part, Your Honour will see document 2 comprises an outline of submissions by Network 10 and News. So Network 10, the first respondent in the Channel 10 proceeding, and each of the respondents in the news proceeding have filed a single set of submissions and rely on the same evidence. So Your Honour has a submission there at tab 2. Your Honour has supplementary submissions at tab 4, we rely on two affidavits. They're documents 7 and 10, an affidavit of our instructor, Marlia, M-A-R-L-I-A, Ruth Saunders, made on the 10th of March, and a second affidavit by Ms Saunders on the 15th of March.
Thank you.
One other matter, and that is, Your Honour, we have an outstanding request under section 166 of the
No, I'll come to that presently.
Please.
Yes, Ms Crescento.
Your Honour, I read the affidavit.
No, I'm not asking you to read it.
I rely on the affidavit of my instructing solicitor Anthony Jeffries, sworn 10 March behind tab 8, and the exhibit to that affidavit behind tab 9, AJJ1.
I don't have tabs, unfortunately, but yes. So is that the only affidavit
No.
you've got?
I also tender a supplementary.
No, I
tender
don't want you to
bundle.
tender
Sorry,
or read
we
material. I
rely
just
on
want you to identify it.
a supplementary tender bundle that is comprised of some additional documents from subpoenaed material and material that has been produced. I've got copies for my friends. We emailed them, but I've got printed copies as well. And as a final matter, I also rely on a copy of a statement of claim filed in this court in another proceeding, which I haven't notified, which is a statement of claim in the matter of DeBellin and Nationwide News.
Provide me a copy of that and we'll deal with that tender in due course. All right, well, thank you for that. I have all that material. So I'll,
I
yes,
should say, Your Honour, there's an outstanding notice to produce dispute in relation to a category of a notice to produce that my client sought, and I would seek access to that material as well, which we may seek to tender.
have you got a copy of that notice to produce?
The notice to produce appears in my instructing solicitor's affidavit. And there's an application filed by the applicant to set it aside, which I think has all the relevant material and correspondence.
What
I
page?
don't think is in the court book, regrettably. I'm
Not in the court
sure.
book.
The applicant has copies of its application and supporting affidavit. The notice to produce is found on page 390 of the court book. It was called on yesterday,
Yes.
and there was nothing to produce in answer to items 1 and 2. In relation to item 3, an application has been made to set that category aside. And there's an affidavit, a supporting affidavit of Mr. Spillins in relation to that application.
Yes, all right. Well, so this notice to produce has been called upon and has been adjourned till this morning, has it?
Yes.
And there's an application to set aside paragraph 3 of the notice to produce, is there?
Yes.
Yes, all right. Well, I'll deal with that application now.
Your Honour, I move on an interlocutory application dated 16 March 2023 to set aside paragraph 3 of that notice to produce. I read on that application the affidavit of Paul Spillins, sworn on the 14th of March.
Ms Olsen, do you have copies of those? Thank you.
I don't, I'm sorry.
Any objection to this affidavit?
No, Your Honour.
Well, I note that the affidavit of Paul Victor Slevins,
Spillins.
sworn 14 March 2023, is read on the application.
Shortly put, Your Honour, the position is this. There is a document called a Cellbrite extraction report, which is a document produced by a technical examiner at the AFP who downloaded the entire contents of Mr. Lehrmann's phone during the course of the investigation of the criminal proceedings.
Yes.
Your Honour looks to paragraph 7 of Mr. Spillins' affidavit. You'll get a sense of what the Cellbrite extraction report includes. It is literally everything on the phone.
Yes, I don't think I need to hear from you further, Mr Olsen.
Yeah, thank you, Your Honour.
Yes, Ms Chrysanthou, why shouldn't I set aside a category expressed in such broad terms.
Your Honour, the
When it calls
document,
for documents which on any view of it wouldn't be discoverable in the proceedings pursuant to standard discovery obligations.
Your Honour, if I could just take it one step at a time, we've already had production of parts of this document. So if Your Honour turns to page 475 of the court book.
Well, as I think I said on the last day, I know, for reasons best known to themselves, the applicant agreed to produce a whole range of material which wouldn't be discoverable, and they've done it. But it doesn't mean if an issue was taken with producing further material which is not apparently relevant to the disposition of an issue that the court should require production.
Your Honour, in this matter, by information and belief through his instructing solicitor, the applicant has put in issue his state of mind for the period 15 February 2021 until 16 December 2022. We have reviewed Mr. Svillen's affidavit, and upon review of the first affidavit, notices to produce were issued on behalf of the respondents, to which there has been an answer.
Yeah, but very broad notices to produce, which, to be perfectly frank, in large part I would have set aside because they call for a whole range of documents which wouldn't be discoverable in the proceedings. Now, an agreement was reached between the parties to provide those materials, but that doesn't mean that you're entitled to engage on a fishing expedition in relation to going through this man's entire phone.
Your Honour.
He's put his state of mind in issue in relation to particular facts. If a notice to produce had been carefully calibrated, directed with specificity at requiring production of documents apparently relevant to the disposition of the facts in issue on this application, then I would have allowed it. But to require production in terms of paragraph 3 is a classic fishing expedition.
Well, Your Honour, if I could address Your Honour on that, the Celebrate document is one document. In response to the initial notices to produce, a complaint was made about the onus being put on the applicant to search that document for relevant material, particularly in relation to advice given concerning any potential defamation claim. Ultimately, parts of that document, remembering it is one document and a notice to produce calls for documents, have been produced. So if I could take Your Honour to the court book, there is a segment of those documents that appear in Ms Saunders' affidavit at MRS 15, starting at page 463 of the court book. Now, Your Honour can take it from me that what appears at page 463 and following is parts of that document. So the applicant has acknowledged...
With respect, Ms Chrysanthi, that makes the point I was making with crystal clear clarity. There's a vast amount of this material which couldn't conceivably be relevant to the disposition of this application and couldn't, on any view of it, meet the direct relevance test referred to in 20.14. Now, I appreciate the discovery tests and the apparent relevance tests are different, but I'm not allowing this application to become a proxy for production of vast reams of material which are not relevant to the disposition of this application. There will be, in the event the proceedings continue following this extension of time, these extension of time applications, there will be standard discovery.
If I can briefly just finish the submission very briefly, Your Honour. This document was sought because of paragraph 10 of Mr Svillen's first affidavit, where he says directly that his client received messages on the 15th of February.
Sorry, paragraph 10?
Paragraph 10, and he was asked if it was him. And
Right, just let me turn that up. That's the affidavit of the 1st of March.
Yes, it's behind tab
Paragraph 10.
5.
Sorry, I've read that now.
Yes, and also in that affidavit, something that is relied upon is paragraphs 15 to 23, putting in issue the applicant's state of mind as to advice received. Now, this document was produced in answer to a request concerning those matters. In respect of paragraph 10, Your Honour, for example, can see at page 463, messages that are not in support of paragraph 10, in fact, are to the contrary, if there is such a thing as the opposite of what is said in paragraph 10, where at page 463, Your Honour can see that Mr. Lehrmann's friends did not identify him and were asking him if he knew the woman. And it goes on, exchanges about the allegations in the article, going on to page 465. For example, the second message at 465, do you know who the guy was? And Mr. Lehrmann saying, not the faintest idea, I haven't been approached by anyone, and so on. And there are many messages to this effect that each of the respondents rely upon in the submissions
Yes, but
about Mr. Lehrmann's state of mind. But, Your Honour, it goes on...
I accept that, and there are some representations concerned in these messages which are referred to in submissions that I can understand could be apparently relevant.
Yes,
but
Your
there
Honour.
is a vast amount of material that isn't. And the fact is, the notices to produce that were first served were indiscriminate, calling for such things such as the brief of evidence and the like. And this is a further example of an indiscriminate category of documents. Now, for reasons best known to themselves, the applicants have produced to the respondents what appears to me to be significant material which isn't relevant, but that doesn't mean that when they do seek to set aside a category which is self-evidently too broad, that I'm going to allow it. Now, I think I've allowed you to develop the submission enough. We've got a lot to get through, unless there's anything further.
Very briefly, Your Honour, only what's on page 474, which is in direct contradiction to the instructions Mr. Lehrmann has given Mr. Svelens, where in the...
Well, you can make submissions on the basis of what's at page 474.
Your Honour, but we have been given 1 day, and there is a broad-ranging submission, and there is evidence relied upon by the applicant that he had a state of mind as to his legal advice from time to time until the end of 2022. And this document...
That can be explored, Ms. Chrysanthou, but I'm not allowing you to go holus bolus through a whole range of material which on any view would be irrelevant. It's too broad, and as I say, I think I've allowed you sufficient time to develop the submission, unless there's anything else you wish to say.
Only, Your Honour, that we don't seek a category of documents, we seek one document. And
you seek one document which is a computer file which contains a whole lot of irrelevant information. The notice to produce could have been calibrated in an appropriate way. Not only this notice to produce wasn't calibrated in an appropriate way, the other notices to produce were self-evidently too broad. I propose to set aside paragraph 3. Do you wish to have reasons? Well, I don't think you'd want them. Ms. Chrysanthou?
Your Honour, I think I do require short reasons.
All right, well, I'll deal with those when I deal with the application. Yes.
Yes, Your Honour, the applicant reads the affidavits. I note the affidavit of 10 March. So I understand by agreement with the parties.
Well, can we just deal with it one by one?
Yes.
Do you read the affidavit?
Read the
of
affidavit of 1 March of Paul Victor Spillins.
Any objection to that affidavit?
Your Honour, the objection rests upon the outcome of the Section 166 issue. So the affidavit contains a raft of, the entirety of that affidavit from paragraph 2 is said to be based on hearsay representations from a single source, Mr. Lehrmann. But all of the respondents have issued requests under Section 166 of the Evidence Act, requesting that Mr. Lehrmann voluntarily give evidence in respect of many of those representations. Not all of the representations are the subject of challenge. They're identified for our part in a request dated the 15th of March 2023 that Your Honour will see at Court Book 733.
733?
Yes, 733 at 735.
Just let me turn it up. 733.
Sought to narrow it, Your Honour, only to matters which are genuinely in issue between the parties and as to which we say Your Honour would better assisted by direct evidence. So
yes.
the matters in paragraphs effectively 13 to 23.
So it's essentially just to frame the objection.
Yes.
As I understand it, you object to the representations contained in the paragraphs you specify in paragraph 5.
Yes.
But that is dependent. That objection is dependent upon the resolution of what you say the remedial response is to the failure to comply with what you contend to is a reasonable request. That is, if I was to make an order that the applicants be required to call Mr. Lehrmann, you wouldn't press the objections?
That's so, because in those circumstances, we would be entitled to test Mr. Lehrmann in respect of the representations and test Mr. Spillins.
And in the alternative, I think, the other remedial response you say to what you contend is the unfairness in producing the evidence of this way, if I was against you in respect of the request in making an order that you call Mr. Lehrmann, you would seek an order seeking the discretionary exclusion of the representations you've identified in that paragraph.
That's so, in reliance on section 169. Can I just say, Your Honour, we put it the other way around. That is, it's really a matter for the applicant in our submission as to what evidence he wishes to adduce in support of this application.
Well, that's why I asked at the beginning the clarification of what evidence. Now, they don't propose to call, the applicant does not propose to call Mr. Lehrmann unless I make an order that they call him.
Follows from that in our submission that there's been a failure or refusal in the language of the Evidence Act to comply with a request which we submit is reasonable. In those circumstances, the appropriate remedy is the second remedy that Your Honour identified in our submission, that is the exclusion of the contested paragraphs identified in paragraph 5 of our letter of 15th of March.
I understand that. Dr. Collins, thank you. Ms. Crescento.
Your Honour, we take an additional step. We say at the outset the paragraphs should be excluded under section 135 because they're so vague in their nature and unhelpful that the prejudicial effect and the likelihood of causing unnecessary cost and confusion substantially overwhelms the probative value. So our initial objection is under 135 that Your Honour just exclude the paragraphs. If Your Honour proposes to not exclude them on that basis, on the face of them, then we press our request under section 166F of the Evidence Act, which has been notified. It's in the court book. It was notified, it's at page 731 in very similar terms to my friends.
In a sense, though, don't I have to deal with the section? I understand why you make reference to 135, but in a way, I have to deal with the 135 issue together with the issue of exclusion of the material pursuant to the remedial provisions in 167, because in dealing with the discretion under 135, I've got to take into account the 192 factors in any event, and one of the factors relevant to the 135 discretion would be everything that's occurring in relation to these representations, including whether or not a request had been complied with.
Yes, and that doesn't necessarily, though, require Your Honour to take the next step and consider whether an order should be made. Your Honour can deal with the 135 objection at the outset by noting a request has been made and refused and looking at the paragraphs themselves and seeing how broad brush they are and how they're impossible to test either on the most part by any date, by it being linked to any particular event. I should add on the 135 objection, I don't wish to mention the war, but the parties did issue a notice to produce in relation to this advice and a subpoena to Mr. Corn, and nothing was produced. In fact, what has come about is that Mr. Corn did not have a file, did not make a file, did not render invoices, does not have any file notes, and we're precluded, and that is relevant. I don't think that's in dispute on the left. That's relevant to the 135 objection, that there aren't even contemporaneous documents that we can look at to test these very broad brush propositions.
Can I ask, is there anywhere where you have, am I to proceed on the basis that your objections are the same as the objections identified on top of page 734 in the letter from Dr. Collins instructing solicitors?
Ours were slightly more limited. Ours were at 731.
731.
So My learned friend's objections, I think if Your Honour's looking at a Venn diagrams, ours are a slightly smaller subset to my learned friends, but they capture the same sort of material.
But they're subsumed in that larger group, are they?
Yes.
Yes.
I'm sorry, I may have inadvertently misled Your Honour. The paragraphs identified in paragraph 5 of the letter at Court Book 734 are all of the representations in Mr Svillin's affidavit. The paragraphs to which we take objection are listed in page 735, enumerated in paragraphs 1 to 10. So that too is a subset.
I see. Oh, thank you.
Apologise
Yes.
for that.
No, not at all.
So it's our position that Your Honour doesn't have to consider the making of the order until Your Honour determines the 135 objection in the context of the utter failure of documents in relation to Mr Corn and the fact that a request has been made and refused.
So what order you press your applications in? As I apprehended from what you said, you want me to deal with the discretionary exclusion under Part 3.11 of the Act, the Section 135 issue. If I'm against you in relation to that, you press, do you, an order under 167 requiring the applicants to call Mr Lehrmann, do you? And thirdly, if I'm against you in relation to that, do you say that there's some sort of separate analysis I need to go into for the purposes of determining whether or not the material or the representations should be excluded pursuant to section
1691C.
169.
So we say the steps are these. Your Honour looks at the affidavit.
But did you say that's a separate?
Yes.
I would reach a different conclusion than I'd reach in respect to the section 135 analysis.
Yeah, yes, Your Honour, because possibly for reasons of case management under section 37M, having regard to the interlocutory nature of the application, the time available to the court, and the other factors that Your Honour raised last week, Your Honour would form the view that in the circumstances, it's not appropriate to make an order under section 169 that Mr Lehrmann present himself to give evidence. But having regard to the fact that Your Honour's made that order, the unfairness under section 135 is considered, the unfairness is considered anew. And when Your Honour looks at the Evidence Act, section 1691C, Your Honour will see the factors that Your Honour takes into account. And the factors are in subsection 5. I should have notified Your Honour in the context of
it
this.
seems to me I've got to take this in stages,
Yes.
and this is why I'm having difficulty in understanding a world where I would entertain a discretionary exclusion under 135, and yet I wouldn't also exclude the adduction of the same representations under 167 or 169. 169.
It seems that the factors under 169 are broader, arguably.
Right.
Well, in relation to
But
subsection...
that's why I'm having difficulty understanding why I just wouldn't deal with it through the prism of because the first can I say this? I would have thought it's the other way around, because there are three requirements for a request under section 167A. First, there must be a request. The request must be reasonable, and importantly, it must be a reasonable request for the purposes of determining a question that relates to a previous representation. And as the Court of Appeal said in Trimcoal, to determine this, one must identify with precision the representation. Now, it may be that I form the view that there has been a maladroit request, the request is not reasonable, or there's been a failure of specificity, and yet I would still form the view that there is a relevant unfairness for the purposes of section 135. Given one is broader, don't I have to deal with the broader one? And if one is more tailored, dependent upon the request. But even if I'm against you in respect of the request, then it would seem to me there'd still be a residual discretion at a 135.
Yes.
That's why I would have thought it's the other way around.
Yes, Your Honour, but possibly to save the need to deal with the 167 to 169 procedure, if Your Honour looks at the evidence and has regard to the fact that, and I should notify Your Honour, we've made a second request in relation to Mr Corn. We were served with an affidavit, so-called, perhaps in reply,
Well,
Mr Spillin's
you raise an interesting point.
third affidavit.
Because that's why I say there needs to be precision with
Yes.
the request. The fact that Mr Lehrmann said this to his solicitor is interesting and may be relevant, and is relevant potentially. But what really is the representation is what Mr Corn said to Mr Lehrmann.
Yes.
Now, I don't understand that has been the subject. I haven't seen a
Yes.
request in respect of that.
We made a request, Your Honour, and that request is found on page 742.
42.
Sorry, that's the response. The further request is at, sorry. I hope it's in the court book.
Well, look, I think I understand how it works. I think
Yeah,
I need to...
732, Your Honour. So as part of that same request, at page 732, the sequence was we received the first affidavit on 1 March. On 8 March, many documents were produced on subpoena and by the applicant. On 10 March, the respondents put on submissions where they
All
relied...
right, well, no, I see 732.
Yes.
I understand the point.
So that
Look,
request
I
has
think
been
we
made.
should. I think we should. I understand the submissions in general, but I think we should do this with some degree of
Yes.
rigour. So I think if you, I am going to deal with the issue of the request. I'll deal with the 135 issue at the same time. So if there is any evidence that you wish to adduce on the voir dire in relation to this, then you should identify it, and I will proceed to then deal with the relevant discretions.
Yes, Your Honour. We first rely on the requests that are made by each party and the response. Your Honour will see...
Where do I see those?
The requests start at page 731. I think I can do it on behalf of everyone to just put all the requests in. The first request is my instructing solicitor in relation to Mr Lehrmann and Mr Corn at 731 to 732. Then the request by Thompson Gear on behalf of the other respondents starting at 733. It goes to 736. And then there's a request at 737 from the News Limited parties, which is identical to the Network 10 request.
Yes.
Then there's a response at 742 from Mr Lehrmann solicitors, Mark O'Brien Legal.
Yes.
And in particular, that's a response to our notice, where Your Honour will see it said that Mr Corn's not available.
Yes.
And then there's a response from Mark O'Brien Legal at 743 and 744 to the other two requests by the other respondents. Your Honour,
So which pages? Sorry,
743 to 744.
All right. Well, does anyone have the objection to me receiving on the voir dire pages 731 through to 744 of the court book?
Not from the applicant, Your Honour.
Your Honour, we also tender... there's no objection.
No objection.
Okay.
No.
Right. Well, I'll mark pages 731 to 744 of the court book, exhibit VD1.
Your Honour, I also tender a series of messages that were produced in answer to a notice to produce by Mr Lehrmann, which is annexed to Ms Saunders' affidavit and is MF15, and it starts at page 477 of the court book.
477?
Yes. The actual document starts at 463. The relevant material...
Sorry, you're going too quickly for me.
Sorry, Your Honour.
463
is where the document starts, MRS 15. This is,
I'm not going to allow all this material to
no,
go
it's
in.
not all of it, Your Honour. I just wanted to tell Your Honour where the document starts, and I'll tell Your Honour which messages we rely on specifically. There's only a handful of them.
Yes.
We rely on a message on page 472. Third message identified as 94670. And
94670. Yep.
dated 15 February 2021 at 5:06 p.m.
Yes.
from Mr. Lehrmann to Greta Sinclair, which says, if I'm named tonight, then he says I'm up for millions as defamation. On that message. Then we rely on a message on,
Why is that relevant on the voir dire?
because it is relevant to the representations made in Mr. Sphelan's affidavit as to advice given to Mr. Lehrmann that day by Mr. Corn. We say these documents are contemporaneous documents of Mr. Lehrmann's state of mind that contradict the hearsay representation that is made on behalf of Mr. Lehrmann in the affidavits.
Right. So there's that one?
Yes,
Yep.
at 473, it's a series of messages on the whole page, starting at 15 of the 2nd, 2021, and it's message 74732, and it's messages between Mr. Lehrmann and Greta Sinclair. I think in fairness the whole page should go in, but the key messages that we rely on is the third from the bottom, 74737. Starting at 735. Thank you, Mr. Collins, Dr. Collins. 794735. From Mr. Lehrmann to Greta Sinclair, Warwick doesn't think I will be named.
Yes.
So that's a reference to at least the timing as to when he's speaking to. And then at 74737, if I am, then he, Channel 10, as well as the Government Department of Finance are up for a lot of money.
Yes.
And then over the page at
So those three, that is 3475, 94735, 94736 and 94737 are the three you
yes,
seek to tender?
yes,
Or you tender, rather?
at page
Any-
474.
I'll come back at the end if there's any objection to the identification of these messages. Yes, what's
Yes,
the
at
next one?
474, at the first message, 94813, Mr. Lehrmann says to Miss Sinclair, I'm just getting reassurances. And then Miss Sinclair responds, and at 94815, Mr. Lehrmann says, I want to be sure about things. And then at 94817, he says, criminal, he says, is off the cards completely.
Sorry,
94817. Mr. Lehrmann says to Miss
Yes.
Sinclair,
Yes.
cards completely.
Yes.
And then he says at 94818, one, it's false, and second, they have nothing.
Yes.
And then at 94819, but we may have, there's a typo that he corrects in the next message, civil.
Right, well, I got 1, 2, 3, 4, 5, 6, 7 on that page. Yes.
Then at 475, I tender the third message from the bottom, which is 94835.
Yes.
I probably, to understand who he's talking about, need to tender 94832.
Sorry,
I
948.
think to understand 94835, I have to tender 94832,
Yes.
which says, but I want to know if someone calls me, I refer them to Rick.
Yes.
And then at 94835, and he said tonight, I won't
Yes.
see the light of a courtroom.
Yes. All right, well, I see those.
Yeah.
Yes.
And also 94837, on the bottom of that page, he wanted me to keep it locked down. And then at page 476, the last two messages 94971. I've got two lawyers now.
You say 4?
Yes, 94971. It's the last two messages. I've got two lawyers now, from Mr. Lehrmann to his friend.
Oh, that's the second. That's the penultimate one
Yes.
on my page.
Yes. And then 94972, criminal,
Yes.
over the page. 94973, who says it's joy his realm yet.
Yes.
Another who says I'm up for a bit. Money, sorry, I'm up for a bit of money.
Yes.
94975 is a correction to the previous message.
Yes.
And then the last three messages on that page, 477, 94978, is from
All right. I just want you to identify them at the
Yes.
moment. 1, 2, 3,
9,
4,
4,
5,
9,
6.
7,
There's 6 on that page. Yes.
Yes. And then, so that's from the other person too, Mr. Lehrmann. 94979. And 949.
No, I've got the last. I've got
Last three,
the
yes.
last 3. Yes. So there's 6 on that page. Yes.
And then the next page, 94983, which is the third one.
Yes.
94984.
Yes. Yes.
94985. 94986.
Yes.
94987 and 94988.
All right. So there's.
Those are the messages I tender.
Right. Well, just let me identify those. So there's one message on page 472. There are 3 messages on page 473. There are 7 messages on page 474. There are 3 messages on page 475. There are 2 messages on page 476. There are 6 messages on page 477. And there are 6 messages on 478 that you have identified. Any objection?
No objection to those being relied on, Your Honour.
We rely on the same messages, Your Honour.
No objection, Your Honour. I do seek to tender a few additional text messages.
Yes.
Identify those.
Yes, please. I should say, for the purposes of clarity, that any evidence adduced on one of the applications for extension is evidence in the other application for extension, and any rulings I make on evidence, obviously enough, flow across unless I specifically make an order to the contrary.
Thank you, Your Honour. Sorry, Your Honour, I'm just seeking to identify them. I seek to tender a few messages on page 470. You'll see on page 470 that there are text messages between the applicant and a person by the name of John McGowan in relation to defamation. So the text message ending 96.
94596.
And I should also tender 95, so 94595, to put 96 in context.
Those 2?
Yes, plus the following 2.
So it's the 4 last messages on page 470.
Yes, Your Honour.
Any objection to those?
No, Your Honour.
All right. Yes.
And there are some further messages between Mr. McGowan and the applicant at page 476. So there's the message at the top of the page ending 65. And the message ending 68.
Sorry. 965.
Yes, and
How could that be
9
relevant on the voir dire?
and 94968.
Sorry, 94965.
Yes, so the message at the top of the screen,
Get here.
that's a message between Mr. McGowan and the applicant. So earlier in the evening, there are messages which I've already identified between Mr.
They get
McGowan
here.
and the
So
applicant.
94965. And what's the other one, Ms.
And the next one, 94968.
Okay.
Those two, Your Honour.
Any objection to those?
Only on the basis of relevance. I'm not quite sure how they go to any of the representations.
Yes. How was 94965 and 94968 relevant? Ms.
Only
Enlow?
they're relevant to the earlier text messages I took you to between the applicant and Mr. McGowan. So the two men are talking about defamation an hour or so earlier, and then we see in these later text messages that I took you to that the two men then get together. And then following that, we have the messages that Ms. Chrysanthou took you to, where there's reference to a defamation lawyer.
All right. Well, I'll let them in.
Thank you, Your Honour.
So I'll mark then as Exhibit VD2 the text messages that I've identified. If I could ask one of the solicitors on the respondents team to provide me with a redacted copy of the exhibit for the voir dire. I presume in due course that evidence will be adduced on the application in any event. So I'll give it a separate marking if it's tendered in the applications. And then if we could have that in electronic form and put on the electronic court file.
Yes, Your Honour. Your Honour, I tender the subpoena to produce that was issued to Corn Tlay defence lawyers, and it's found at page 318 of the court book. (318 to 320).
Yes. Any objection to the tender of that subpoena on the voir dire? All right, well, the subpoena to produce documents at pages 318 to 323, addressed to Corn with a K, new word CLAIS defence lawyers, will be marked VD3.
Thank you, Your Honour. And I tender the response to that subpoena, which is found on the following exhibit, page 325.
Well, actually, I'll just mark that part of, I'll mark the response as also part of VD3.
On this application, Your Honour, I also rely upon, in considering Mr Swillen's first affidavit.
So when you say on the application, do you mean the voir dire? Or
Yes,
the
on the voir dire.
Yes.
Your Honour, in addition to Mr Swillen's first affidavit, I also rely upon the representations in Mr Swillen's third affidavit at paragraph 4. And that's at page 396 of the court book.
The representations on page.
Paragraph 4 at page 396.
You're tendering, are you? Paragraph 4 of the affidavit of Mr Swillen's of 14 March 2023.
I'm not tendering, Your Honour. I say that in order to consider the 166 to 169 issue, Your Honour needs to look at both of Mr Swillen's affidavits together, because the first affidavit deals with the representations from the applicant's perspective. The third affidavit deals with the representations from the perspective of Mr Corn. So the information and belief affidavit in the first instance is from Mr Lehrmann's instructions.
Well, I just want to get clear. Are you tendering that material at
No,
4
Your
or
Honour.
not? Then why am I being taken to it?
We're objecting to the same material as part of the same application, and we say it's relevant that two different versions have been given by Mr Lehrmann and Mr Corn to Mr Swillen's of the same conversations.
Well, if it goes in for all purposes, subject to a section 136 limitation.
But it's not a tender, Your Honour. It's an application
Well,
that
it is if
concerns an
people
objection.
well, I'm just saying this, if it's tendered on the applications.
Your Honour, Mr. Lehrmann seeks to also read this affidavit, and we object to paragraph 4 as we've given notice.
Well, I don't think you need to tender it on the voir dire then.
Thank you, Your Honour.
Yep. Now, is there any other material on the voir dire?
Not from us, Your Honour.
No, Your Honour.
I tender a couple of the messages for the voir dire, so be relevant to our submissions.
Yes.
Firstly, on the voir dire, I would tender paragraph 4 of Mr. Spillin's affidavit that Ms. Chrysanthe was just referring to.
Well, I'm dealing with the objection of that. You don't need to adduce that into evidence on the voir dire.
In relation to in relation to what I understand is a submission as to the 167 issues, in addition to the messages that have already been brought to your attention, Your Honour, we would additionally rely on, have in evidence on this point messages 94574.
Sorry, what page are we on? Sorry, Mr.
467 to 468.
467. Just let me get back to that.
So it's the bottom
Yes.
two and the first two. Bottom two of 467 and the top two of 468.
This is 94568, is it?
94574 to 94577.
So that spans 2 pages.
Yes, it just spans 2 pages.
All right, any objection to that material? All right, the material on page, the last 2 messages on page 467 being 945578 and 94575 and 94576 and 94577 on page 468. I think it'll be easier if I just make that part of VD2.
And 2 further messages, and that's it on page 465 of the court book. Messages 94545 and 945.
Sorry, I
apologise.
On 475, I'm sorry. I was just doing a marking. Yep. I've got page 475 in front of me.
465, Your Honour.
465, sorry. Yes.
They are the second and third messages on that page, 94545, 94546.
All right. Now, those 2 messages, any objection to that also forming part of the... Right, well, those 2 messages on page 465 will also form part of VD2 and can be included when that in the exhibit when it's presumably tendered on the application, if it is. Yes. Yes. Now, in outlining the argument, Dr. Collins and Ms. Chrysanthe, do you want to say anything? I'm coming to come back to you for any further submissions after I hear from Mr. Wybrow, so I'm not seeking to shut you out of anything you wish to say on the matter.
Your Honour's heard our broad outline. Perhaps, does Your Honour wish us to make our points clear so Mr. Wybrow can respond? It's our application. It's a matter for Your Honour.
Well, sorry, I thought I did understand what you were saying, but if you wish to elaborate.
Well, only in the context of the evidence that's now been put before Your Honour on the voir dire. What Your Honour has is 3 different versions of the same conversations on 15 February 2021. Mr. Spillin's on information and belief gives evidence in his first affidavit. And this is the evidence to which objection is taken. Starting with the introduction of Mr. Corn in paragraph 13 at page 69.
Yes.
But 13 and 14 on their own are innocuous. But then from paragraphs
Sorry,
15,
I've got the affidavit of 1 March. Which paragraph numbers did you want me to?
paragraphs 13 and 14 introduce Mr. Corn,
Yes.
and then they're pretty innocuous that they looked at
Yes.
the matters complained of, or the matters.
Yes.
Paragraphs 15 to 23 then purports to give a conversation, paragraph 15, on the 15th of February 2021. Now, it seems to us that Mr. Lehrmann's instructions to Mr. Svillens about that conversation are inconsistent with what appears to be his state of mind that evening as revealed by the text messages.
Well, all you say is there's a bona fide dispute about those representations, and you think it would occasion an unfairness in all the circumstances to allow second-hand hearsay to get in this way in all the circumstances.
Yes, particularly having regard to the fact that Mr. Corn has given instructions to Mr. Lehrmann on information and belief in paragraph 4 of the third affidavit, to Mr. Svillens, that appear again to be inconsistent with the other two versions.
I think I can deal together with given it's really the same point, I think I can deal together with the paragraph of the affidavit in which there are representations. But I do want to do this with a degree of precision. Usually, at least when I was involved in doing requests, you'd have a schedule which would set out the representations with specificity, and you'd say why they are reasonable, why you've made a reasonable request, but what the representations are. I have that. Dr. Collins has given me that in the letter, but I just want to make sure I understand what are the relevant representations which you say are the subject of the request. As the Court of Appeal indicated, that's really the first step. So I had there was the letter that Dr. Collins referred me to, which unfortunately I didn't mark. What page was that, Dr.
Page 735.
Sorry, I didn't quite hear that.
736,
What was the page?
735 to 736
735 to 736.
are where the representations appear. In the top of
735. Yeah.
5.
Now, there's 1 to 10. I understand the representations which are the subject of this request are identified by Dr. Collins instructing solicitors at paragraphs 1 to 10 on page 735.
Yes.
And in the paragraph immediately below.
Which is part of VD1.
Sorry, Your Honour, just below paragraph 10, there's then a reference to Mr. Svillens' third affidavit, paragraph 5, so that perhaps should have been numbered 11.
Yes, all right. Well, thank you. So they're the universe of the representations identified, 1, and I will mark that as 11, so 1 to 11.
That's in relation to Mr. Lehrmann. In relation to Mr. Corn, it's paragraph 4 of the third Svillens affidavit.
And it's so paragraph 4 of
Svillens affidavit of 14 March.
14 March, all right?
So that's in relation to the request concerning Mr. Corn.
Well, so I'll say 12. That it's each of the it's a representation constituted by 4A, 4B, 4C and 4D.
Yes, Your Honour.
Affidavit of 14 March 2023. All right, well, I'm going to proceed on the basis that the representations in respect of which the request is made are 12, being the 10 numbered paragraphs on page 735, 11 being the additional paragraph of that letter, and 12 being each of 4A and 4C in the affidavit of 14 March 2023. Yes.
And we say that it's a reasonable request under section 167, defined in section 166, in particular C and F. In relation, in F, to evidence of a previous representation, to call as a witness the person who made the previous representation. In this case, in relation to the identified representations, Mr. Lehrmann, and in relation to the last identified representations, Mr. Corn.
Yes.
Your Honour has seen the correspondence where the request.
But aren't really many of the representations in 1 to 10, in truth, representations recorded that are by Mr. Corn to Mr. Lehrmann, rather than the representations by Mr. Lehrmann to his solicitor?
They're both
what
relevant.
Matters?
They're
What matters is the truth of the representation by Mr. Corn to Mr. Lehrmann.
I would have thought so, Your Honour, but there's a 2022 Queensland Court of Appeal decision about a Dr. Akabri that's in the list of authorities relied upon specifically by the applicant. And in that case, the plaintiff received advice from the solicitor, and there was a difference of opinion between the solicitor's file note and the plaintiff's evidence, who gave direct evidence, as to what that advice was. And it was plain from the file notes that the solicitor had given certain advice, and it was also clear that Dr. Akabri had misunderstood that advice and not proceeded to commence the claim within time. And the question in the Queensland Court of Appeal was, first of all, whether the plaintiff's evidence should be accepted over the file note, which it was. It was accepted that the solicitor gave the advice and the doctor misunderstood it. And then the next question was whether his understanding was reasonable or unreasonable, having regard to the actual advice given. So in these circumstances, there's two forms of representation. There's the actual advice given, which is a representation from Mr. Corn, but then there's also the representation from Mr. Lehrmann to Mr. Svelens as to his understanding of what he was told.
I understand that, and that's why I'm trying to separate, because I say there are two types of representations, but it seems to me in the circumstances of this case, what really matters is, given the nature of the advice that is said to have been given, it's really not something to admit of ambiguity. It was either given or it wasn't given, and I would have thought that it's really what matters is the representation of the advice given by Mr. Corns. But in the end of the day, I don't think it really matters very much.
Only in one respect, Your Honour, that in the third affidavit that we received on the 14th of March, Mr. Lehrmann seeks to undermine the text messages that have now been produced, in the sense that he, through the representations of Mr. Corn, it's said that Mr. Corn disagrees with what is recorded effectively in those text messages as to the advice that was given. So Your Honour's been taken to text messages which seek to summarise both criminal law advice and defamation advice, both which are relevant to this application. The criminal advice being, "I'll never be charged," or words to that effect. "This is hopeless, I've got nothing to worry about." And the defamation advice being, "You've been defamed and you're up for a lot of money," or words to that effect. Now, Mr. Corn has told Mr. Svelens on 14 March that he didn't give advice to that effect. And in particular, in 4B, there is no second solicitor or defamation solicitor, according to Mr. Corn. In 4C, he doesn't agree that he told Mr. Lehrmann he was clear of any risk of being prosecuted.
Yes.
And in 4D, he says something about the weight. So what we have is quite a distinct understanding, if you compare the text messages to what Mr. Corn is now saying.
Can I try to shortcut this and
Yes.
say Mr. Wyberg would know where to focus his submissions? It's all come on relatively quickly, so I don't think I can be too critical of the terms of the initial request that was made. And I do think that there there appears, subject to anything Mr Wybrow makes, some sort of bona fide dispute as to what passed between Mr Corn and Mr Lehrmann at relevant times. And I accept that. And I'll hear from Mr Wybrow shortly as to why I shouldn't form that view. What I will need your assistance with in due course is why this particularly matters, given the nature of the tasks that I'm engaged in and the fact that this was a man during the limitation period who was facing criminal charges, in truth, and it's reasonable to infer objectively from the circumstances that any solicitor who wasn't acting in a very strange way would have given advice not to commence defamation proceedings.
Your Honour, for the first half of the...
And why this isn't an ordinary case of the type the full court talked about when it was talking about the difficulty with someone in those circumstances commencing defamation proceedings.
For half of the limitation period, Mr Lehrmann did not have extant charges, as occurred in Ducador.
Appreciate it.
And in the other cases, Dr Akabri's case, in Spedding, in Hooter, all of those cases involved publications which effectively were the charge or referred to the charge that had already
Why was he
occurred.
required to commence defamation proceedings in the first half of the limitation period?
That's not the test. The test
I know it's
is,
not the test.
was it
but
unreasonable? Was it
you're
not
the one who
reasonable?
raised the fact that he wasn't charged till halfway through. I'm wondering what that relevance is.
Because the limitation period is an entire 12 months. Was it not reasonable for that entire 12 months to not commence? The test is not whether it was not reasonable on the last day. There's 12 months with which to commence. We'll be taking, Your Honour, to the amendments that brought in the 1 year limitation. It used to be 6 years, as with other torts, and there was quite a drastic legislative position taken
I understand.
to reduce it to 1 year. And the purpose of that reduction was the public interest in immediately seeking, or as quickly as possible, seeking to rectify a person's reputation. And so the notion that we only have to deal with the last day of the limitation period and not the first 6 months, we say is wrong. And Mr Lehrmann has the onus on this application to demonstrate that it was unreasonable or not reasonable for him to commence for the entire period. And
Is the logic of that that if I formed the view that it wasn't, just say it wasn't reasonable for the first 7 days after publication, but it became wholly unreasonable for the 51 weeks thereafter, then an applicant would lose a limitation extension. That's the proposition.
no, Your Honour, it's always a matter of degree. But here we have literally half of the period in which there's no extant charge, so that the so-called ordinary rule, which we actually don't accept should be seen as correct.
Well, I have to see it as correct because that's what the full court said.
Well, we formally say it's not, because insofar as all the defamation barristers sitting at the bar table are concerned, many, many, many cases are brought by persons who have been charged, by persons who are accused of criminal offences and have not been charged and might be charged. I mean, that is most defamation cases. Most defamation cases in this court concern serious conduct amounting to crimes. The only other category really is serious professional incompetence or negligence. So in circumstances where the media often accuse people of crimes, whether there's extant criminal proceedings or not, it seems wrong to us to have some sort of rule that a plaintiff is entitled to avoid the 1 year limitation period, which is an entitlement given to the media and to publishers, and an entitlement they're entitled to rely on in the conduct of their affairs and their businesses, that they can just avoid that because they've been accused of a crime, and perhaps it's possible, having been accused of a crime, there might be a charge.
Anyway, you'll have plenty of opportunity to develop that, including your submission.
But that is why,
Sorry, just let me finish. You'll have plenty of time to develop that submission, develop your submission why you say the full court is wrong, which I presume is a formal submission that's been made to me. I hadn't appreciated the submission was going to be made the full court is wrong, because I may well have considered reserving a question for the full court, for the full court dealing with the application. But in any event, I'll hear those submissions in due course. At the moment, what I'm seeking to deal with is as an analysis of the importance of this evidence. I understand your ultimate submission about that. All I'm saying is that I accept in your favour that the applicant has put this on 3 bases, and this is one of them, the advice.
Yes.
They obviously think it's relevant, and I have to deal with it. And I'm with you in relation to the fact that there appears to be a bona fide dispute on the advice point. The only point I was making is that it doesn't seem to me to be the real issue you need to confront on this application. That's.
And I should say our primary position, Your Honour, is that we distinguish Ducador because Ducador is concerned with a case, as I've said, where the charges are extant at the time of publication and are so intrinsically connected that the publication is in effect reporting on the charge.
Well, I'll give you a little preview of my views, preliminary as they are, because it's nothing more than I recently published in Laundry.
Yes.
And that is, the full court were very careful to say that they're talking about an ordinary case. What is needed is what might be described as a multifactorial assessment having regard to all the circumstances. And that is why, in that case, I said, well, that wasn't an ordinary case, because the applicant in that case decided he wanted to swear affidavits all over the shop and expose himself to cross-examination.
But we go further than that, Your Honour. We say this isn't even within the ordinary case, because what Ducador is talking about are where the charges either predate or coincide with the date of publication.
All right. Well,
so we say we don't fall within that, sentence at all.
I understand that, and I will let you develop that submission.
And that is why that what happened from 15 February to 7 August is important to our submission.
Yes, I understand. Now,
I understand Your Honour's...
You seem to have made a forensic decision not to call Mr. Corn, and matter for you, but how is it fair to the respondents to be able to test the evidence of what passed between Mr. Corn and Mr. Lehrmann? When he's a solicitor of the Supreme Court of New South Wales, isn't he?
Yes, Your Honour.
He's in Sydney?
He's in Sydney.
Well, there's no reason why an affidavit couldn't have been put on by him, and I'm correct to infer, that a deliberate forensic decision has been made not to call him.
Well, he's unavailable today, so in that sense, haven't got the exact page, said there's no, if Your Honour were to require, pursuant to the notices, if you were to find the notices were reasonable and there's been a failure to comply and gave a direction, we've indicated that Mr. Corn's appearing in another court in Lidcombe at this today, and we understand for some time, and would make himself available if Your Honour directed at a time convenient to the court and subject to him being released from, it's at page, what page? 742, Your Honour.
742.
In that sense, it was the forensic decision in the context of he would not have been available today.
So the question is, really as a matter for you, if a request is being made, it's really your election as to what you do. If you propose to call Mr. Corn but are unable to do so because he's in the Forensic Medicine and Coroner's Court complex in Lidcombe, then no doubt the appropriate step for you to take would be seek an adjournment until he's finished in the Forensic Medicine and Coroner's Court complex in Lidcombe. But as I understand it, and this is why I sought clarification of the evidence you proposed to adduce, You don't propose to seek an adjournment.
If, taking it the step by step, Your Honour, if our submission is in all of the circumstances you would not find that the requests are reasonable pursuant to 169, I hear what Your Honour says about
Sure.
subsection B.
No, I appreciate I haven't heard you from on that point. Assume I'm against you in relation to the fact that there's been a request, and it's a reasonable request, and it's a reasonable request because there's a bona fide dispute in relation to what passed between Mr. Corn and Mr. Lehrmann.
We would be seeking an adjournment to permit Mr. Corn to be able to be here to be cross-examined. This is the crux of, from our position, this application. Your Honour identified last week the two main points being that the fact that there were criminal charges either extant anticipated and there had been legal advice indicating shouldn't commence at this time. Now, if there is a bona fide dispute as to whether or not that advice was given, based, it would seem, on some text messages on the evening in which the project went to air from communications sent by Mr. Lehrmann to his girlfriend as being on their face inconsistent with legal advice, then that's we're happy to clarify that.
Well,
and make Mr. Corn available.
so just say there's clarity about what's happening. If you wish to call Mr. Corn, and that's entirely separate from anything I do in relation to the request, if you intend to Mr. Corn, then that changes the evaluation entirely when it comes to consideration of the 135 application in respect of Ms. Chrysanthou and Dr. Collins' contention there's been a failure to comply with the request. I know the request was made in Mr. Lehrmann as well, but it's clearly a relevant matter in considering the reasonableness of that request. I hadn't appreciated that, given that Mr. Corn was unavailable, that you proposed to seek an adjournment to adduce evidence from him.
To be more precise, understanding and having been advised that he is, we anticipate, unlikely to be readily available necessarily without some arrangements being made in his current engagement, a decision was made to put that material in an affidavit of information and belief from Mr. Svillens.
Well,
it's there. There's been a request made that...
Mr. Svillens got any further detail as to Mr. Corn's commitments in the forensic medicine and coroner's court complex in Lidcombe?
As I understand he does, and it's a rather long-running case involving that app that AFP and FBI put on people's phones and charged them $1,000 and then listened to everything they said, which was supposed to be the secure phones. So it's I don't know any more than that it's a long-running one. I can't see how there could not be an arrangement made that he could be excused for a couple of hours if necessary. So in that sense, following the bouncing ball in this sense, Your Honour, we put on the evidence in that way, not hiding Mr. Corn, but as a matter of convenience that here's the evidence from the solicitor on information and belief. He would otherwise be unavailable today. We've received a request that he wants, that the respondents wish him to be cross-examined. I was proposing, let's assume that I've made submissions as to the reasonableness of that, and Your Honour was against me, and that there was, Your Honour was prepared.
Well, it just seems to me, Mr. Whitebrow,
Sure, cut it.
This isn't, the advice given by Mr. Corns is something that you place, it's one of the three things that you place reliance on, that is the advice was given in particular terms and it was acted upon. It's in dispute
From the day of the
that
publication.
Mr. Corns gave that advice, as I understand it from what the respondents have said, and
We understand.
we're dealing with experienced counsel, and they've already taken me on the voir dire material, which seems to support some sort of bona fide issue that arises in relation to that.
Can I be heard briefly on that, if necessary? I'm not...
Well, I'll hear from you in relation to that. Yeah, now if you wish.
Your Honour, the bona fide issues here relate to messages, an apparent on the face inconsistency between messages sent by Mr. Lehrmann to his girlfriend and another female friend on that evening, expressing a degree of confidence and it'll all be clear, there won't be criminal charges. This is the 15th of February. An article refers to the AFP having provided some statement, as opposed to what Mr. Lehrmann is. Mr. Svillens says that he was told by Mr. Lehrmann. Indeed, even it's raised as some significant inconsistency that he told Mr. Svillens, people were contacting me and saying, is it
But
you?
I don't think it has to rise to a level. I don't think one has to characterise the text messages as giving rise to some sort of inconsistency at a particular level.
Sure.
The question is one of fairness. It's an issue on the application. What passed between Mr. Cord and Mr. Lehrmann is in dispute. You adopted the course of putting on hearsay material in relation to it, which is not unusual in these applications, but as Dr. Collins says with some force in his submissions, respondents are either damned if they do or damned if they don't, because if they allow the hearsay material to go in and don't challenge it, then if people like me sitting on a full court say, well, it's unchallenged evidence, you didn't challenge it. So I think really all I need to do is form a view. Well, look, but we're getting ahead of ourselves. I'm now getting into the minutiae of the request. The fact is, and I'm not giving you judicial advice about how you should run your case. You've indicated to me you want to call Mr. Corn. I don't think I should deal with the issue of the request. What I should be dealing with is the application for an adjournment to allow Mr. Corn to come in here and give evidence. Now, the first thing I need to know is when he can get on Western Line from Lidcombe to Martin Place Station to get in the witness box.
Your Honour, permit us a short adjournment to make some inquiries about those matters and get some instructions.
Yes, I will. I'll allow you because it seems to me material to the adjournment application, and when I understand that material, when he can actually come and get in the witness box, then I'll hear from the respondents as to whether or not such an adjournment should be granted in all the circumstances. All right. Well, look, I'll adjourn briefly. If you could then just perhaps tell my associate when you're ready to come back on. Any difficulty with that course? Just to obtain. I'm not prejudging any adjournment application.
No, I understand.
But any difficulty with that course from the respondent's point of view, a short adjournment? All right. Well, he might be on his feet. The people who designed this courtroom seem to suggest that, decide not to put a clock in it. Anyway, it's 10:29 p.m. Apart from going to the RSL School of Interior Design, they decided not to put a clock in. All right. Well, look, I'll adjourn for 10 minutes in order to allow you to make those inquiries. If you need more time, Mr. Wyber, I'll just let my associate know, and I'll come on for the court when you've had the opportunity of making those inquiries. All right. Adjourn the court, please.
Grant, have you met Anthony and David?
Yeah, I hadn't
Grant, actually.
Grant David. That's Anthony. I'm David. How are you, mate?
Not
Haven't you met Barry?
No.
How is that possible?
So did you work that out between yourselves? Just block him when he comes over with his shit that he wants to say.
And the court does seem to claim reasonable cause for failure to comply with the request includes the known unavailability of evidence. So they knew. They knew he was That was the response. You've directly, you've got that.
Testing. Testing.
I think he's standing, so they've just moved that one. He's between the two.
At the very least,
Yeah, exactly. Yeah, you've learnt this word. Yeah. So she's, my wife's back to work 5 days a week. So.
Oh, really? Okay, so what, grandparents?
No, I wish. Yeah, they're all in.
Testing. Testing. I think it's fine now.
We're going to oppose. For it's worthless, yeah. Oh, yeah.
Yeah.
My lifelong friends. Seriously, lifelong friends
This is what the court of appeal said in Washington College said as to whether that was reasonable. But failure to comply with reasonable cause. Factors will include the known unavailability of persons submitting a request to be called.
Twice as long as I permitted. We've managed to get hold of Mr. Corn. I'm instructed in a hearing at the moment, but he can be available, and I appreciate Your Honour's got other things to do as well, as do my learned friends, next Friday on the 24th, or the 27th, which is the following Monday, or the 4th or 5th of April. 5th of April. So in that sense, I have instructions.
Sorry.
Rather than to go through the...
Sorry, can you give me those dates again?
Yes, 24th of March.
Yeah.
Tomorrow week. 27th. And the 5th of April.
Yes, sorry, interrupted you. Interrupted you.
Oh, sorry, Your Honour. My instructions are, rather than to seek an adjournment, so Mr Corn can be called by the applicant on the application in relation to the matters that have only on information and belief from Mr Svillens, and he can give direct evidence about this significant matter. And if there's to be any directions as to filing affidavits, etc., obviously that could be done, but I'd be seeking that this application be adjourned until next Friday at 9 a.m. or at a time convenient to Your Honour and my friends.
I don't quite understand why he could only make himself available on those days.
As I wasn't in the room at the time, but I understand he's in a hearing this week and next week.
Finish at 4 o'clock, presumably, and they presumably have luncheon adjournments. And presumably I confess I don't know when the Forensic Medicine and Coroner's Court sits, but I presume it sits at 10 a.m. in the morning.
Yes, I can't say.
In any event, thank you. Now, look, it seems to me there's several ways of proceeding. One is I accede to your I'll preface this by saying the following. I do believe that in light of the material that I've seen on the voir dire, that it would constitute an unfairness on you leading second-hand hearsay in relation to what Mr Corn said to Mr Lehrmann, and I'd be disposed that the evidence of those representations made by Mr Corn are currently contained in the affidavit of your instructing solicitor be rejected. And we'll come to the basis of that rejection in due course. That leaves a variety of different, in the light of that, there's a variety of different ways we can proceed. If that objection was not persisted in, we can proceed today and there can be cross-examination of your solicitor, and we can proceed to deal with the evidence today. The other alternative is try to find a time when Mr Corn can give evidence which slightly earlier than the dates identified, in the event that I was otherwise minded to grant you an adjournment to do so. And the third is to proceed to adjourn the time to the first available date when Mr Corns can be in a position to give evidence, and we proceed the way that you've indicated. So let me hear from the respondents now as to what they say about those things.
Honour, we do press the objection for the reasons that I and Ms Chrysanthou outlined, and we oppose an adjournment. Mr Corn could have put on direct evidence of this matter much earlier than today and at the time that the principal evidence went on the 1st of March. As Honour pointed out, he's a solicitor of this court. By that date, a decision had been made to waive privilege in respect of the communications between Mr Corn and Mr Lehrmann. Corn was able to respond to a subpoena in a timely manner when one was served upon his firm. What appears to have happened is that when the tension, I'll try and put it neutrally, the tension between Mr Svillen's second-hand hearsay evidence and the messages first emerged, a further forensic decision was made by those opposite that instead of then putting on direct evidence to deal with the tension, they would again rely upon hearsay evidence in the form of a further affidavit by Mr Svillens. When we challenged that, can I take you on to the response we received? This was yesterday at page 742 of the court book. Instead of doing what our learned friend now does and say, well, yes, we accept the force of your objection and we agree to call Mr Corn to give direct evidence, or we'll put on an affidavit directly from him. Instead of that, we would get this letter at 742. Our client neither consents to nor opposes the calling of himself, but will comply with a direction by Your Honour. Now, the proper construction of that letter is it's a failure to comply with a request that we say was a reasonable request served on behalf of Ms Wilkinson, for whom Ms Chrysanthou...
Well, today's a change of position.
Correct, and that's really the point, Your Honour, is that, can I just make this point? We're here today at vast expense. We've come ready to argue the substantive application with no notice that an adjournment might be sought until about an hour and a half into today's argument. And what's plainly happened, with great respect to our friend, is he's read the tea leaves from the bench. He sees the way the matter is going and he has changed position. But he hasn't done us the courtesy of an explanation for that change of position. And in our respectful submission, the court ought to have one. The fact is that if an adjournment had been foreshadowed yesterday or prior to yesterday, it could have been dealt with by the parties in a much more cost-efficient manner than what has now happened. As Your Honour will know, many of us here have had to come up from Melbourne overnight in order to be here today. If it was an adjournment application, it's highly unlikely that you'd have this many silks sitting at the bar table to deal with it. In our respectful submission, it could have been dealt with over Microsoft Teams or in some other more cost-effective manner. So for all of those reasons, we oppose the application for an adjournment, but we make this point that if Your Honour is minded to grant it, it ought to be on terms that the costs thrown away by reason of the adjournment paid by Mr Lehrmann, and we would seek an order in the discretion of the court that they be payable forthwith. Those are our submissions, Your Honour.
Your Honour, it was plain when Mr Svillens' affidavit was served on the afternoon of 1 March that the interactions between Mr Corn and Mr Lehrmann were to be relied upon by the applicant on his application for extension of time. That triggered much activity on the part of those behind us on this side of the bar table. The first thing it triggered were notices the following morning, the first one being an immediate notice sent on the 2nd of March, which is, Your Honour will see behind at page, page 700 and page 726. It's misdated 14 February. It should be dated 2 March. So we got the affidavit on the afternoon of 1 March. The following morning, first thing in the morning, we put the applicant on notice that we had issues, and this is in paragraph 4, about the evidence and the importance of the previous representations by Mr Lehrmann and his account of the representations of Mr Corn. So from the morning...
What page was that, sorry?
Page 726.
726.
And I think it's agreed that somehow that's a very badly misstated letter. It should read 2 March. And it was sent first thing in the morning, having received Mr Svillens' affidavit on the afternoon of 1 March.
I thought you said 726. I've obviously got the wrong page.
Sorry, it is 726, sorry, Your Honour.
726?
Yes.
726 is a letter of the 14th of February.
Yes, it's misdated.
Oh, I'm sorry.
Yeah, that's my...
I'm sorry.
It's it's correctly identified in the index. It's 2 March 2023.
I see. Sorry.
And I know that it was sent first thing in the morning, where in paragraph 4, we put the applicant on notice of the issue we have about Mr Lehrmann's previous representations and his account of the representations of Mr Corn. My learned friends...
But as I said to Dr Collins, the fact is there's been a change of position from the position that obtained even up to the commencement of the hearing this application today. Yes. And I think, as Dr Collins didn't unfairly put it, might be thought that the applicant was sitting by to see whether I would be persuaded to exclude this material or not, having made it tolerably clear that I thought there would be an unfairness in allowing this material, then there's a change of position.
Our point, Your Honour, is there's two changes of position. The evidence on this application was due on the 1st of March. Mr. Lehrmann elected to not put on hearsay information and belief evidence from Mr. Corn. He elected to do it only through himself to Mr. Svillens. This Corn evidence that we received on the 14th of March is not in reply. It is evidence that should have been filed on the 1st of March. After the 1st of March, huge expense has been incurred. Subpoenas have been issued, notices to produce, and steps have been taken to deal with the second-hand hearsay evidence of Mr. Corn. Then, without notice, on the afternoon of 14 March, we received that third affidavit, and so that is the first change in position. We made an immediate request that was refuted, as my friend Dr. Collins has taken Your Honour to. So today's adjournment application is a second change in position. Now, Mr. Corn's evidence, in his oral evidence, would be all of 15 minutes probably. He's giving evidence of 2 or 3 conversations in chief and would be asked some questions about that. Now, as Your Honour's pointed out...
Well, I mean, I don't understand why it wouldn't be possible for someone to request who's ever presiding at Lehrmann if to allow him to give evidence at 1 o'clock during the luncheon adjournment, and if for some reason it slipped slightly over, that he'd be able to go back into court.
Well, that's asking,
and he
Your
could
Honour.
do it. He could do it remotely if he wished, but
It's
that's not what's proposed.
It's wholly
But
unacceptable.
it seems to be one of the 3 options that I outlined.
Well, I mean...
How long do you expect that you would... Could I ask these 2 questions? Perhaps this is... I didn't ask Dr. Collins this, and perhaps I should have, and he might be able to give me an answer. In the event that I did exclude what I'll describe as the Corn representations, and would you... I presume from what you said you would still propose to cross-examine Mr. Slivens?
Yes.
So there's no reason we couldn't proceed with that today?
It would also depend on what Your Honour did with the representations concerning the other paragraphs in the Svillens affidavits arising out of the failure to comply with the Section 166 notices that were issued to Mr. Lehrmann. So if Your Honour were to...
I was posing that question irrespective of the result of that. Will that be determinative of your choice as to whether you're going to cross-examine?
The cross-examination would be much more circumscribed, Your Honour.
Well, yeah, well, I would deal with that, obviously, because I'd have to work out what evidence went in chief before you start cross-examining. But irrespective of that, there's going to be cross-examination of 2 witnesses if Mr. Corn is, and there's no reason why that can't proceed today.
That's right.
My perspective, Your Honour, obviously I act for an individual, and an adjournment of the sort proposed has significant cost consequences to her, and the dates proposed are quite far in advance. I mean, if it was proposed that he were to come tomorrow morning, that would be a different situation to delaying by 1 to 2 weeks from the perspective of busy senior counsel who have prepared the matters and have other matters to prepare. From our perspective, we're not available on the 27th at all, if that were the date that's being proposed.
That's the least of them. That's the least of my problems.
But that's, I know Your Honour doesn't have time.
No,
having
believe me.
From other matters,
I've
I
got
know
one
that
or
Your Honour
two,
doesn't have time.
I have 1 or 2 things in my docket.
Yes. But we particularly as my client's an individual, we oppose the adjournment, and we don't think that cost could possibly remedy what's been thrown away if we can't proceed today.
One of my clients also opposed the adjournment application for the same reasons that have been stated. If an adjournment is to be granted, then they also seek a cost order of the kind that Dr. Collins identified.
Yes, Mr. Wybrow.
Your Honour, wasn't clear on whether or not Your Honour would be proposing certainly not to rule on the adjournment application at this stage, but there's going to be a necessary need to call Mr. Sfillens in any event, and in the background, further inquiries, we'd only just got on to Mr. Corn as Your Honour came back onto the bench, can be made, and further instructions about other aspects to be done. Can I say, just in relation to reading the tea leaves, Your Honour, we had made it clear that we were objecting to the notices on a particular basis. I indicated to Your Honour that if Your Honour were, as you had preliminarily indicated, of a mind to say that the notices were reasonable, then it would be a matter of whether you would give an order or some other thing. We did indicate in the letter at page 642 that if directed to do so, 742, Mr. Corn would be available for cross-examination on a date. So it was foreshadowed. I'm not suggesting...
No, I understand that, but the change of position is I'm not directing you to do it.
No.
What you're doing is deciding to adduce evidence in chief which had not been foreshadowed until this morning. I understand the circumstances in which that's occurred. This often comes up in circumstances where there's a point taken by a party in contested litigation that you haven't called someone, and I've done this myself, and then you stand up and say, well, you shouldn't draw such an inference because here he is, I'll put him in the witness box. You can ask him whatever he wants, which tends to diffuse the notion that there should be an inference drawn. And then your opponent stands up and says, oh, that's all unfair. And you say, well, you can't have your cake and eat it too. The fact is they're maintaining the objection. I think the objection is well-grounded, and I do propose to exclude the evidence for reasons that I will give. But it does seem to me that at the end of the day, I have to do justice between both parties. They're entitled to test the material. I don't think, I have certain views as to what I regard as a hierarchy of important issues, but I haven't heard submissions, and I'm not going to, obviously enough, express any views about that at the moment, but this is one of the 3 points you wish to run, and I don't think it would be fair to your client to shut him out of the opportunity of calling Mr. Corn. I am a little surprised that in 2023 some more pragmatic expedient can't be fastened upon to make sure that he gives his evidence. Now, if I was the applicant, you've got more than one instructing solicitor, I'd get one of them on a train to Lincoln and make sure he's in a position to give evidence as quickly as possible. I would be prepared to sit over the luncheon adjournment to receive his evidence. If that's not possible, then we can revisit the issue of the adjournment, it seems to me. So it was the communication as such to know when there is an adjournment of the Forensic Medicine Coroner's Court?
The difficulty, Your Honour, was, as I understand it, communication had only just been made as Your Honour was coming back onto the bench, and so we got those dates without explaining some of the quite sensible expediencies. And
the fact that there are three silks sitting at the bar table, there'd be significant costs being incurred today.
Correct.
And to be perfectly frank, I can tell you now that the 3 dates, the 24th of March, I have already 3 hearings all day. The 27th of March, I'm in Brisbane for a hearing. And the 5th of April. I'm in Finland.
Do they have Microsoft Teams? You're on the
So none of those dates are, how can I put it, convenient.
Well, I'm advised that inquiries are being made in the interim.
Well, I think then we should proceed to deal with the evidence we can deal with now, and I would counsel your solicitors to get on their bike and work out what's happening with Mr. Corn.
I think they worked that out, Your Honour, and are on that bike.
All right. Well, then what we should deal with, can we deal then with the affidavit of the 1st of March? So the first objection is to paragraph 13.
Yes, sure.
Is it the whole of paragraph 13?
I don't think anything survives.
On the basis of Mr. Corn not being available, or in relation to
It's not
Lehrmann?
in dispute that Mr. Lehrmann watched the program at about the time it was played.
But whether he watched it in...
No, well, I'm just saying it'd be easy to just reject paragraph 13 in its entirety, if that's not in dispute. Yes, all right. Well, I reject paragraph 13. Paragraph 15.
14, Your Honour, the second
On
final
14,
sentence.
yeah. Is it in dispute that Mr. Lehrmann reviewed the second article that evening?
Not that Mr. Lehrmann did. The Corn. It is that Mr. Corn.
Well, if it's not in dispute, then again, it's easier perhaps to reject the entirety of paragraph 14. Paragraph 15.
The whole paragraph.
Yes, I will reject paragraph 15. Paragraph 16.
The whole paragraph.
Just so I can understand the...
Well, I think 16 falls in a
objections.
different category.
There's two bases of, as I appreciated, objection. One is Mr. Corn is not at the present moment available, but an issue arises, as we understand it, as to whether... So I understand it. The objections are, Your Honour should not admit these paragraphs on the information and belief of Mr. Svillens. It should be subject to direct evidence from the applicant himself. If that's what I understand their position is.
No. I'm rejecting 13, 14 and 15. I have on essentially two bases. One is having regard to the matters identified in section 192 of the Evidence Act. And in particular, the extent to which it would be unfair to a party or a witness, and the power to give a direction in relation to the evidence that is a direction allowing you to, in effect, rely on evidence out of time. I think allowing this evidence in when it's proposed that
be out of time,
Mr.
Your Honour.
Corn be called and give direct evidence of the representations that he made, allowing that to get in this second-hand hearsay form would, when there's a possibility of receiving direct evidence, would be of such little probative value that it's substantially outweighed by the evidence, that the evidence might be unfairly prejudicial. I mean, for all I know, if I was allowed this material in, even though your intention is to call Mr. Corn may refuse to come at 1 o'clock and give evidence, and it shouldn't be allowed to get in this form. So the only relevance of 13, 14 and 15, as I understand it, seems to me to be what Mr. Corn gave advice, the content of the advice Mr. Corn gave to Mr. Lehrmann. And according to those circumstances, I reject it. Now, allied to this, is that a request has been made to call Mr. Lehrmann to give evidence, which has been refused, and there's no determination being made to call Mr. Lehrmann.
Well, with respect, Your Honour, we have not refused to call Mr. Lehrmann. Indicated that we haven't responded to that notice in that sense, unless it's...
Well, you've refused to comply with the request to call Mr. Lehrmann. I've asked you now 2 or 3 times who you're calling. You're not calling your client. I understand that. But the question then becomes, what should the response to that be? Now, it seems to me that it's open to me to form the conclusion that the request is reasonable. The request is made, the request is reasonable. It's evidence of some importance, you say in your case. And having regard to, I wouldn't propose to make an order directing you to or Mr. Lehrmann, but I would think in all the circumstances, particularly in circumstances where there are other ways you can deduce the evidence of Mr. Corn, that evidence should be excluded.
But just to be clear from our perspective, Your Honour, and consistent with the communications and certainly my instructions, whilst Your Honour might not make an order, having determined that it's appropriate to, having determined, as I understand it, that it's been without reasonable cause a failure to comply with the requests that have been made, both in relation to Corn and Lehrmann.
No, it's not Corn.
Leaving aside
Corn,
Corn,
you're calling him,
Corn's...
so that goes. But there's also a request made in respect of Mr. Lehrmann.
Yes,
and
we
I'm just saying
any...
this is an alternative. It's an alternative basis for rejecting 13, 14 and 15. It's not dependent upon the first basis because I would exclude it on a discretionary basis under 135 in any event. But I'm saying that there's an independent and separate reason why I wouldn't allow that anyway, is because Mr. Lehrmann could have given evidence of that if Mr. Corn didn't give evidence of it, and he hasn't given it, and he's been requested. So it just leads up to the same point.
In relation to the reasonableness of the request, in relation to the 10 matters that have been identified, and if Your Honour was going to make a...
Are you talking about 13, 14, 15 at the moment?
In relation to 13, 14, 15, absolutely. I wasn't sure if Your Honour was making a
no,
finding in relation to the request.
No. Well, I am. I am saying I would reject 13 and 14 and 15 under 1691C and 1693 circumstances where you haven't complied with the request in respect of Mr. Lehrmann. That's an independent basis. In respect of 13, 14 and 15, that is the Corn communications. Now, all I'm saying is, in a sense, that's a bit of a, that is an independent basis for rejecting 13, 14, 15, which I'd reject on the basis of 135 in any event, given you're calling Mr. Corn.
Just been advised that Mr. Corn is available to attend at 9 a.m.
Sorry?
Mr. Corn's available to attend at 9 a.m. tomorrow morning. I've just been advised.
I can't do it tomorrow.
I understand what you're saying about 13 to 15. I perhaps was jumping ahead in relation to
Yes,
any ruling
all
in
right.
relation to 16.
Well, it might be
et cetera.
relevant to 16, which is a separate issue. Yes, can we move to 16? Dr. Collins?
16 turns upon the outcome of the consequence of the decision made by the applicant not to comply with the request that Mr. Lehrmann give evidence. In our respectful submission, that was a reasonable request and no reasonable cause has been given for failure to comply with the request. In those circumstances,
Isn't this a contemporaneous medical material which is being tendered?
yes, well, that's right. And so, if this were to go in, we want to test this evidence as against the contemporaneous material, because there is contemporaneous material. Your Honour hasn't been taken to it, but which is not fully consistent with what is said in that paragraph.
How's it not consistent?
Mr. Lehrmann, the evidence is that Mr. Lehrmann presented at the Royal North Shore Hospital on the 16th of February. That was the day after the publication of the News Limited article.
I've read that material. Just perhaps before you go on, perhaps I'll just ask for clarification of one matter.
Yes, cool.
From Mr. Wybrow. Mr. Wybrow, do you really need more material in relation to the health of Mr. Lehrmann other than the contemporaneous medical material?
And the material that's before, no. That's why we're curious as to what the dispute was.
Is there
in
any
number
need for you
16.
to read 16?
Well, you don't need to read 16 if the material is otherwise before you.
All right, well, I note that 16 isn't read and you can tender the medical material in due course and it'll go no higher than the medical material. So 16's not read.
Your Honour, 17's in the same category in our respectful submission.
Yep, 17 is not read, and you can just tender the business record in due course, Mr. Wybrow. What's the next one?
18's in a slightly different category. We press the objection to it. Your Honour will
Well,
see...
18 wasn't part of the representations you objected
I'm
to, I
sorry.
thought.
Notified a separate objection to 18, Your Honour.
18, all right.
I'll let Ms. Chrysanthemum do that.
I sent my learned friends a schedule last night. Section 18 is specifically objected to because a notice to produce was issued in relation to the documents referred to in paragraph 18, and no documents were produced. The second half of that paragraph is inadmissible under section 48, which purports to give evidence of the content of a document outside the scope of section 48.
Well, why don't I just make a limitation under section 136 of the Evidence Act in respect of 18 that it's evidence of the representation that was made by Mr. Lehrmann to the deponent and also evidence of the belief of Mr. Lehrmann, but not otherwise evidence of the truth of the representations.
Yes, that gets around the section 48 objection, Your Honour.
All right, well, I'll make is there any difficulty with the section?
No.
I'll make a section 136 limitation in respect of paragraph 18 in the terms I've just identified.
Paragraph 20, Your Honour, is in the same category as paragraphs 13, 14 and 15 in your submission.
Yes, I reject paragraph 20 for the reasons I've indicated.
Make the same submission in relation to paragraphs 21, 22 and 23.
It seems to follow, doesn't it, Mr. Wybrow?
Yes, Your Honour.
Yes, all right. I make the same ruling, reject paragraph 20, 21, 22 and 23.
Paragraph 32 is the next paragraph, and Your Honour, that turns on the argument that we've put in respect of the section 166 notice to Mr. Lehrmann that it's not satisfactory that this evidence be before the court on the basis of
Well, 32 can't be in dispute, can it?
Sorry, Your Honour?
First sentence of paragraph 32 can't
No,
be in
no,
dispute.
sorry, Your Honour's quite right.
Nor the second sentence.
Well, the second sentence is, with respect, Your Honour, that purports to be a statement of Mr. Lehrmann's state of mind. It's a form of an assertion by the solicitor.
I'm not going to be vexed by the proposition that his entire future depended on successfully defending the charge and being found not guilty. That he would perceive that surely.
We have a point, and it's not the point that's going to ultimately turn Your Honour definitively, but it is a point that we press, and it's the confidential point which Your Honour will have seen in the submissions.
I see.
Other matters that. Other matters.
Well, why don't I make a I understand that point, Dr. Collins, but isn't that cured by me making a 136 limitation
Yes,
with respect to the second and third paragraph?
Yes, it would be.
All right, well, I'll make a 136 limitation. Is that a difficulty, Mr. Wybrow, just limiting it to the belief of Mr. Lehrmann?
I'm a bit confused, and I'm grateful to my friends.
No, I'll
Which sentence is
so it's paragraph 32.
32, yes.
First sentence goes in.
Yes.
Second sentence and third sentence go in, but subject to a limitation under section 136 of the Evidence Act.
Well, that's right. On the basis of his belief.
That it is restricted to the belief of Mr. Lehrmann as communicated
Don't have to prove
to
the
his
truth of
solicitor,
that belief.
and but not the underlying truth of the representation.
That's okay, Your Honour.
Right, well, I'll make a section 136 limitation in those terms with respect to paragraph 32. And we go to 42 now, do I?
The second sentence of 42.
So I don't think there's much probative value in the second sentence of paragraph 42. That just be proved one way or the other by other evidence, isn't it?
Well, we're not aware of any evidence, but as I understand, part of the submissions that are being made is that they're in relation to Mr. Lehrmann having, in a sense, in a Landry sense.
But you can make that submission. The evidence doesn't rise or fall on what said by the solicitor.
Well, it doesn't need to be in that affidavit. It's a submission based on whatever evidence there is. Yes.
Well, I know. So I can say that's not second sentence is not read.
Yes, Your Honour.
Second sentence is not read.
That leaves Mr. Svillin's third affidavit.
So there's no objection to the affidavit of 10 March?
That's so, Your Honour. That's an
Yes, all right. Well, I note that the affidavit of Paul Victor Svillin's sworn 1 March 2023 is read subject to the rulings that I've made. I note the same deponent's affidavit of 10 March 2023 is read without objection. And I'll now rule on the 14 March 2023 affidavit by the same deponent for reasons that be made obvious. I'd reject the whole of paragraph 4. Subject to anything anyone else you wish to say, Mr. Wybrow? It seems to follow.
No, not based on what we've discussed.
Right, so paragraph 4 is rejected. Is that the entirety of the...
Paragraph 5 is objected to, Your
Paragraph
Honour.
5.
Under point 11 from page 735 of the court book, on the basis of the failure to comply with the request under section 166 that Mr.
we give evidence on this. I understand I have, rather than Your Honour having to deal with that, Mr Lehrmann's available, and if Your Honour permits us to call him, he's happy to give direct evidence of these matters. Obviously, we have some concern about there being a...
Right, if you just waste, if you've decided to call Mr Lehrmann in chief,
Yes?
then we said to have wasted half a morning going through objections because he can give direct evidence of these things.
Yes.
So you're now making an election, notwithstanding what has been said before, that you're going to call your client.
I just wanted to clarify that they were my instructions, but I anticipate that that's the position given the rulings that are being made in relation to the reasonableness of the notices. We had taken a position that there was no opposition to calling Mr Lehrmann, but we objected to the reasonableness of the notice that required, the 166 notices that required, that Mr Svillin's evidence was not sufficient to deal with these matters, and that Your Honour was addressing that issue. Now, I've read those tea leaves, Your Honour. You have effectively made some...
So you've got... I just want to understand where this is going, Mr. Whitebrow, because I don't want any confusion. You've got the first two affidavits of your solicitor in,
Yes.
and the only part that I have rejected of the third affidavit is that relating to Mr Corn. I haven't dealt yet with the representations contained in paragraph 5. Now, I haven't ruled on what I would do in relation to those representations at this time. I ruled on the representations, qua the Corn representations, and reached a view. That doesn't mean that I necessarily form the view that I would affect the material in paragraph 5. But I don't need to get to that point if what you're doing is saying to me that you're going to call your client. So I just have to take this step by step.
And step by step, Your Honour, is in relation to the material that has not been read in the affidavit of 1 March. It includes, and I appreciate Your Honour has not yet ruled on the application to adjourn for Mr Corn to come and give direct evidence of those matters, but it is an application that is not only strenuously objected to by every other respondent, but one where they have sought or will be seeking cost orders against Mr Lehrmann to be paid forthwith. So in those circumstances, that, and where I'm instructed, Mr Corn is simply not available today, that one way of avoiding that risk to Mr Lehrmann of either an adjournment with costs or no adjournment, and that evidence is not otherwise going to be before Your Honour, is to call him on these issues. We have obviously been concerned, given the nature of the notices to produce, the width of them, and some of the submissions made, that if he were to give evidence, it appears that my friends want to undertake an extensive forensic credit examination going beyond this issue of the limitation period and his evidence relevant to those matters. That's the matter which causes us some grave concern. But that could be dealt with by way of objection at appropriate times in relation to individual questions, given the way the matter has developed.
Well, Mr Whitebrow, it's not for me to work out how you propose to run the case. We've got to a point where to me, as I understand it, that you propose to call your client in chief.
I want to confirm those instructions, but that's a note that I was provided, and I just wanted to confirm that. But that is, as I understand it, my instructions, yes. Thank you.
Now, if you call your client in chief, are you still also proposing to call Mr. Corn in chief?
If the evidence of Mr. Lehrmann, he's going to be giving, as I understand it, direct evidence of conversations and advice.
Yes.
If that evidence is not contested.
So you're seeking to adduce evidence from, you're seeking leave to adduce evidence orally from Mr. Lehrmann of what Mr. Corn, the representations Mr. Corn
What he was told and what he did, yes.
If you adduce that evidence in chief, is your intention, or you prefer to keep your powder dry to determine whether or not you call Mr. Corn?
I would prefer to keep my powder dry in those circumstances because it would.
Well, if it's
If
put,
there is
I
no
know
issue.
you don't need to go further. I can understand why that might depend upon what's put to him and
Yes.
what Mr. Lehrmann says. All right. Well, if that's the case, do you intend to lead information and belief evidence of those matters in paragraphs 5 and onwards of your solicitor's third affidavit, which I haven't yet ruled upon? Or do you intend to read those? Or do you intend to adduce those out of your client? Adduce that evidence from your client?
Well, perhaps we should have. I'd rather not answer that question in relation until Your Honour's made a ruling as to whether or not that information is going to be not read or rejected. Because if it's rejected, then it's not just information and belief that Mr. Lehrmann could give on it, it would be direct evidence of those matters.
Well,
And I know it seem like a stitch in time saves 9, but I'm instructed to seek a short adjournment while I confirm these instructions.
Sure.
I can advise my friend.
No, it's an important point,
Yes.
and you should have plenty of time to consider your position. It seems to me that I must say to you that the balance of the affidavit seems to deal with matters which are the subject of contemporaneous representations contained largely in business records. So anyway, it's a matter for you to how to run your case. If you want to call Mr. Lehrmann, then obviously enough, I'm not going to shut you out from doing so, particularly in circumstances there's a request by the respondents that you call him. It's entirely a matter for you, and I don't think I should descend in the arena of saying anything more.
Raise one matter, given my friend's taking instructions. It's an unorthodox approach that my friend has taken to change his view as to which evidence he's calling, depending on outcomes of rulings, paragraph by paragraph. We would appreciate it in order to consider how...
It's not that unprecedented. Often in situations where you reject evidence, you'll give people leave to adduce different evidence of that material, but there's a number of unusual aspects to this.
We would request that my friend make an election at the different aspects of the evidence so that if we are to cross-examine witnesses, we know what evidence is being read.
That's why I'm seeking clarity in respect of the material from paragraph 5 onwards.
Yes.
The other material I've allowed is in. Some of it obviously contains hearsay representations by a witness who's about to be called, so we don't want to get in. I mean, this is an interlocutory application. I didn't think I had to worry about Ethicon type inferences and all sorts of things. But in any event, we'll allow Mr. Wybrow to... You take your time, Mr. Wybrow, and work out what you want to do, and you allow my associate know whether or not you wish to proceed dealing with the affidavit of your third affidavit of your solicitor. Now on the basis that you're either calling or not proposing to call Mr. Your client. Now,
I want to just confirm those instructions, Your Honour.
Now, I'll deal with those objections on that basis. If you think following the rulings, I want to determine this application justly. If you think following the rulings I make in respect of the balance of the material in the third affidavit are of a character that means that there's no evidence of something that you wish to rely upon, then that doesn't prevent you then making an application, seems to me. Seek leave to call your client, notwithstanding you haven't served an affidavit claim, but we just got to take this by stages. You work out what you want to do, and you can let me know. I don't think, Ms. Chrysanthou, I understand the point that you make, and that it's really, one shouldn't be in a situation where one is giving judicial advice by reference to rulings, but I just have to take applications that are made, and these seem to be made at different stages. I have to take them on their merits and work out what is fair. And we've got to this point. I think I should allow Mr. Wybrow to take instructions.
Yes, of course, Your Honour, but the only request we make is that, having regard to the fact that ordinarily these matters proceed by affidavit, I think Mr. Wybrow should inform us when he comes back precisely his position definitively in relation to Mr. Corn, so we at least know that if we embark upon a cross-examination of Mr. Lehrmann, if he's presented, whether or not Mr. Corn is then coming on.
No, look, I think you can proceed on the basis that the evidence from time to time, he wants to keep his powder dry in relation to that. Now, I am going to say on the material presently presented, I want to understand the witnesses he's proposed to call. When I say keeping his powder dry, what I'm saying is it's not unusual, depending upon where the position is following cross-examination and re-examination, that someone might come along and say, well, in the light of this, I want to call somebody else.
At trial, yes, Your Honour, on an interlocutory
Well,
application such as
this has morphed into a more complex evidentiary position because of the position that's been taken by the respondents. Now, usually, as you know, these, and I'm not being critical at all, usually these applications proceed on information and belief. I have set aside one day because I thought it was possible to deal with this application with celerity. It's proving more complicated than I thought because of changing forensic positions and the position taken by the respondents. That's no criticism of anyone. For my part, I quite enjoy the colour and movement associated with forensic decisions having to be made on the spot. But we can just take it one application at a time. And I'll now adjourn, and you can tell me when you're ready, Mr. Wybrow, through my associate.
Court is temporarily adjourned.
Would it assist to be able to identify the topics that we... Yeah, that's right.
I understand what objections you were taking to the second affidavit, because
This court is now resumed. Seated, please.
Yes. Mr. Wybrow.
Yes, Your Honour, I formally seek leave to call the applicant to give some short evidence in relation to matters pertaining to the Corn advice and text messages. My learned friends have confirmed with me that there will not be any cross-examination about matters pertaining to the affidavit of the 10th of March or in that line of country, if I can put it that way, Your Honour. Certainly there'll be objections if there is.
Well,
Confidential matter. The confidential matter.
Yeah, the confidential matter, I think it's been called.
do you propose then that I defer really on the balance of the solicitor's evidence until the applicant has been called and been cross-examined?
No, it would be, that position is happening in any event, but it would be useful to understand the position in relation to the affidavit of 14 March.
Well,
I appreciate that paragraph 4
who
is
do you
out.
propose to call first? Do you propose to call your client first or your instructing solicitor?
I propose to call my client first.
Well, if you propose to call your client first, then I think we should deal with his evidence first, and then we'll come back and deal with the objections to the affidavit material in chief of your next witness, which will be Mr. Fillens. All right, well, is there no objection then to that course being adopted by any of the respondents?
No.
Yes, well, you can call your witness, please.
Affirmation, thank you.
Your Honour, Ms. Lehrmann would like to make an affirmation.
Yes.
I solemnly and sincerely declare
I solemnly and sincerely declare
and affirm
and affirm
that the evidence I shall give
that the evidence I shall give
will be the truth,
shall be the truth,
the whole truth,
the whole truth,
and nothing but the
and
truth.
nothing but the truth.
Take a seat, please. Yes, Mr. Wybrow.
Thank you, Your Honour. Mr. Lehrmann, could you tell His Honour your full name?
Bruce Emery Lehrmann.
And just for future benefit, how do you pronounce your surname?
Lehrmann.
Lehrmann.
I don't take any offence to other pronunciations. Okay. That's fine.
What's your current occupation?
I'm a law student.
And you were the defendant in the proceedings, the DPP and Lehrmann in the ACT Supreme Court last year?
I was.
I want to ask you some questions about the 15th of February 2021. Were you employed there then?
Yes, I was.
Where were you working then?
British American Tobacco.
During the course of that day, did you become aware of an article that had been published?
I did, yes.
To the best of your recollection, did it name you?
No, it did not.
Did you read that article?
I did.
Can you recall how you came to be aware of the article?
Not specifically, no.
Having read that article, did you consider it had anything to do with you?
I did.
Why was that?
Because it identified the office that the person worked in, elements like the dock, things like that. However, the element of an alleged sexual assault was not me.
Did you at some stage seek to get some legal advice as a result of that article having been published?
Yes, I did.
What did you do that you can recall?
In terms of how I got that legal advice? Well, a close friend of mine I reached out to in the afternoon of the 15th, asking in more or less that I need a lawyer. And he gave me the name of a solicitor by the name of Warwick Corn.
Did you know Mr. Warwick Corn before that day?
No, I did not.
Did you contact Mr. Warwick Corn that day?
I can't recall whether I contacted him or he contacted me, but contact was made.
Okay. Did you see him that day?
I did.
Where did you see him?
In his office near the Downing Centre.
And Can you recall approximately what part of the day that was?
Late afternoon of the 15th.
And understand you've waived privilege in relation to discussions with Mr. Corn on this day, is that correct?
Well, specifically in relation to this application today.
Did you discuss the article with him?
I did.
Were you aware that there was a proposed television program to be broadcast that evening?
We were aware. Yeah.
Did you watch that night?
I did.
Where did you watch it?
In his office.
Who was with you when you watched it?
Rick was, and I believe my friend Harry Hughes, potentially. I can't recall specifically. But
You
Rick,
and Mr. Corn were there?
Rick and I were there, yes.
Okay. Following that, the project we're talking about, that being broadcast, did you get any advice or did you seek any advice in relation to possible defamation proceedings?
Well, that was not the purpose that I engaged Mr. Corn for. It was for obvious criminal proceedings or an investigation. It was obvious and apparent that was about to be undertaken. So,
during the course of discussing with him issues relating to potential criminal proceedings, did the subject of possible defamatory statements in either the article or the television program come up?
Certainly, I was outraged from what I was seeing.
Okay. And did you raise that with Mr. Corn?
I did.
You call doing the best you can. I appreciate it's 2 years ago now. What was the nature of your inquiry?
Well, I wanted to commence defamation proceedings. It was that outrageous at how this allegation was advanced before a complaint had been re-agitated with the AFP.
Before that day, had you known that there'd been any complaint at all in any event?
No.
Did Mr. Corn give you any advice in relation to your inquiries about defamation?
Did.
What was that advice?
That advice was that defamation proceedings could happen, but we need to wait until the resolution of any criminal proceedings or an investigation.
You given any advice as to what might be...
Mr. Wybrow, I think I'd be best assisted if you could to try to elicit the best you can the direct speech.
Yeah, oh, of course. So you heard what His Honour said in relation to, appreciate it, it's to the best of your recollection, what you said and what he said.
Yeah.
In relation to this potential criminal allegation, the best you can recall, what did you ask and what did Mr. Corn say in relation to that?
Well, I mean, keeping in mind it's some time ago, but from what I recall, I was outraged by the material I was seeing and asked about commencing defamation proceedings. His advice was...
What did he say, best you can say?
Well, I mean, to the best that I can recall is that they have to wait until we see what happens with the criminal matter.
Do you recall whether there was any reference to how long you could wait or whether there are any time periods or anything like that?
No.
Okay. Moving forward, did you retain Mr. Corn in some capacity going forward from the 15th of February?
I did.
What was that?
To represent me in the, to represent me in the eventual criminal proceedings. He represented me a couple of times in the magistrates' court, and particularly over the course of the AFP investigation, and I was eventually interviewed in April.
Now, between, let's say, then February to April, were you following the course of this story, if I can put it that?
I was.
In what way?
Well, it was very public, so as soon as articles were online or television programs, I was keeping abreast of it, certainly periodically checking social media and Twitter.
Well, in relation to your employment, this was a Monday the 15th. Did you go to work on the Tuesday?
No.
Why not?
I was suspended.
And can you recall how you were on Tuesday 16th?
Not in a good way.
I'm not sure if
Put it
this is
lightly.
in dispute from records, but you presented yourself to Royal North Shore Hospital
I did.
and you were there overnight
Yes, I was. Yeah.
and you've had a chance to read those records?
Briefly, yes. It was
Did you
very
know,
hard.
or
to
do you
read them.
understand that you were placed on 30-minute observations?
I was not aware of that.
Did you subsequently then go to another health facility?
I did.
How long were you there for?
Approximately 12 days.
And from then, where did you go?
Well, given the intense media scrutiny and some advice to me that media were staking out my home here in Sydney, there was strong advice from my lawyers and the treating doctors that I retreat back to Queensland to live with my mum.
And where was your mother during this period of your stay?
In Toowoomba in Queensland.
And did she travel down here?
She did.
And when you were released or discharged, where did you go?
We commenced the drive back to Toowoomba, which is 10 or 11 hours, overnighting at close family friends in the Hunter Valley.
You said a moment ago, advice from my lawyers and doctors. Was there more than one lawyer?
Oh no, it was just Rick.
How long did you stay in Toowoomba for at that point?
Well, Toowoomba then became my primary residence, except for one journey back to Sydney in April to meet with John Corn, who had commenced as counsel.
And why did you have John Corn come into this matter?
Well, there are a number of reasons, but I understand there was, as we could foresee, criminal proceedings commencing or, an investigation underway. Rick Corn had some concerns about potential conflicts, so his father took over carriage of the matter in a primary capacity.
Did Mr. John Corn, did you ever ask him that you can recall any advice about defamation?
Not that I recall, no.
Can you recall whether or not he ever gave you or offered any advice?
No.
In relation to Mr. Rick Corn, did you maintain any communications with him?
Communications in the
As
sense
in,
of
when
what?
you're in Toowoomba, did you ever call him from time to time?
Oh, yes.
And you said you were following the story as it was being reported from February whilst you're in Toowoomba?
Yes, I was, yeah.
Did you ever raise with Mr. Corn some of the stories or the nature of these stories?
Often.
And what were you saying?
Every time an article would come out or Four Corners report or whatever, there was outrage, and it was apparent on social media that people knew that it was me, and it was a mixture of being upset, angry, and I wanted to fight back against the media.
And did you ask for advice in relation to fighting back from anybody?
Sure. Well, from Rick, yeah, sure.
At any stage, anybody else before the criminal proceedings finished?
No.
And did Mr. Corn, or what did Mr. Corn say?
Well, he kept maintaining his position that that any defamation would be considered after a resolution to the criminal matter.
You've given evidence to the effect that that's what he said on the 15th of February. Did that advice change at any time from him?
No, it did not.
Yeah, they're my questions, Your Honour.
Thank you. Yes, Dr. Collins.
Your Honour, thank you, Mr. Lehrmann. Mr. Lehrmann, you're here because you've sued the publishers of the Australian newspaper and the broadcasters of the Project television program.
Yes.
And two of the journalists involved in those stories.
Yes.
You sent a lot of messages to various people on the day that those stories were published and went to air via your phone, didn't you?
I did.
You back up all of the messages on your phone in the cloud?
I assume that's how it happens, yes.
And that's always been your position?
Yes.
you were backing up all of your messages as at the 15th of February 2021?
I'm sure I would have been, yes.
That meant that if one had access to your phone, one could see all of the emails that you'd sent,
Yes.
all of the text messages that you had sent,
Yes.
WhatsApp messages,
Yes.
messages that you had sent or exchanged via social media networks such as Facebook and Instagram.
Yes.
And you were an active user of the WhatsApp application,
Certainly.
text messages,
Yes.
you sent emails,
Yes.
and you used both both Facebook and Instagram.
Yes.
You had a Twitter account for some time as well.
Until Mr. Shiraz made me delete that.
You've had access to your telephone at all times on and since 15th of February 2021, haven't you?
Up until the 15th of February 2021. Yes. Yes.
After 15th February 2021?
Yes, up until the AFP seized it under warrant.
Telephone was seized by the Australian Federal Police, which executed a warrant on the 19th of April 2021.
Yes.
Did you continue to have access to the messages that had been on the phone because they were in the cloud after that date?
Yes, possibly, yes.
After that, well, just answer the question directly if you could. Did you or didn't you?
Yes.
You were able to continue sending text messages after the 19th of April 2021?
From a new number, though, yes.
You were able to access your WhatsApp messages both before and after the phone was seized, after 19th
No, not
April
WhatsApp.
2021?
No.
You're able to, is your evidence you don't have access to your WhatsApp messages from 15th February 2021 as at today's date?
As at today's date, I do now have access to, well, I have access to the Cellbright report, only recently, yes.
So just explain to His Honour how that came about. Just if you can identify the first date upon which you had access to the WhatsApp and other messages that you had sent on the 15th of February 2021.
That would have been soon after the notices to produce were sent from the respondents.
Okay, so you became aware that the respondents in this case had sought access to messages that you had sent on and around the 15th of February 2021.
Relating to this application, yes.
And you were asked by your solicitors to produce those messages?
I was.
And what did you do?
Well, I've produced them.
How were you able to produce them if you didn't have access to the messages on your phone?
Through the Cellbright report.
So when did you gain access to the Cellbright report?
3rd or 4th of March, soon after your notices to produce were served.
How is it that you didn't have access to it prior to that date? Are you able to?
I haven't had access to any material relating to my matter, being the criminal matter prior to this. Yes.
So how did you come to obtain access to it on or about the 3rd or 4th of March?
I don't recall. I think it might have been from my instructing solicitors who may have obtained it from Mr. Wybrow.
So is your evidence to His Honour that you had no access to any of the messages that you sent on the 15th of February 2021 between the 19th of April 2021 when the phone was seized by the Australian Federal Police and about the 3rd or 4th of March?
I did not have access to
Excuse me. I think there's need to be clarity in relation to this. When you say no access, are you referring to the fact that he didn't access them or that he couldn't, if he wished to, seek access to them? And at the moment, it's a little confused in the evidence about which of those you're talking about. He was able to access them when he sought to access them. And I would infer that they were in the position of his barrister. They were in possession of his barrister, given what he had said. Are you saying that that same access that he was able to obtain through his barrister was not available at an earlier time, or that he didn't do it? I'm just a little confused.
Let me clarify it with the witness. Thank you, Your Honour. You could have requested access to the Cellbright report at any time after the 19th of April 2021?
I'm sure I could have, yes.
But you didn't?
No.
And the only thing that prompted you to seek access to it was the notices to produce that were served by the respondents in this proceeding?
Yes.
But you recollect, don't you, that you had sent many messages, many hundreds of messages on the 15th of February 2021 via your mobile phone?
Sure.
You sent them via WhatsApp?
Sure.
I just want to test something you said before, Mr. Lehrmann. You're able to log into WhatsApp, aren't you, from any device, any electronic device, not just the mobile phone upon which you set it up?
Yes. I don't do that though. But
Sorry?
I don't do that. But yes, I'm aware you can do that.
You were an active user of WhatsApp as at the 15th of February 2021.
Mm-hmm.
You were an active user as at the time your phone was seized by the Federal Police on the 19th of April 2021.
Yes.
And did you continue to be an active user of the WhatsApp service after the 19th of April 2021?
Yes.
It's your evidence to His Honour that you did not seek to log in under a number that would enable you access to the messages that you had sent prior to, just wait for the question, Mr. Lehrmann, prior to the seizure of the phone.
Well, Dr. Collins, my phone was seized by the AFP. I had a new number and signed into WhatsApp under that new number. So I did not have the messages associated with the old number because that phone was seized and in the possession of the AFP.
Lehrmann, what I'm suggesting to you is that you well know that the WhatsApp service enables you to access messages which had been sent under a previous number as well as messages sent under a new number.
I was not aware of that.
Now, I want to ask you about your communications with Mr. Rick Corn on the 15th of February 2021. Who was it that recommended that you speak to him?
Harry Hughes.
Who's Harry Hughes?
A close friend of mine.
You said to Harry Hughes, didn't you, there's an article in the paper today, I need some advice about it?
I don't recall the exact words, but I reached out to him.
Well, you reached out to him because you had seen an article in the Australian newspaper?
Not the Australian newspaper.
Which newspaper?
No, news.com.
On news.com, thank you. So you'd seen an article on news.com.au and you'd realised it was about you?
Yes.
And your first thought was, this is damaging to my reputation?
Well, yes.
Yeah. And you thought you were outraged, you told His Honour?
Sure.
And your first thought was the possibility of defamation proceedings against those who had written the article?
Absolutely.
So you asked Mr. Hughes, did you, for a recommendation as to a defamation lawyer?
No.
What did you ask him?
I asked him if I can explain with Mr. Hughes. I was informed that I was the person subject of a criminal allegation by Rosie Lewis at the Australian at approximately 2 o'clock that afternoon. That is when I then reached out to Harry Hughes to seek criminal legal advice.
Is Harry Hughes a lawyer?
No.
So how did you come to know that Rosie Lewis from the Australian had...
Via my boss at work.
But at the time...
Sorry, I didn't hear that. Sorry.
Via my boss at work. Sorry, Your Honour.
That was the boss at British American Tobacco?
Correct.
Who had received an approach from Rosie Lewis of the Australian asking whether they had a response in relation to the allegations concerning you.
I believe, having seen the email through these proceedings, that she was not only asking for a response from British American Tobacco, but was putting questions to me.
So you were aware that the Australian was going to publish an article about you from that email communication?
I was not aware that they were going to publish an article, no.
You were aware that you were the subject of media interest from the Australian and the Australian was seeking your response to allegations against you?
Yes.
Yeah. And you received communications from other journalists, didn't you, on the 15th of February 2021?
Prior to Rosie Lewis?
Yes.
Possibly, I don't recall.
Don't recollect? Seriously, your evidence, Mr. Lehrmann, you don't recollect having been the subject of an article on news.com.au in which you weren't named, journalists reaching out to ask you about the allegations?
Yeah, Jack, that wasn't his evidence. The question was any other journalists, and it's just been put the article, so it should be clear.
Well, I think actually the first question was, does he recall being contacted by other journalists prior to 2 p.m. on the day when he was contacted by journalists from the Australian? So perhaps, Dr. Collins, you just clarify the question and
were you contacted?
Respond.
Sorry. Were you contacted by any other journalists prior to learning of the communication from Ms. Lewis of the Australian?
I don't recall that I was, no.
You were contacted by a number of journalists around this period, weren't you, about the allegations that had been published concerning you?
Well, after Ms. Lewis's approach, that was the case, yes.
Yes. You became aware, didn't you, that the project was going to be broadcasting a program on the evening of the 15th of February?
Yes.
And were you aware of that at the time you reached out to Harry Hughes to ask him for a recommendation as to a lawyer?
I did, yeah.
And you used at the time a Hotmail address, didn't you? A
Yes.
Hotmail email address. And you had received a series of questions, hadn't you, from the broadcaster of the project, informing you that there was going to be a story and that they wanted a response to a series of questions.
Well, I did receive them, yes.
Now, I want to ask you about your conversation with Mr. Corn. So your evidence to His Honour was your concern at the time was defamation and protecting your name in light of what had been published on news.com. And you asked Mr. Hughes for a recommendation as to a lawyer.
Yes.
He recommended Mr. Corn.
He did.
And I think you said to our learned friend, Mr. Wybrow, you can't recollect whether you reached out to Mr. Corn or Mr. Corn reached out to you. It's likely to be you reaching out to him, isn't it, given that Mr. Hughes passed on his name to you?
Well, not necessarily. I remember Mr. Hughes giving my number to Mr. Corn, so it is possible that he reached out to me. I honestly cannot recall on that day. It was a traumatic day.
Sorry, is your evidence to His Honour that you had a conversation with Mr. Hughes, was that in person?
Yeah, well, no, it would have been over the phone as well, yes, yeah.
So how is it you're able to say to His Honour that Mr. Hughes passed on your details to Mr. Corn?
He has my number.
Sorry, on what basis?
Mr. Hughes has my mobile number, so he passed it on to Mr. Corn.
Mr. Hughes tell you that he had passed your number on to Mr. Corn, did
He
he?
probably would have done, yes.
Speculating before His Honour, Mr. Lehrmann, I just want to ask you, please, to stick to things that you're able to give direct evidence of. Do you know whether Mr. Hughes passed your number on to
I don't
Mr.
know
Corn?
if he did or not.
So why did you say to His Honour that he must have done?
Well, I was in response to you, Dr. Collins, I was saying that Mr. Hughes has my mobile phone number and was in a position to hand that to Mr. Corn. So he may have done.
Is it the truth that Mr. Hughes gave you Mr. Corn as a contact and you called Mr. Corn?
It's possible that I did. I don't recall the exact moment that Mr. Corn and I came into being.
First communication was a telephone conversation between you and Mr. Corn?
A brief one, yes.
What time of the day was that, on the 15th of February?
I don't recall the exact time, sorry.
Morning or the afternoon?
The afternoon.
Was it before or after the project went to air?
Before.
Project went to air at 6:30?
Yes, I'm sure you're in receipt of that. So, yes.
So just take us through, if you would, what you said to Mr. Corn in that first brief conversation by telephone at some point on the afternoon of the 15th of February.
Well, that would have been seeking to meet to discuss the allegations that Mr. Lewis put to my boss.
Okay, so you said to Mr. Corn, to the effect, you've had an approach by a journalist from the Australian who are, you fear, about to write an article about you.
I wasn't fearing Ms. Lewis's article. She was alleging that I was the subject, or confirming that I was the subject of the sexual assault allegation, and she'd also confirmed that she'd heard it from government sources. So that's...
And did you tell Mr. Corn that you were also the subject of an article on news.com.au that morning?
I did bring it to his attention, yes.
In that first telephone conversation?
I don't recall it. I don't recall, I'm sorry, if that was that first phone call.
In that first telephone conversation, did you say to Mr. Corn to the effect that you were going to be the subject of a story on the project that evening?
Yes, I would have, yes.
And are you able to recollect anything else that was said in the course of that conversation?
No, it was very brief, and then it was mainly focused on setting up a face-to-face meeting.
Say to him in substance, I want to see you about considering my rights in defamation law against the people who are publishing these stories about me.
I did not approach Rick Corn for the purposes of defamation, no.
Now, you went to see Mr. Corn in his office, you said somewhere near the Downing Centre?
Yes.
What time of the day?
That late afternoon.
And was it arranged that you would be there for the purpose of watching the project as it went to air?
Not for that sole purpose, no.
Was that part of the reason why that was the time arranged for the meeting, Mr. Lehrmann?
No, it was, well, we had the Samantha Maiden article as well, which we discussed, and then obviously the core discussion around criminality and rights and around that.
Just coincidence that you were in his office when the project went to air. Is that your evidence?
No, we watched the project interview.
Yeah. You went to his office, Mr. Lehrmann, because you knew you were going to be the subject of a story on the project that night, and you went there so that you could watch it with Mr. Corn. That's right, isn't it?
Yeah, I didn't want to be alone.
Well, why did you tell His Honour that you didn't know whether you'd discussed being there to watch it when it went to air?
The reason I engaged Mr. Corn was for criminal advice, and the media were airing criminal allegations, and Rosie Lewis had identified that I was the subject of that. So,
Mr. Lehrmann, you gave evidence to His Honour that your primary concern on the 15th of February, when you saw the news.com article, was defamation. You remember giving that evidence?
yes.
No, that's not correct, Your Honour.
Well, he's just affirmed that it was, Mr. Wybrow.
Well, I must say to you, Dr. Collins, that was not my recollection of the witness's evidence. He did give, he's given evidence on a number of occasions about the fact that his primary concern at that time, and the reason why he contacted Mr. Corn, was because he had become apprised of the fact that there was a criminal, there was a possibility or there was a criminal allegation against him.
I think the transcript will reveal what the evidence was.
Yes,
but
contextually. Yes.
Well, yes, quite right. Now, how long was your meeting with Mr. Corn in his office on the 15th of February 2021?
It would have been over 6 hours or so.
Met with him for 6 hours on the 15th of February 2021.
I did.
And you watched the project together? And you told Mr. Corn that you were the person who was being accused of the sexual assault of Brittany Higgins?
Yes.
And you asked Mr. Corn, didn't you, before the program went to air, if he thought you were going to be named?
I did.
And Mr. Corn told you that he didn't think you would be named?
That's correct, yes.
Thank you. As at the 15th of February 2021, you were in a relationship with Greta Sinclair?
Yes.
And you sent her a series of messages on the 15th of February 2021?
I did.
And you were sending messages to her while you were in Mr. Corn's office?
I was.
And you sent messages, for example, at 5:37 p.m. on that day? You just need to say yes or no.
Yes, sorry.
Mr. Lehrmann. That's quite all right. Now, until the 15th of February 2021, had you told Greta Sinclair that you were the subject of the allegations that were the subject of the media reporting on that day?
No, I did not know about them.
You made a decision that you would tell her?
Yes.
And you told her on the 15th of February 2021?
And I found out.
That you told her before you went to see Mr. Corn?
Yes.
That was in a telephone conversation?
A brief telephone conversation, yes.
And what time of the day was that?
It would have early afternoon, soon after I was suspended from work.
Now, Mr. Corn said to you that he didn't think you would be named on the project that evening.
That's right.
And he said to you, didn't he, that if you were named, you'd be up for a lot of money from Channel 10?
I don't remember the exact wording of it.
That was the substance of it, wasn't it?
Sure, he was outraged at how the allegations were being aired.
I didn't ask you what his state of mind was, Mr. Lehrmann. I asked him what he said to you.
Well, I'm not going to confirm something I don't remember, so...
Let's put it to you again. Did he say to you words to the effect, prior to the project going to air, that if you're named, you'll be up for a lot of money?
I don't recall him saying that.
Say to you, if you're named, you'll be up for a lot of money from Channel 10, as well as the government and the Department of Finance?
No, I don't recall him saying that.
That you're saying you don't recall, or he didn't say that?
I don't believe he did say that.
I don't believe he said that to you. Thank you. I wonder if the witness could be shown. Does the witness have a copy of the court book?
I don't. No.
We'll just get you a copy of the court book, Mr. Lehrmann. don't be overwhelmed by it, Mr. Lehrmann.
No, I'm
gonna
used
take
to
you to
lots of
parts of it.
folders.
But if you have a look in the folder, you'll see there are numbers at the foot of each page, large numbers. I want you to go, if you would please, to page 470, 472.
Yes, Dr. Collins.
So just help us to identify this, would you, Mr. Lehrmann? Is this a printout from the Celebrite report of instant messages that you sent and received on the 15th of February 2021?
Yes.
And you've reviewed this before coming to give evidence today?
Yes.
Okay. And you see on the left-hand column there are a series of sequential numbers. At the top of page 472 it begins 94668.
Yes.
If you go down 2, you'll see message 94670. You see that?
Yes.
And it's identified as being an instant message in the next column. You see
Yes.
that? Does that mean, as you understand it, it's a WhatsApp or an SMS?
I take that to mean an SMS.
Is that typically how you communicated with Greta Sinclair as at 15 February 2021?
Yes.
Yeah. And the next column we see a reference to it being an outgoing message. Do we take it from that the message which then follows is a message you sent her rather than one that she sent you?
Yes.
Go over to the next entry. Do we see a date, the 15th of February 2021 at 5:06 p.m? You see that?
Yes.
You were already in Mr. Corn's office as at that time?
Yes.
In the next column we see sent from a number. I won't read it out, but was that your mobile phone number as at 15 February 2021?
It was.
And the number following that, again, I won't read it out, but that was Ms. Sinclair's number?
Yes.
Just pausing there for a moment. I'm sorry, Dr. Collins, but is it your understanding that remains, or perhaps you don't know, the number of Ms. Sinclair?
I still know that to be her number, yes.
Yes, all right. Thank you. In due course, when this material is filed, then I'd be disposed of making a confidentiality order in respect of that number.
Thank you, Your Honour.
Sorry, Doctor.
I'm just conscious of the time. If you want to...
We'll continue to go till 1 o'clock. Thank you.
So, Mr. Lehrmann, just concentrating on that entry 94670, I'm right, aren't I, that that's a message that you sent to Ms. Sinclair at 5:06 p.m. or thereabouts on the 15th of February 2021 while sitting in Mr. Corn's office?
It is.
And you see what you see the content of the message. You said, if I am named tonight, then he says I'm up for millions as defamation. You see that?
Yes.
That's the message you sent to Ms. Sinclair?
It is.
He was a reference to Mr. Corn?
Yes.
And that's what Mr. Corn said to you?
No, it is not.
Your evidence to His Honour that you've invented a conversation with Mr. Corn for the purpose of conveying a false message to your girlfriend?
I was placating Miss Sinclair, given she was incredibly upset and distraught.
Now, can you go to the next page, please? We're just pausing there. Look at the next message for me, please. 94671.
Yes.
See, that's a response you got, looks like 7 seconds later from Ms. Sinclair.
94671.
Yes. You see, it looks like it's sent at 5:06:57.
No, that's an outgoing message from myself.
I'm sorry. I'm sorry. I apologise, Mr. Lehrmann. That's a message from you to Ms. Sinclair saying, Harry, that's Harry Hughes, is it?
Yes.
Harry may join us as well.
Yes.
And that's because you were planning to have to get together with Ms. Sinclair and others after leaving Mr. Corn's office?
No. My recollection is that Harry, I didn't want to be alone that night and I wanted him to join me in Rick's office.
In Rick's office, I see.
Yes.
And did he come to Rick's office?
Best of my recollection, he may have joined us much later that night.
Ms. Sinclair go to Rick's office?
No, she didn't.
Can I ask you to go to the next page, please, page 473 in the court book. And you see at the top, The first message is 94732. That's a message from Ms Sinclair to you at 5:37 p.m, so about half an hour later.
Yes.
She says, I guess the project has started by now.
Yes.
And you respond in the next message, 94733, yeah. But then in 94734, we aren't watching yet.
Yes.
You were aware, were you, that the project had started at 5:37 p.m. on the 15th of February?
Well, I see what's happened. These times would have been in daylight savings time, I assume. Because you've previously told me that the project started at 6:30. These times are 5:37.
But no idea whether that's right or not, do you,
I
Mr
object, Your Honour.
Lehrmann? You've just made that up in the witness box.
Object. The document on its face tells us what the UTC is.
Yes, I know. I
It's
saw
unfair.
that. Do you want to reconsider that question?
Sorry.
Do you want to reconsider that question?
Yes, I won't press the question.
it
I
is-
withdraw the,
yes.
withdraw the question. So, Mr Lehrmann, the 5:37 you think is actually 6:37 because of daylight saving time?
Possibly.
Don't
yeah.
know. That's all right. Now, do you see a message 94735? It's a message from you to Greta Sinclair. It says 5:37:44. We'll just leave to one side the question of daylight saving time. That's a message you sent to Greta Sinclair. Warwick doesn't think I'll be named.
Yes.
And you told His Honour a moment ago, in answer to a question from me, that that is something that Mr Corn said to you before the project went to air?
I believe he would have thought that, yes.
Say it to you, Mr Lehrmann.
Best of my recollection, he would have said that, yes.
So I put to you perhaps 10 minutes ago that Mr Corn had said to you that he didn't think you'd be named, and you agreed that he had said that?
Well, it's hard to recall from 2 years ago.
You gave a definitive answer to His Honour not 10 minutes ago, Mr Lehrmann.
As I said, it is hard to recall the context in which these conversations were taking place.
What's your evidence now? Did Mr Corn say to you words to the effect, I don't think you'll be named, or not?
I don't recall. I mean, Rick, it's important to put it into context, I believe, that I was placating Greta because she was distraught, when in actual fact, I was in a sense putting on a brave face to Miss Sinclair.
Put it to you squarely, Mr Lehrmann. What you were doing was faithfully sending contemporaneous messages to Ms Sinclair in the course of your meeting with Mr Corn on the evening of the 15th of February 2021.
No, they were not contemporaneous.
And I've caught you out, haven't I? Because you agreed that you agreed not 10 minutes ago that Mr Corn had said to you the words set out in message 94735.
No, well, as I've told you, it is hard to recall exactly the nature of the conversations taking place. But what I was putting to Miss Sinclair was a brave face. I was not telling her the exact advice Mr Corn was giving me for fear it would upset her.
See, on your evidence, Mr Lehrmann, you weren't putting on a brave face. You were inventing conversations with your lawyer and passing them on to Miss Sinclair. That's your evidence.
To placate her, yes, she was upset.
You want His Honour to believe that your recollection of the conversation in the witness box today is to be preferred over the contemporaneous messages that you sent while you were sitting with Mr Corn in his office on the 15th of February 2021. That's right, isn't it?
Question, Your Honour. It doesn't follow.
Mr Lehrmann, would you mind just going out? I just want to deal with the objection. Yes. I don't want to embarrass you by dealing with when you're in the courtroom. So if you just go out, the court officer will get you in a moment. Yes, the objection.
Your Honour, the objection is that was an unfair question in the context where he said he didn't recall precisely everything, and my learned friend had put to him, I can't remember the exact question, but he put something that did not follow from his answers and was an unfair double-barrelled question in terms of inventing things, having seen this document, when he'd never accepted that he recalled precisely these matters. Now,
Dr. Collins, what I'm concerned about is this somehow morphing into some sort of broader exercise than legitimately should be the case on the extension of time application. Why does it matter what the nature of his representations were to his then girlfriend on this evening? It isn't what matters in this part of the case whether or not Mr. Corn gave the advice to him that he said he did. I'm not sure whether it's going to be put to him that he's being untruthful about that.
What will be put, Your Honour, is that Mr. Corn said to him the things which he faithfully recorded in these contemporaneous messages sent on the day, and that is the reliable evidence before Your Honour of what occurred in the meeting with Mr. Corn. Now, it becomes very significant when we get to the later messages where Mr. Lehrmann represents that he had formally retained a defamation lawyer on this day. Now, if Your Honour accepts that these messages are the reliable record of what occurred on this day, then it must follow in our submission that Mr. Lehrmann's evidence given in chief to our learned friend is not to be accepted.
So you say on this application, it's necessary for me to fairly dispose of this extension of time application for me to make a finding as to whether on the one hand the representations he was making to his girlfriend that evening were true, or on the other hand, he was, as he said on a number of occasions, placating a girlfriend who was upset on that day.
Well, broadly, there are two matters that Your Honour will have to address in the judgment on the extension of time application.
But you say it's necessary to make a finding on that issue?
Yes, Your Honour. Yes. Your Honour will have to resolve what was Mr. Lehrmann's state of mind about the prospect of criminal proceedings being brought against him. I'm about to come to a series of messages where he represents that he'd been told criminal proceedings were completely off the cards, he was completely in the clear, the matter would never see the light of a courtroom. There's further records down the track to similar effect, to which I'll take the witness. That's directly inconsistent with the evidence that Your Honour's ruled out from Mr. Svillin's affidavit on hearsay, and directly inconsistent with the evidence that this witness gave to Mr. Wybrow in chief. There's no getting away from it in our respectful submission, Your Honour. If this witness's state of mind was as represented in these messages, then it was not reasonable for him not to bring defamation proceedings in the first year. He thought there was no risk
I'm not seeking to cut you out from legitimate cross-examination.
No. That's how we put it.
I'm not going to. I want to understand how it fits in. I've already expressed my view as to what I think is what might be described as the Tigris and Euphrates of this application, but I don't want the cross-examination to develop into some sort of broader exercise that's necessary to fairly dispose of this application. But you, of course, are experienced counsel, and I'm not going to stop you if you want to put submissions based on this material. That was really a relevance issue that I want clarified myself. To be perfectly frank, I can't now recall the question. If I could just direct you to put whatever it is you were intending to put again.
I objected on an unfair question, but the broader basis, my learned friend indicates the proposition that's being put and then draws this bow from text messages. As I understand it, they are all text messages on the evening of the 15th of February, as somehow referable to a state of mind that continued for the next 365 days.
In any event, you called him Mr. Wybrow, and if on the basis the evidence in chief was relevant, and I think I've got to be, I have to allow the respondents to test it, irrespective of my view as to what I really think matters on the application. Court officer, if you could please have the witness come back in.
But Your Honour, it is 1 o'clock, isn't it?
Oh, it's 1 o'clock. How much longer are you going to be, do you think? Another hour. Right. Well, look, if I'm looking around vainly for a clock. I do have a watch.
We have one. It's
I have a
1:01.
watch. I have a watch. Look, I want to get through this today, the evidence, at least. And if you're going to be another hour, I don't want other respondents cross-examining on the matters you cross-examined on. If there is anything, any particular question which has not been covered by the general topic of cross-examination, of course I won't shut you out, but I don't want repetitive cross-examination on anything. Look, I realise we started at 9 o'clock, and I hope this isn't imposing on counsel unduly, but I do want to try to resolve this today because of my availability issues. So is it possible to come back at 1:30, or is that cause insuperable difficulties?
Of course, Your Honour.
It's fine, Your Honour. Could I just raise...
Don't have a conference at lunchtime.
Obviously, could you... we'd ask that you'd call Mr Lehrmann back and give him the usual warning so he understands why we...
Yes, certainly, I'll do that, Mr Whitebread. That's a sensible course.
If I'm absent or seek to absent myself at any stage...
No, I
seek your leave.
I understand the difficulty you find yourself in, but Mr Rolson's here.
Yes, thank you.
Sure can step into the breach.
Yeah,
that's what a junior's for.
Thank you, Your Honour.
Mr Lehrmann, we're going to take a luncheon adjournment now, and we'll come back at 1:35. So if you could be back here just before 1:35. At present, you're under cross-examination, and I'm saying this to you, it's nothing to do with you, nothing to do with your evidence. It's something that's said to every witness, or at least I say to every witness who's under cross-examination, and that is you ought not, during the currency of your cross-examination, speak to anyone about your evidence. So if you could just ensure that that occurs, then we'll see you back here no later than 1:34 to resume at 1:35. All right, we'll adjourn the court till 1:35.
I have to go and
No,
do
if there's
Silence will stand. The court is now resumed. Be seated, please.
Sorry I'm slightly late. Just had an urgent message about the necessity for me to relist another urgent matter at 4:15 this afternoon. So I'll have to, if we're not finished by then, I'll just have to interrupt this matter, deal with that, and then we'll continue.
We're certainly confident we've finished with all of the evidence, perhaps not the submissions.
Go ahead.
Lehrmann, I was asking you some questions before the lunch adjournment about the conversation that you had with Mr. Corn in the course of the 6 or so hours that you spent with him on the 15th of February. You haven't said on what time you think you arrived in his office?
Oh, the late afternoon of the 15th.
So the project went to air at 6:30.
I believe so, yes.
How long before the project went to air did you arrive at his office?
A couple of hours, possibly, yeah.
Best evidence you were there from about 4:30 to about 10:30?
Thereabout. It would have been later than 10:30.
Later than 10:30. It might have been more than 6 hours that you spent.
Yes, yes.
What time did you leave the office?
It was in the hours of the morning hours of the 16th.
I see. So after midnight. And did you have a few drinks while you were in his office?
I would have done, yes.
Because when you presented at the hospital the following day, you told Royal North Shore Hospital, you said that you'd been quite intoxicated the night before.
Yes. Yep.
And you did all the drinking in Mr. Corn's office. Is that your evidence? I'll go back to the conversation that you had with Mr. Corn at about the time the project was going to air and then shortly thereafter. After the end of the program, did you ask Mr. Corn what he thought was going to happen?
I would have done, yes.
Have a recollection of saying that to him?
Yes, yes.
And he told you, didn't he, that criminal charges, in his view, were completely off the cards?
No, he did not say that.
Said to you that the criminal charges were completely off the cards because, first of all, it's false, and secondly, they have nothing?
No, he did not say that.
Neither he said that to you? He said to you, didn't he, that you might have civil rights arising out of the program?
Civil what?
Civil rights arising out of the program?
Certainly after the resolution of criminal proceedings, he did.
I'm just asking you what Mr. Corn said to you. Did he say to you on the 15th of February that you could have civil rights arising out of the program?
Words to that effect, yes.
You understood that to be a defamation claim?
Yes.
He said to you, didn't he, that the criminal charges would never see the light of a courtroom? They were that outrageous?
No, he did not say that.
I put to you, Mr. Lehrmann, that you understood, as a result of the communications with Mr. Corn on the 15th of February 2021, his view was that you would never be charged in relation to the allegations that have been the subject of the project.
That was not how I understood his advice to be.
I ask you to go back to the court books. You still have that in front of you?
I do, yes.
While we're there, on these messages, can we proceed as common ground that Australian Eastern Daylight Time is 11 hours in advance of Coordinated Universal Time? So, for example, at the top of page 473, that should be 6:37. And
so Your Honour, they're all out by an hour because of daylight saving time. You agree with that, Mr. Lehrmann?
Yes.
Yeah, thank you. So can I ask you to look, please, at page 474. Go about halfway down the page. Do you see a message on the left-hand side, 94817?
I do, yes.
That's an instant message that you sent to your then girlfriend, Greta Sinclair, at about, we had an hour, about 8:55 p.m.
Yes.
Still with Mr. Corn at that time?
Yes.
Yep. You said to Ms. Sinclair in that message, criminal, he says, is off the cards completely. You agree you sent that message?
I do.
Reference to he was a reference to Mr. Corn.
Yes.
Put to you again, Mr. Lehrmann, that is what Mr. Corn said to you, and that's why you wrote that message to Ms. Sinclair.
He did not say that.
Your evidence to His Honour is that you fabricated a conversation with Mr. Corn for the purpose of conveying that to Ms. Sinclair.
It is.
Yeah. Your evidence is you fabricated it because you were trying to placate her.
Yes.
Yeah. How was that placating her?
Well, she was incredibly stressed and traumatised, and about what was reading and what I was telling her. And Rome was burning, and I was trying to put on a brave face.
So you made up a conversation with a lawyer?
Yes.
You typed this letter, typed these messages that I'm asking you about while you were sitting with Mr. Corn in his office, correct?
He was in the office, yes.
So while you're having a conversation with Mr. Corn, your evidence is you're fabricating the content of what he's telling you for the purpose of sending messages to your girlfriend.
Well, we weren't talking non-stop through the course of the night.
What were you doing?
I was watching the media, watching the project, conversing with friends.
The project was over, Mr. Lehrmann, some hours before this message, correct?
Yes.
What were you doing at the time you were sending these messages?
Well, I would have been myself checking Twitter and the media post the project.
Just you, Mr. Corn, Mr. Lehrmann, that you were having a conversation with Mr. Corn about your concern for your reputation arising out of what had been broadcast on the project that night. That was the purpose of you being in his office.
Through the course of my night, yes, with him.
And you wanted to be reassured about what was going to happen following the broadcast of the program.
Yes.
And you sought that reassurance, and Mr. Corn said to you, well, criminal is completely off the cards.
He did not say that.
You say he did say to you that you might have civil rights?
Yes.
So just looking at these messages, just so that I understand this, you say 94817 from you to Ms Sinclair, 755. Criminal, he says, is off the cards completely. Your evidence is that's a fabrication by you?
Yes.
Next message, so about a minute later, is it? A few seconds later, 7:56 or 8:56, you said to Greta Sinclair, one, it's false, and second, they have nothing. So your evidence is that that's a fabrication of a conversation that never occurred?
Yes.
Yep. Next one, 7 seconds later, 7:56:09, okay, 8:56:09, but we may have civil. So you say that's not a fabrication, that's what he actually said to you?
Yes.
And you've corrected in the final message on that page, 94820, a typo, you meant have instead of heave.
Yes.
So your evidence to His Honour is that these messages, all sent in the space of a minute, are a sort of mixture of fabrications and truth.
Yes.
Are you going on from those messages now, Mr. Collins?
I'm sorry.
Doctor, are you moving on from that now?
I've got just some more. Yeah, I'm moving on from the topic of Ms. No, I've got a little bit more to go on Ms. Sinclair.
Okay. Well, I just wanted to ask a clarifying question, but I'll wait till you finished.
Then did Mr. I think I might have put this to you, Mr. Lehrmann, did Mr. Corn say to you that the allegations, the criminal allegations, won't see the light of a courtroom? It's that outrageous?
No, he did not.
Go to page 475, please, and look at message 94835.
Yes.
Can you see that's a message from you to Ms. Sinclair at 8 o'clock, or it must be 9 o'clock, on the 15th of February, your message to her. And he said tonight, I won't see the light of a courtroom. This is that outrageous. You sent that message?
I did.
And the reference to he was a reference to Mr. Corn?
Yes.
But your evidence to His Honour is you fabricated that conversation for the purpose of placating Ms.
I did.
Put you again, Mr. Lehrmann, that evidence is not truthful evidence, and that the message you sent was a faithful statement of what Mr. Corn had said to you.
I disagree.
Okay. I'm moving on to a different topic in the messages. I'm done with Ms. Sinclair.
Can I just ask you about the message 94818 on page 474, Mr. Lehrmann?
818, yes. Yes.
Where you say, one, it's false, and second, they have nothing. Can you just explain to me what you meant by that message?
Refreshing my memory, Your Honour, I would have also been casting my own interpretation of what I was seeing in the media that night, yes, and that day. Yeah.
So that wasn't repeating something that Mr. Corn said, that was just your view?
Yes.
So, thank you.
You were seeking by that message, Mr. Lehrmann, to convey to Ms Sinclair that that is what Mr Corn had said to you, but you just say you fabricated that
Yes.
conversation. You wanted her to think that that was the advice you'd received.
Yes.
Yeah. Just you, that is the advice you received.
It
Mr.
was not.
Now, Talia Robertson is a lobbyist, or was a lobbyist, is that the right term?
Yes, for Barton Deakin, yes.
Barton Deakin. Barton Deakin is a government lobbying firm that has an association with the conservative side of politics.
Yes.
Yeah. How did you know Talia Robertson?
Since 2014, when I began working in government.
She'd become a friend, and you had her phone number.
Yes.
And was she a source of advice to you from time to time?
Yes.
And you contacted her on the 15th of February 2021 to seek her advice, didn't you?
Yes.
Called her?
Yes.
What did you say to her?
I would have indicated to her that I was seeking a criminal lawyer and spoke about the Samantha Maiden article.
Didn't you say to her, you need a defamation lawyer, Mr Lehrmann?
I don't agree with that, no.
This year you asked her for a recommendation for a defamation lawyer and she provided you with one.
No, she didn't.
Yeah. What time of the day did you contact Talia Robertson on the 15th of February?
It would have been that afternoon.
After you'd had your first conversation with Mr Corn?
Yes. Yes.
You already had a criminal lawyer to provide you with advice in the form of Mr Corn by the time you say you asked Talia Robertson for a recommendation as to a criminal lawyer. Is that your evidence?
Yes.
If you had a criminal lawyer, why did you need a second recommendation, Mr Lehrmann?
Well, Rick hadn't, I don't believe I'd informally engaged Rick, so I was seeking options and until such time as I'd had a face-to-face meeting with Mr Corn.
I've caught you out, haven't I, Mr Lehrmann? You gave His Honour evidence that you had a phone call with Mr Corn, which was for the purpose of arranging a meeting that very day. You remember giving that evidence?
Yes.
Yes. And you'd had that conversation, you just told His Honour, before you had this conversation with Ms Robertson?
To the best of my recollection, yes.
So you had no need to be scouting around for a second criminal lawyer when you hadn't even met with the first but had a meeting arranged. You agree with that?
I was seeking multiple options because this was the first time I've had to engage a lawyer.
Incidentally, you knew that Mr Corn was a criminal defence lawyer, didn't you?
Yes.
The name of his firm was Criminal Defence Lawyers.
Yes.
Yeah. You knew he wasn't a defamation lawyer.
Yes.
But you were concerned about exploring your defamation rights.
Well, yes, yes, certainly, yeah.
Now, I want to ask you about the conversation you had with Ms Robertson. So you say you asked her for a recommendation of a criminal lawyer. Did she give you one?
I don't believe she did.
Now, did you send some messages to Ms Robertson later in the evening on the 15th of February while you were still with Mr Corn?
Yes.
I want to suggest to you that you said to Ms Robertson that by about 11:30 p.m. on the 15th of February, you had two lawyers, one criminal, one defamation.
I did say that to her, yes.
And that was true?
No, it was not.
Why'd you tell her that you had two lawyers, one criminal and one defamation, but wasn't true?
To portray the image that everything was under control and things were going to be okay.
So you said to her, I've got two lawyers now, a criminal who says it's not his realm yet. That was true?
No.
You had Mr Corn, didn't you?
What do you mean it was not his realm?
You had a criminal lawyer, didn't you, Mr Corn,
Yes.
as at 11:30 p.m?
Yes.
And he'd said to you, criminal's not your realm yet.
He said to me that criminal was not my... No, he did not say that.
Suggest you he did say that to you because he told you earlier in the evening that criminal charges were completely off the cards.
No, he did not say that.
Substance you had nothing to worry about.
No.
And that therefore it wasn't his realm yet.
No, he did not say that.
Just putting it to you squarely, Mr Lehrmann, so that you can address it for His Honour. That's why you sent that message to Ms Robertson.
No, that is not why.
Why did you send a message to Ms Robertson saying that Mr Corn had said to you that criminal was not his realm yet?
Because Miss Robertson was a close friend and mentor for many years and was well connected into the political sphere, and I wanted to portray an image that my house was in order.
So you sent false, fabricated messages to your girlfriend because you wanted to placate her,
Yes,
and you sent fabricated messages to Ms. Robertson for what purpose?
as I just explained previously.
Then you said to Ms. Robertson that the second lawyer you had, this is at about 11:37 p.m, the second lawyer says you're up for a bit of money. You intended to convey by that that you had retained a defamation lawyer who had told you you were up for a bit of money because of what had happened in the course of the day.
I wanted to convey that. I wanted to give that image, yes.
And I just want to suggest to you that Ms. Robertson had given you the name of a defamation lawyer.
She did not.
You said to Ms. Robertson that Mr. Corn had told you you were clear from criminal charges completely. Remember saying that to her in a message?
I remember saying that to her, yes.
You do?
Yes.
Yeah. And that's because that is what Mr. Corn had said to you, Mr.
No,
Lehrmann.
he did not say that.
And now, Ms. Robertson told you that you needed to take this matter seriously and to go home and not leave your apartment.
Yes.
Yeah. What did you understand her to be? Why did you understand her to be telling you to go home?
I would have been probably because of the media scrutiny and to stay safe and in one place.
And you said to Ms. Robertson at about 11:45 p.m. on the 15th of February that you'd had a criminal lawyer and a defamation lawyer. Remember saying that to her?
Yes.
And going to put you that's true. That was true.
No.
You told her at 11:46 p.m. that you had retained those two lawyers formally.
I had not.
You said that to her though, didn't you?
Oh yeah, I agree. I said that. Yeah.
Going to put to you that was also true.
No.
And Ms. Robertson responded to you at about 11:47 p.m. I bet your lawyer is thanking me now. Remember receiving that message?
Yes.
You responded, you have no idea.
Yes.
Saying that?
Yes.
To you that what Ms. Robertson was saying was, I'll bet the defamation lawyer is thanking me, Talia Robertson, for having for you having been referred to him or her.
No.
And you responded, you have no idea, because you were seeking to convey that that was absolutely the case.
No.
You have no idea how thankful he or she is. No. Can you explain to His Honour why you responded, you have no idea, to the message, bet your lawyer is thanking me now?
I can't be sure. It would have been in the context of discussions with Mr. Corn.
I'm sorry, didn't quite catch that.
It would have been in the context of discussions with Mr. Corn.
Your evidence to His Honour is that those messages I've just taken you to were all fabrications about a non-existent conversation with a non-existent lawyer.
Yes.
Can I just understand 94987, that is the penultimate message on page 478, bet your lawyer is thanking me now, ellipsis. What did you think that was being conveyed to you by that comment?
The best of my recollection, it would have been with respect to something advice Rick Corn was giving me, and I was testing that with Miss Robertson.
But why would you say, bet your lawyer is thanking me now?
You mean Miss Robertson, Your Honour, said that.
I'm looking at the second last. You got page 478 there?
Yes, yes.
Look at the second last comment.
Yes.
Incoming from, and you'll see the number.
Yes.
To you.
Yes.
Bet your lawyer is thanking me now. I'm just trying to get your assistance in understanding what you thought was being conveyed by that text message.
To the best of my recollection, we would have been discussing advice Rick was giving me. I don't have a recollection of what the context of that, Your Honour.
But why would Rick be thanking her?
I'm not sure. I don't recall the context of those.
Thank you.
Isn't the answer, Mr. Lehrmann, that when Ms. Robertson sent you a message, bet your lawyer is thanking me now, she was conveying to you, and you understood her to be conveying to you, that the lawyer you had engaged on her recommendation was thanking her for the referral?
No, that was not.
And your response, you see at the bottom of the page, 94988, 1 minute later, about 30 seconds later, at 11:48 p.m, you have no idea. What you sought to convey by that was you've no idea how grateful he is. He or she is that grateful.
No.
What were you seeking to convey by you have no idea?
Well, as I'm trying to recall, it would have been in the context of discussions with Rick that night and what I was conveying to Talia.
Suggest to you that if your evidence is to be accepted, Mr. Lehrmann, your response to Ms. Robertson's message, "Bet your lawyer is thanking me now," should have been, "What on earth are you talking about?" You agree?
No, not necessarily.
Well, what explanation can you give for sending the message?
As I said to His Honour, I don't specifically recall the context and nature of this conversation.
Yes, I've caught you out, Mr. Lehrmann, that what happened here was exactly as I put it to you. You'd received a recommendation, taken up the recommendation. Ms. Robertson said, "I bet your lawyer is thanking me for the recommendation," and you responded, "You have no idea."
Can I object on the basis that there's been a very important message left out, which my friend keeps putting questions.
Barbara, you really shouldn't make an objection like that in front of the witness.
I haven't said...
Could you please go out, Mr. Lehrmann? Yes, but he's got the documents in front of him. You say that the question is unfair because of what, sorry?
Because...
94983?
Yes, and then...
Well, I'm aware of that.
No, it's 94984.
83?
84, which was not put to the witness.
I mean, these emails start, don't they? At 94978 on page 477. Is that right? Yes. And they go through to the end of that page.
Actually, it's a bit earlier, Your Honour. It's at 94969 on page 476, and then it's interrupted by 94969.
Oh yes, I see that. Let me read these, all of them, which I haven't been taken to. So it's commenced tomorrow won't be good, and that's the first. So that's the first communication of the messages from this woman.
If the 94967 is from...
Oh, yes.
From Mr. Lehrmann to her, but the context isn't clear.
What's
that? Your Honour, we're missing a lot of messages.
What's that in response to?
Can I just make this submission to Your Honour? If Your Honour looks at the sequential numbers, Your Honour will see that we are missing great swathes of the messages. So we have nothing, for example, at the bottom of 475, message 94837 was sent at 8 p.m. or 9 p.m. On the top of the next page, the numbers jump to 94965. So
well, it appears from 94967 that whatever the communication was that's a response to, the "yeah, true" is not there.
That's right, because there's 120.
Well, I would allow you to call, if you wish to obtain a copy of that communication, I'd allow you to call for that communication in order so we can get a full suite of the narrative of the communications.
We have asked for it and we were declined, but I do formally call for the messages, all of the messages between 94837 and 94965.
With that woman.
They're available in any printed out form or anything at this stage, Your Honour. They might be, I don't know. The brings us back to They can be provided, Your Honour, those messages, but it's pages 33,488 to 33,491 of a something of that nature.
Yeah, but in order to understand the context of the communications between these two individuals, I think it's fair that I was against the whole idea of having every communication this person's ever made in the history of that phone produced. I do think appropriately calibrated call, which has now been made under Section 36 of the Evidence Act, if it wasn't caught by the previous notice to produce.
There's no difficulty with answering the call except
Okay,
that
well, how logistically are we going to do that?
Maybe we can just isolate those.
Well, if your solicitors can isolate those, and if they want to send a copy of that document to my associate, then my associate can print it out so Dr. Collins, it should then be produced to the court and I'd give access to Dr. Collins to it. Because I think to assess, if you're saying the question's unfair because it's acontextual, because you have to have a look at all the communications, or some other communications, I think one has to look at all of them. It's little Delphic.
I'll just try and isolate those from a document that I have. Yeah, could I just get the page? It's the entries 94837 to 94965.
The start of it appears to be 94967 on page 476. That is the message at 11:35 and 13 seconds PM, recorded there as 10:35. Now, true must be in reference to somebody, so that message needs to be produced, and there are further messages with that lady during the course of the evening, then they should also be produced.
Your Honour, the page numbers that are missing, hopefully listed in an email from my learned friend's instructing solicitor, which is found at page 480 of the court book, where Ms Saunders identified yesterday morning the pages that are missing in between
That's useful, thank you, Ms Chrysanthou. So your solicitors can look at those page numbers on 480 and just scour that to see that all the messages from that lady have been produced. All right, well, is it convenient for you to go on to perhaps to another topic and perhaps return that when the call's been answered? Dr. Collins, can you get the witness back in, please? Thank you, Mr. Lehrmann. Go ahead, Dr. Collins.
Thank you, Your Honour. Mr. Lehrmann, could I ask you to go back to the court book to page 476? I'd just like to get your answers, please, in relation to which of these messages that you sent to Ms Robertson you say were fabricated conversations and which you say were faithful accounts of what you were told. Can you see 94971, where you've said to her, I've got 2 lawyers now? Is that a fabrication or true?
That's fabricated.
94972, criminal, that was true because you had Mr Corn.
That was known, yes.
Yes. 94973, who says it's not his realm yet. Is there evidence to His Honour that you fabricated that?
Yes.
And you say Mr Corn didn't say that, do you? Then 94974, and another who says I'm up for a bit of money. Is that a fabrication?
Yes.
Yeah. Then can I ask you about, at the bottom of that page, 94980, he said, "I'm clear from criminal completely." Did you fabricate that?
Yes.
Is that your evidence? I suggest you didn't, that was what Mr. Corn had said to you.
I disagree.
At 94983, please, on page 478, said to Ms. Robertson, "I've got criminal and a defamation." So you lied to her about that.
I did.
Then 94984, "Haven't spoken to anyone as you advised," which was amazing. You said that to her?
Yes.
That wasn't true, was it?
Well, I take that to be in the context of media.
Spoken to, obviously, Mr. Corn.
Yes.
You'd spoken to Ms. Sinclair.
Yes.
You'd spoken to Ms. Hughes, Mr. Hughes.
Yes.
And you'd spoken to Ms. Robertson.
Yes.
Yeah. Had you spoken to anyone else about the allegations?
Well, about the allegations, yes.
Why did you say, "I haven't spoken to anyone as you advised," which was amazing?
I take that to be in the context of media.
What had Ms. Robertson said to you by way of advice? What's the advice you're referring to there?
It would have been not to respond to media.
Then 94986, you see that? You've said retained formally. I take it that's a typo. You intended to say formally, F-O-R-M-A-L-L-Y.
Oh, yes.
Yep. And can I just put you that you said that because that was true. You had retained both the criminal and defamation law. So you lied to Ms. Robertson. That's your evidence?
Yes.
And then I think I've asked you the questions about 94987 and 94988. Incidentally, you drew a distinction in these messages to Ms. Robertson about a criminal lawyer on the one hand and a defamation lawyer on the other.
Yes.
And that's because you understood it was important to have separate defamation advice in order to assess your rights in relation to the articles and broadcasts that had implicated you.
No.
Why did you make a reference to the need for a defamation law?
I fabricated that.
I suggest to you, Mr. Lehrmann, you understood very well that in order to get defamation advice, you needed a defamation law.
Well, yes, I understand that. Yeah.
And you understood that as of the 15th of February 2021, didn't you?
Repeat
you
your
understood that in order to get defamation advice, you needed a defamation lawyer, not a criminal defence lawyer?
Obviously, yes.
Can I move to a different topic? Mr. Lehrmann, on the 19th...
Not rocket science, Dr. Collins.
I'm sorry?
It's not rocket science. It's not rocket science.
No, I couldn't agree more, Your Honour.
Take that as a personal affront.
Oh, defamation's not rocket science. Well, it's pretty close. It's pretty close. Mr. Lehrmann, you attended at the offices of the Australian Federal Police on Goulburn Street on the 19th of April 2021.
Yes.
And that was for the purpose of attending an interview.
Yes.
And prior to attending on the 19th of April 2021, you'd had a conversation with a Mr. John Corn.
Yes.
I don't want you to say anything about what Mr. Corn said to you. I just want to identify, he attended Goulburn Street with you?
Yes.
Yes. And he gave you some advice. I don't want you to say what it was, but he gave you some advice.
Mm-hmm.
And following that advice, you participated voluntarily in an interview with the Australian Federal Police.
I did.
The Australian Federal Police executed a search warrant against you for the purpose of obtaining your mobile telephone.
I did.
You handed the telephone over in compliance with the warrant. And you were asked for and you provided the password or passcode so that they could open the phone.
Yes.
Provided them with all of your usernames and passwords so that they could access your email accounts.
Of course, yes.
And your social media accounts, including Facebook and Instagram.
Yes.
And your WhatsApp messages. Okay. The police conducted an initial inspection of the phone while you were in attendance at Goulburn Street on the 19th of April 2021.
They did.
And they told you that as a result of that initial inspection, they had found a folder on the phone that contained images relevant to the investigation of the rape allegation against you?
Yes.
Dr. Collins, there's been no objection to this, but does this arise from the topics adduced in chief?
Your Honour, this goes to the Yes, in the sense that Your Honour has evidence before you of what happened before the Australian Federal Police got the transcript of it, and one of the issues in the proceeding.
Sorry, I should do
of
this.
course. Yes.
Sorry, Mr. Lehrmann, I'm sorry to have you jumping up and down like a yo-yo, but it's best you go outside when I discuss this with Dr. Collins.
I'm going to take the witness to what happened on that occasion, which is consistent with the messages that I've just taken him to and inconsistent with the account that he gave in chief. So Your Honour will see that he participated in a voluntary interview, at which time he said, I haven't needed to retain anyone formally because this is all just about a couple of media articles. That's the first point. The second point is we face three... We have to,
where does that appear?
Answer 25.
If you want, it goes in the court book 2. Court book 146. So the questions are numbered. And so Mr. Lehrmann was being given a warning of his rights, including his right to silence. Question 23. Now, do you wish to communicate with your legal practitioner at this time? No. Question 24. And is it correct that, again, I'll just reiterate, you attended here earlier with Mr. John Corn, your legal representative. Answer, yes, that's right. I want to just make it clear at the moment, I'm just, taking advice. Question 25, okay. Answer, he hasn't been formally engaged in a sense because I haven't been, it's just been a media report, so Question 26, right. Answer,
so this is going, but these are questions going to the fact that someone's downplaying something in a ERISP to the police. Is that what the
we say it's consistent with the advice that we say he received from Mr. Corn.
I'll allow you to cross-examine on that. Is there any other topics which weren't the subject of the material?
First, we say, Your Honour, we're entitled to cross-examine at large on matters relevant to the application for an extension of time, and one of those matters is the extent to which Mr. Lehrmann remained stumm, to take Your Honour's term, in the period leading up to the criminal trial.
I don't want this cross-examination to extend further than is necessary to fairly dispose of this application. There doesn't seem to be any dispute about the fact that he participated in an ERISP on the 19th of April 2021. I've got a record of interview. It doesn't seem to be in dispute that the transcript records the representations that were made, questions asked and representations made by him. What additional material is it that you say
Your Honour,
reflects him making out of court representations concerning the charge?
Entitled to ask him, did he voluntarily answer all the questions? Did he withhold anything? Doing his best to provide a complete and full account to the police, knowing that what he said could be used against him in the subsequent proceedings. Our ultimate submission will be there was nothing left to protect from the interlocutory processes of the civil proceeding by the time the police...
No, I'm just trying to work out what you did with it. I don't want... It's a sensitive issue. I don't want to unfairly circumscribe you. It seems to me those two things that you've identified are fairly able to be the subject of challenge. I just don't want him to have to jump up and down again. So is there any other topics?
One other topic, Your Honour, is the photos that were taken. I'll just take Your Honour to this, the photos that the police seized. Your Honour goes to Court Book 452.
453.
Yeah, 452 is the
452
other page. So the police appears from the transcript, on the inspection of the phone, went away and conducted an initial inspection and identified in the photo app on the phone...
Yes, no, I saw this.
...albums. Then if Your Honour goes to the photographs of what they took, take photograph 3, for example, put the page one, sees on the 4th of... Now, this is relevant to this question of staying stumm. On the 4th of March, we've got a reference to speaking to someone, Joanne of PR, and presumably her rates of $3,000, with the talk about ACA and 60 Minutes, Channel 7 Nightly News, and Andrew Clennell and Andrew Bolt of the Sky Network.
Yep. Oh, I understand that. Yep. Okay.
That's the only, that matter, and then I have two, probably no more than two questions in relation to the health issues, and I'll be done.
All right, thank you. Well, I'll try not to interrupt you again.
Not at all.
Thank you. Yes, Court Officer, thank you. I should ask you, Mr. Ossett, do you have any issue with him being asked questions on those topics? That have been
Not if it's confined in that way, Your Honour.
Yes, right, thank you. Thank you, Mr. Lehrmann. Yes, Dr. Collins, when you're ready.
Thank you, Mr. Lehrmann, for your forbearance. I was asking you some questions about what occurred when you attended the Australian Federal Police Office in Goulburn Street on the 19th of April. I think you said to His Honour that you participated voluntarily in an interview, and the interview lasted some hours?
Yes.
About 4 hours?
Yeah, I believe so.
And your phone was seized in the course of that attendance?
Yes, immediately, yeah.
And you answered all of the questions that were put to you to the best of your ability?
Yes.
Yeah. You didn't exercise your right to silence at any time?
No.
Because you wanted to convey to the police officers attending the full version, your version of the events, as fully as you could?
To assist their investigation, yes.
Sorry, what did you say?
To assist their investigation, yes.
Didn't withhold anything from them?
No.
Told on a number of occasions that you weren't required to answer any questions that they put to you?
Yes.
And you understood that that was an important right, but you chose not to exercise it. I ask you to go in the court book, please, to page 146. I'll just help you identify this, Mr. Lehrmann. This is the transcript of your attendance at the Goulburn Street Police Station on the 19th of April. So you'll see the start of it on page 129.
Yep, it looks familiar, yes.
If you go to page 146,
yes,
you can see there's a series of questions and then your answers. You see that?
Yes.
Let's start at question 23. So you were asked, I think this is by Officer Borman, B-O-O-R-M-A-N. Now, do you wish to communicate with your legal practitioner at this time? And you responded no.
Yes.
And is it correct that, again, I'll just reiterate, you attended here earlier with Mr. John Corn, your legal representative? You were asked that question?
Yep.
And your response was, that's right. I want to just make it clear at the moment, I'm just, taking advice from him. You see that?
Yes.
And what you were seeking to convey was that you hadn't formally retained Mr. John Corn at that time?
Yeah, well, yeah, I was taking legal advice from him. So
Yeah, you're taking advice without having formally engaged him?
yeah,
Sorry, I know I said I would interrupt, but I do have to understand this. Mr. John Corn is a barrister?
yes. Sorry.
Yes, that's right.
Father of.
Yes. Father of Rick
So
Corn.
the son, solicitor, instructed his father as the barrister. Is that right?
Is that what happened, Mr. Lehrmann?
I assume so. You'd have to ask Rick. I wasn't privy to the, yeah.
You told His Honour before that Mr. Rick Corn couldn't assist because he had some sort of conflict.
That was what was conveyed to me, yes.
He was the source of the referral to his father, Mr. John Corn?
Yes.
But you're not sure of the details of how Mr. John Corn came to be
No.
engaged to help you?
No.
Okay. Was there a separate firm of solicitors involved?
A separate firm
Of solicitors involved?
No.
Or criminal defence lawyers involved?
No.
What was the conflict?
I wasn't privy to that. Yeah, I don't know, Your Honour.
So did you understand that usually you instruct solicitors and solicitors retain barristers?
Yeah, I understand that, of course, yeah.
Did you understand that your solicitor, Mr. Rick Corn, had retained on your behalf Mr. John Corn, a barrister, or was it more informal than that, or what was happening at this time?
I believe it was somewhat informal. He was briefed on the matter to represent me, but because of that unorthodox nature at this point, because I understand barristers wouldn't typically come into a matter at this point, but he identified that he may have a potential conflict, so brought his father in.
Thank you.
By a barrister wouldn't come into it at this point, you meant that you hadn't been charged with anything?
Yes.
Hadn't been suggested to you that you were about to be charged with anything?
By who suggested?
By anybody at the Australian Federal Police?
Oh, no, not by the police. No.
In fact, quite to the contrary, they said to you, you're here to assist with investigations in a voluntary capacity.
Yes, I don't know if that were the exact words in voluntary.
That was the substance of it, wasn't it?
Yes, yeah.
And that's what you understood. You were there voluntarily,
Course,
not under
yeah.
any compulsion.
Yeah.
And you didn't need a barrister in the formal retainer sense because you weren't facing any charges that required anyone to go to court.
No.
So question 24, when you said, I just want to make it clear at the moment I'm just taking advice from him, you were conveying that you'd taken advice from him solely for the, I don't want to say what he said, but solely for the purpose of attending for the voluntary interview with the police on that day.
Yes, not in his capacity as in the orthodox way a barrister would appear in a matter.
Yeah, because you didn't need a barrister at that time.
Yes.
And then at question 25, the officer says, okay, and then you elaborate. He hasn't been formally engaged in a sense because I haven't been, it's just been a media report, so you know. Remember saying that?
Yes.
So it's just that was your state of mind at the time, that there was, you understood that criminal allegations were off the cards because all that this was about was a media report.
Not that they were off the cards, no.
Mr. Rick Corn had said to you on the 15th of February that criminal charges were completely off the cards.
He didn't say that.
And that they would never see the light of a courtroom.
No.
But why did you say to the police that this has just been a media report if you, in fact, thought it was much more serious than that?
Well, because I was voluntarily participating and they hadn't sought to arrest me and they'd taken some time to come and speak to me.
Well, was that truthful, what you said to them?
Yes.
That you hadn't formally engaged because it's just been a media report?
Yes.
Now, you gave some evidence before, Mr. Lehrmann, about your mobile phone containing, don't want to sound pejorative, but effectively your whole life was on your phone the same way our whole lives are on all our phones. Yeah. You had your emails, WhatsApp messages, text messages, social media accounts, and you're in the habit of taking photographs of your handwritten notes.
Yes.
And so once is this right?
Well, sorry, you said I'm in the habit of. I'm not in the habit of taking notes. I did that in order to give to the AFP to assist them.
I'll come to what the photographs were of, but is this right, Mr. Lehrmann, that once the police had your phone and had access to your phone, they had access to all documents in your possession that were relevant to the allegations that the police were investigating?
Yes.
There was nothing that they didn't have access to once they were able to access your phone?
Yeah.
No other documents anywhere?
No.
And you understood that once the police had access to your phone and you'd handed over the means of access to the various accounts on the phone, they could use anything they identified on the phone for the purpose of the prosecution?
Yes.
Now, one of the things that the AFP identified was an album in your Photos app titled Higgins Matter Blue Notebook. You recollect that? And were they photographs you had taken of handwritten notes you had made in what was physically a blue notebook?
Yes.
You started a notebook headed or titled Higgins Matter sometime prior to going to the Federal Police on the 19th of April?
Yes.
What was the purpose of that notebook?
To compile what I was seeing in the media.
Compile what you were seeing in the media. And wasn't part of it also to plan your fight back against what you had seen in the media?
Sure.
And I'll just take you straight to it if I could. If you go in the book, please, page 452. So you can see here it's an AFP photograph cover sheet, which then in the subsequent pages contains a printout of the pages from the Higgins Matter blue notebook.
Yes.
Yep. And that's your handwriting, is it, that we see on page 454?
Yep.
455, and right through till we get to the end of those photos at page 461?
Yes.
ask you please to go to photograph number 3, which is on page 456. Sorry, 455. See that?
Yes.
And about halfway down the page, there's a date on the right-hand side, the 4th of March 2021. You see
Yes.
that?
Yes.
So we take it that you made the notes that we there see on the 4th of March 2021?
Yep.
So that's about 2 or 3 weeks after the article in the Australian and the broadcast on the project.
Mm-hmm.
On news.com.au.
Yes. Yeah.
And news.com.au. And it's a reference to Joanne. Do you see that? Who's Joanne?
From memory, a close family friend suggested her as someone who may be able to assist with media.
What do you mean by assist with media?
Just media inquiries that were coming in.
Written Joanne PR, is that because she was a public relations person as you understood it?
As I understood it, yes.
And is this a note of a telephone conversation you've had with her?
Oh, no. No.
What is it?
This would have been a conversation I had with my close family friend Lyndon, who suggested her.
I see. So you had a conversation with Lyndon. What's Lyndon's surname?
Bienoff. Bienoff?
Bienoff, thank you. About the need to engage, or potentially the need to engage a public relations assistant. And you've written down, does that say $3,000, $3,000?
Yes, that sounds right, yes.
What do you understand that to be?
A cost associated with Joanne, yeah.
Then you've written under a series of sort of bullet points, ACA and 60 Min's investigation, you see that?
Yes.
Then Channel 7 Nightly News, you see
Yes.
that? And then Andrew Clennell / Andrew Bolt,
Yes.
who are Sky News presenters.
Yes.
Is this right, that you were putting those media organisations and journalists down because they were potentially friendly media outlets to whom you might tell your story of what happened back in March 2019?
Yeah, I believe that to be the case.
So it's an honour to understand that as at the 4th of March 2021, you were actively contemplating telling your story publicly?
Well, I had a lot of people advising me to do that, yes.
And so you were actively contemplating it?
It was an option, yes.
You were thinking about which media outlet you might go to tell your story?
Sure.
That's why you've selected media outlets not associated with the Australian or the project?
Yes.
You thought that A Current Affair or 60 Minutes might be interested in an exclusive interview with you?
It appears that to be the case, yes.
Yeah, or the Channel 7 Nightly News?
Yes.
Or the Sky News presenters? Yeah. See the names to the right, can you help us with those? Is it Rosie Lewis? Oh, that's the Australian journalist.
Yes.
Below that, Alex Smith, is it?
Yes.
Who's Alex Smith?
I don't know. Those three names appear to be people who I had thought had defamed me.
Well, just for his honour, who's Alex Smith?
A journalist, I assume. I'm sorry, I don't know. Yeah. At the time, yes, probably.
I see. So you think they're the names, you don't recollect why, but they were names of people who you thought you might have rights against at the time?
Yes.
And Vicky Campion?
I believe she is a columnist for the Daily Telegraph.
Thought she might have defamed you as well?
Yes.
And so as the 4th of March 2021, you were giving active consideration to your potential defamation rights against Rosie Lewis, Alex Smith and Vicky Campion?
Well, no, I'd noted them down because they had written articles that I was outraged at, yes.
Alexandra Smith is the state political editor of the Sydney Morning Herald, if that's some assistance.
Showing my Melburnian roots, you're right. Mr. Lehrmann, on the next page, 456, it's a little hard to read, but it looks like it's a note you made on the same day, is that right, the 4th of March 2021?
Yes.
And you've written March 22nd, 2019, so that's the evening prior to the allegations which were the subject of the charge you faced?
Yes.
And you've written in here, haven't you, your account of what you say happened on that night?
No, it was a collection of what I had seen the complainant traverse in the media, and then some annotated thoughts and versions of myself, but it's not a complete account, as you put it.
Okay. Just take the first bullet point. You've written BH, that's Brittany Higgins.
Yes.
Initiated drinks and we were equals.
Yes.
That's your statement, isn't it? Not something that you'd gleaned from the media that she had said.
No, because she also indicated she was intoxicated.
No, what it says, Mr. Lehrmann, just tell me if I'm not reading this correctly. BH initiated drinks and we were equals. You see that?
Yeah.
I want to put you that these bullet points are the key points that you wanted to convey to friendly media in an interview that you were contemplating giving at that time.
Not necessarily, no.
You wanted to convey to the media that you and Ms Higgins were equals, not that you were in a position of hierarchy or a different...
Certainly there were factual inconsistencies with what she was putting that I wanted to correct, yes.
Yeah, well, that's what you're doing here. You're jotting down the things that you want to get on the record in a media interview, correct?
I don't accept that it was solely for the purposes of a media interview.
But that was one of the purposes of it.
Potentially, yes.
You feel is it important at some stage for me to read these? I can't read these.
We might see if we can produce an agreed transcript of them in conjunction with our learned friends. It is tolerably clear if one spends enough time looking at them.
Right.
And as Ms Chrysanthus is saying, if you've got colour photographs, I confess it's not assisting me much. About halfway down the page, Mr Lehrmann, there's a reference to Q&A for March 2021. Are you able to assist His Honour with what that's a reference to?
Q&A, the program on the ABC. Yeah.
Then you've referred to Sam Maiden. Is that because she had appeared on Q&A at about that time?
I believe that, yes.
In the bottom third of the page, under the long line, we see the words friendly media. You see that?
Yes.
And here you were jotting down again potential media outlets to whom you could give an exclusive account of your version of what occurred back in March of 2019.
I don't believe that necessarily was the case. There was times that I was contemplating correcting some of the factual inaccuracies I'd seen reported, not necessarily tell my version of events. Yeah.
Sure, but you wrote it down because you were contemplating engaging actively with the media.
Yes.
You've written down here, again, assist us with this, it's Chris Yeoman, he was a Channel 9 reporter.
Yes.
Chris O'Keefe was a Channel 9 or a Current Affair.
Mm-hmm.
Jeff Bishop.
I think I got that wrong. It would be Jeff Chambers, the
Jeff
Australian.
Chambers, it might, yes, thank you. And then we see again Andrew Clennell and Andrew Bolt of Sky News. Considered them to be friendly media to whom you might be able to get your story out into the public domain.
Yeah.
Okay. Then could I take you over, please, to photograph 7, which you'll find on page 459. Again, at the top of the page, we have a number of journalist names. So again, Vicky Campion, you see that? Said to His Honour that you thought she was someone who might have defamed you?
Yes. Yeah.
Told that we've emailed a clear copy to Your Honour's associate.
Oh, thank you.
The next name is Sean Nichols. He is a Sydney Morning Herald reporter who was also working on the Four Corners program.
Yes.
You in fact had a conversation with Mr Nichols, didn't you?
Very briefly, yes.
And you told him your version of what had occurred on the 23rd of March 2019?
No, I did not.
Next is James Marrow. Who's James? Is that James Morrow? Yes. Thank you. Who's he?
I believe he's an editor at the Daily Telegraph. Yeah.
Why were you putting his name down on this document?
I'm not sure. It appears that it's a collection of journalists who are unfriendly and friendly.
Yeah, it seems to be a mixed bag on your evidence. Okay. Andrew Clennell was a friendly journalist, as you, from your perspective?
Yeah.
And so was Chris O'Keefe, who's the 60 Minutes producer.
Yes.
A bit further down the page, we see a name, Kyla Lusikian.
Yes.
Apologise to him.
Yeah.
He was a journalist, a newspaper journalist at the time.
Yeah.
He was another one you perceived to be friendly?
No, I don't think I would have. I don't know the context of why he was noted there.
Thank you. But just can I check that I've got this right, Mr. Lehrmann. What you were noting in the Higgins matter blue notebook, among other things, were some of the messaging that you might try to get into friendly media outlets and identifying some of the friendly media outlets you might speak to.
Yes.
And you contemplated engaging a public relations expert to assist you?
Yes.
Did you in fact do that?
No.
Just a couple further matters, Mr. You went to the Royal North Shore Hospital on the day after the Australian article and appeared and the project was broadcast?
Well, you keep saying the Australian article appeared. It was the representations from Miss Lewis to my boss.
I'm sorry.
Yes.
I'm sorry. In any event, on the day after the project went to air, you went to the Royal North Shore Hospital.
Yes.
So I didn't mean to mislead you, Mr. Lehrmann. And you remained at the Royal North Shore Hospital for a couple of days?
Yeah, yes.
And on the 18th of February, you were discharged by the hospital?
Yes.
And you went to the Northside Clinic? You voluntarily admitted yourself there?
Yes. Yep.
Are you asked to be referred there?
It was, yeah, there was referrals that were undertaken by the doctors at Royal North Shore. Yeah.
Did you ask for the referral to be voluntarily admitted to the Northside Clinic?
No, it was suggested by the team at Royal North Shore.
And I think you said to our learned friend that you spent about 12 days at the Northside Clinic?
Yes.
Discharged on the 2nd of March 2021?
That sounds correct, yes.
Could you have a look at page 402 in the book, please? See, it's a bit hard to read, but it's the discharge summary for
Yes.
the Northside Clinic. And if you look on the right-hand side, you can see a date admitted 18 February, date discharged 2nd of March.
Yes.
See that? And I won't read it out, but can I just ask you to read to yourself what appears under the heading Progress and Management, and just let me know when you've read that.
Yes.
Is that an accurate statement of what had an accurate summary of what had occurred while you were at the Northside Clinic?
Well, not necessarily. Well, yes, actually, at the Northside Clinic, yes.
Yeah. And could I ask you now, please, to go? Sorry, I'll withdraw that. Now, in the period after you were discharged from the Northside Clinic, you were anxious to return to work at British American Tobacco?
There came a point where, yes, I did want to try and get back on track with things, yes.
You had been suspended from your employment on about the 15th or 16th of February 2021?
15th, yeah.
Then you had the medical admission that I've just asked you about?
Yes.
You continued to get medical and mental health assistance after you were discharged from the Northside Clinic?
Regularly, yes.
By about late May, you were ready to return to work?
A gradual return, yes.
Anxious to return to work?
I wouldn't say that I was anxious, but...
you enjoyed your job, didn't you?
Most certainly, yes.
You were pressing to be allowed to go back to work?
Yes, more and often against my psychologist's wishes
early
on.
Well, you got advice, didn't you, from your psychologists concerning your fitness to return to work?
Yes.
And just want to suggest to you that by about late May, they had given you the all clear to go back to work, at least on a gradual basis?
Yes.
And presented that medical evidence to British American Tobacco?
Yes.
Let's go have a look at page 247, please, in the book. I won't go into it in too much detail, Mr. Lehrmann, but this is a report by a clinical and consulting psychologist dated the 1st of June 2021.
Yes.
And you see under the heading recommendations, again, the psychologist says, I'm happy to support Bruce as being fit to return to work. You see that?
Yes.
And you agreed with that assessment?
Yes.
Given the length of his absence, I would recommend a gradual return to normal duties is most appropriate. This may take the form of a starting on a reduced number of days, building up to full capacity over 4 weeks.
Yes.
So the medical advice you'd received was that you were ready to return to work by early June and to full-time work by about the end of June 2020.
Well, the return to work was an element of assisting me and my mental health. Yes.
To address my question, though, you were ready to return to work on a gradual basis by the start of June 2021?
Yes.
And to full-time work by about the end of June 2021.
That would have been a matter for BAT.
Well, just
whether it was full time.
Your desire was to return to full-time work by
yes.
about the end of June 2021.
Yes.
But events intervened in that you were terminated. All the questions I have saved for the call.
I was just going to inquire about that. Where it's
been emailed to your associate, I understand, Your Honour.
apparently it's been printed and will be here momentarily, so we'll just wait.
My learned friends might have some questions not traversing the topics that I've addressed. I'm very much in your honour's hands, but I'm happy to.
Well, I'm happy to use the time productively by doing that if you're content with that course. Yes.
Just finishing off where my learned friend was asking you questions in June 2021. You had formed the view, hadn't you, by 18 June 2021, that you were confident that there was a resolution to clear the criminal allegations in the near future.
Yes.
And that's what you told your employer on 18 June 2021?
Yes.
And you formed that view on the basis of legal advice that you'd received?
Yes.
Now, that was consistent with your state of mind in April 2021, wasn't it?
No. I'm struggling to see the context of your question.
Well, you had no reason to believe in April 2021 that you were about to be charged.
Oh, no. Well, if you can give me a date, before my AFP interview or
Yes.
during?
Before your AFP interview.
Oh, yes. I had no reason to believe I was going to be charged.
You watched the project on the 15th of February with Mr. Corn. You formed the view immediately upon viewing it that it was about you, isn't that right?
Yes.
And you formed the view, didn't you, immediately upon viewing it that you wanted to sue my client, Lisa Wilkinson?
Yes.
And you've always held that view, haven't you, since 15 February 2021?
Yes.
There's no objection to this, but I don't think it's fair for witnesses to be the subject of multiple cross-examinations. Now, you're going back to... No, please let me finish. You're going back to traverse issues as to state of mind at particular times that were cross-examined on by Dr. Collins.
Only in relation to my client, Your Honour.
You're dealing with the state of mind generally. He cross-examined in relation to defamation, potential defamation actions generally.
There's a point in this argument about this witness's state of mind in relation to my client. I had one more question to ask about that.
All right.
You were asked some questions about it, the photographs of your diary note. You weren't asked any questions about page 458. Can you just turn that up, please? It's dated 16 March 2021. Could you just tell me what that heading says? Media.
Media John, yes.
What does that mean?
That was to differentiate between John Corn and my close personal friend John McGowan.
So Mr. McGowan was giving you media advice?
No, he was not engaged for that. He's a close personal friend.
Just looking halfway down the page, do you see there's a line going across the page, a horizontal line?
Yes.
And you see my client's name, Wilkinson?
Yes.
And you see there's dashes coming out of that name, and one says Rush and one says Jarrett?
Yes.
Those are two persons who were accused.
What was the second one say? I'm sorry.
Jarrett. That's John Jarrett, the actor.
Yes.
Accused of rape.
Yes.
And you were aware, weren't you, that he sued for defamation despite being charged?
Not despite being charged. I was aware of his case and the involvement of your client.
In the John Jarrett defamation case?
Well, I had. It's clear that I'd written those notes and associated Miss Wilkinson to those matters.
Defamation matters?
At the time. No, not necessarily defamation matters, just I can't be sure, but it wouldn't have been that. That wouldn't have been what I put them there for.
Can you tell us why you put...
Well, I simply don't recall. It would have... These are rough notes of conversations that were taking place at the time.
Well, Mr. Rush was a very high-profile defamation plaintiff, and you knew that.
Yes.
And I want to suggest to you the reason you put his name there was because you knew that he was a defamation plaintiff who had sued the media
Yes. I was
in
aware of
relation to sexually related offences.
that. Yes.
You understood they were criminal offences for which he'd been accused.
Yes.
And he sued a week after he was publicly accused by the media of
I
those
was not
offences.
aware of that. That's
And what about Mr. Jarrett? What did you know about him?
not very much. And I
Accused of rape?
yes, I was aware of that. Yes.
Sued for defamation?
I was not aware of the timing of his defamation actions, if that's what you're going to suggest.
But did you know he had sued for defamation?
Yes.
And the reason you put their names there was because of their connection with defamation actions, wasn't it?
Yes.
You were aware, acutely aware, weren't you, as at March 2021, that you were in a position to sue for defamation?
I reject that I was in a position to sue for defamation.
Why do you reject that?
The legal advice I had at the time was to not commence civil proceedings, and I did not have the financial capacity to do that.
Well, financial capacity to commence defamation proceedings.
Yes.
You don't have the financial capacity now to run defamation proceedings, do you?
Check that question. I reject that question.
Did you make any inquiries as at March 2021 about lawyers taking your case on a no-win, no-fee basis?
No, I did not.
So you had no idea if you were able to obtain such lawyers on that basis, did you?
Can you repeat the question?
You raised your finances, sir.
Yes.
You had no idea whether you could obtain lawyers without paying them, did you, for defamation proceedings?
Well, I didn't make inquiries, so I didn't know.
And
I can interrupt you, Ms. Chrysanthou, for a moment, because those documents.
yes, thank you.
So I'll note that those documents have been produced in answer to the call made pursuant to Section 36 of the Evidence Act, and I'll grant leave to the respondents to have access to those documents.
Could we get a copy of those as well? Thank you.
Now, in due course, if there's one copy of that, I'll mark it MFI1.
Commencing a defamation case in March 2021 was on your mind, wasn't it, Mr. Lehrmann?
I wanted to, but for reasons explained to other questions, I didn't.
You relied on a solicitor who was a criminal solicitor, is what you've said?
Yes.
Who you hadn't even formally retained?
He was retained. He was advising me on the criminal matter.
No further questions.
Tell me when you're ready, Dr. Collins, after you've viewed that. If Ms. Enbold, do you want to ask some questions?
I do, Your Honour, but I just wondered if I could have a moment to review these before I commence.
Sure.
Thank you.
But having said that, I will restrict cross-examination on these documents to Dr. Collins. He's already started cross-examining on them.
May I start now, Your Honour?
Sure.
Mr. Lehrmann, Dr. Collins asked you about what was described as your blue book. Do you
Yes.
remember those questions?
Yes.
And you gave evidence that That was a book that you used to note down what you were seeing in the media.
Yes.
And you also gave evidence that you used that book to note down your planned fight back against the media. That evidence?
Yes, correcting, yes.
Now, if we look at page 457 of the court book, see there a photograph of a page of the blue book.
Yes.
And you'll see at the top the heading Media John.
Yes.
And you gave evidence earlier in response to Ms. Chrysanthou's questions that
Yes.
that was a reference to John McGowan.
Yes.
Mr. McGowan was your key media advisor at this point, wasn't he?
No.
Was he the person assisting you with your planned fight back against the media?
No, he's a close personal friend who happens to have many media contacts.
You nicknamed him Media John because he was the person who was giving you some advice from time to time about your planned fight back against the media.
No, it was to differentiate between the two Johns that I had in my life at that time.
But why nickname him Media John? Why would you give him that nickname?
Because of his historical background handling media.
So he wasn't giving you any assistance or advice in relation to getting your story out into the media?
He was not engaged to do that. He's a
No.
personal friend. He, of course, would have been giving advice as a friend.
I didn't ask whether you engaged him. I asked whether he was.
He would have been. I'll let you finish your question. Sorry.
Is it your evidence that he was assisting you in some way with your planned fight back against the media?
In some way, yes.
And then if we turn over the page to page 458, at the top of the page there's another reference to Media John.
Yes.
So is that another note of a conversation you've had with Media John McGowan, about your PR strategy?
No, because if you look at the contents of that, it is not.
What is it?
It is a conversation about... it appears to be a conversation of things he had seen and heard and was telling me, and I was noting them down.
And but it was a conversation about, think about why you were using this book, a conversation about your PR strategy.
That was an element of these notes, yes.
Now, can we turn, Mr. Lehrmann, to the text messages? They start at page 463. And if you could turn to page 467. See there at the bottom of the page, the second last message, but there's a message there from Mr. McGowan to you.
Yes.
That's a message from Media John to you.
Yes.
Sent on the morning of the 15th of February 2021.
Yes.
At 11:41 a.m.
Mm-hmm.
And you see there that Mr. McGowan says this: "You got any God?" And then we can see in the next message that he was intending to type gossip. You see that?
Yes.
"Have you got any gossip on who the Canberra rape guy is? The yarn says Rising Star, so that rules out our mates. But who else?" Do you remember receiving that message?
Yes.
And if we turn over the page, your response is there at 11:42. Do you remember sending that response?
Yes.
You responded, "No idea, mate, in the slightest."
Yes.
And do you see you've then sent another message to him 10 seconds later, "I haven't been approached"?
Yes.
I won't read out the next 5 messages, but do you agree that in the next 4 messages, I should say, there are text messages between the two of you in which Mr. McGowan is speculating as to who it might be? That is, who...
That would appear to be the nature, yes.
Yes, that is who the person is, the subject of the news article concerning Miss Higgins.
Yes.
And then at the bottom of the page, you sent a message to Media John at 11:44. I haven't had any approaches despite still being around then.
Sorry, what page was this?
Bottom of 468.
468, sorry. Yes.
So after Media John was speculating
Yes.
about who the Canberra rape guy might be, you responded, I haven't had any approaches despite still being around then.
Yes.
And at the top of the next page,
Yes.
Mr. McGowan responded to you, Yarn didn't make it clear bloke was in that office. Do you see that?
Yes.
And then you responded, oh, right. And then further down the page, you then sent a message to Mr. McGowan at 11:49 a.m. In which you refer to the article as being slanderous and defamatory.
Yes.
So do you agree that at this point you were focused on the defamatory nature of the publication that had been made by my client?
Yes.
Then if we turn over the page, page 470, see a message numbered 94595.
Yes.
You see there that you have received a message from Media John.
Yes.
He says she's on the project tonight, which isn't exactly prime time stuff.
Yes.
You then respond a few minutes later. They wouldn't name, would they?
Yes.
So were you concerned at that point that you might be identified in the project?
Yes.
Yes. And then again, you raised defamation. You sent him the message 12:39, pretty slanderous.
Yes.
And at the bottom of the page, well, it's Mr. McGowan then responds to you,
Yes.
well, it's defamatory.
Yes.
So the two of you, at around lunchtime on the 15th of February, were exchanging text messages about the news publication being defamatory.
Yes.
And the prospect that the 10 publication to be aired that night might be defamatory as well
Yes.
of you, if it identified you. Now, we know, Mr. Lehrmann, that you then went to see Mr. Corn in his office. And if we turn in the text messages to page 476, you see at the top of the page at 10:35 p.m, you sent a message to Mr. McGowan, to Media John.
Yes.
Get here.
Yes.
Now, Mr. Lehrmann, you must have had a conversation with Mr. McGowan prior to sending that text to him, get here. Is that right?
Probably, yes.
He wouldn't
Yeah.
have known where you were had you
Yeah,
not.
he knew where I was, yes.
How did he know where you were?
I would have told him via a phone call through the
so you
course
had-
of that afternoon.
Yes. So you had spoken to Media John
Yes.
prior, at some stage between lunchtime on the 15th of February when you were discussing the defamatory nature of the publications
Yes.
and 10:30 p.m. that night.
Yes.
Had a conversation with Media John.
Yes.
Then at 10:35 p.m, Media John responds, leaving in 5. You see that?
Yeah. Oh, yes. Sorry. Yes. Yeah.
So at that point, Media John is on his way to see you.
No, my understanding is that he didn't end up coming. That's my recollection. Is he didn't end up coming that night.
I think I just saw, Mr. Lehrmann, in the text messages that have just been produced, but I'll have a look now, a reference to you being with John. I'll just
Yeah. It might not have been in Rick's office though.
Sorry, Your Honour, it's difficult to do this on the run. Mr. Lehrmann, do you have the bundle of messages that were just produced?
MFI1.
No, only the folder that.
I'm not even sure what MFI1 is. Just bear with me, which is a bad thing for an MFI. Is this all the stuff? I don't know why there's all these staples in it. Well, look, this is all a bit of a dog's breakfast, frankly, these text messages. I'm going to adjourn. If someone can get me a bundle of the text messages that people want to have reference to, I think it's unfair on you to have it all over the shop. I'm going to adjourn. People can put together one chronological bundle of all the relevant text messages and number it from pages 1 through to where it ends, and then I'll mark it for identification, and then any wish to be shown to a witness, they can be shown by reference to the page number. And in respect of those you might mention it 1 through to numerically, but also put the number that's referred to in the court book, so when I go back and look at the transcript, I'll be able to see what page is being referred to. So I'm going to adjourn while that happens, and if it can be provided to my associate, my associate can then print out several copies and provide it to everyone, and that gives you the proper opportunity rather than having to search around.
Thank you.
All right, well, I'll adjourn until that task is completed.
This thing's up.
So, I understand we're only a minute or two away from obtaining a up-to-date and complete version of MFI 1.
Yes.
Can we proceed in the interim?
Yes, Your Honour, I think so. I should raise, Your Honour, the 23rd appears to be the day that everyone can attend. Double check that.
Thank you.
Your Honour, MFI 1 raises a couple of issues about production, in particular in answer to notices to produce and orders that have been previously made. There was an order made last Wednesday by Your Honour that the applicant produce all documents containing or recording any version given by Mr Lehrmann to any person, other than the AFP or his legal representatives, of events at Parliament House on 23 March 2019.
Sorry, there was an order presented by consent, which in fact I didn't make. I made
no,
a
there's
more
an order that's
refined
made.
version of it because I wasn't going to make an order that someone produced non-privileged documents.
No, there was an order
Privileged
made
documents. So I'm just trying to... What date was the order made?
8 March,
8 March. Let me have a look at that.
Order 5.
Yeah, to the extent such documents are not the subject of an extant claim for privilege.
Yes, and there's a message that is part of MFI 1 that clearly falls within the order that we haven't seen before. There's also messages that we're now seeing.
What was that?
Message is 15 February 2021 at 6:40. It's on page.
And who's that between?
It's from Mr Lehrmann to Greta Sinclair. And he gives a version of what he did that night on the 23rd of March 2019, a short... Never seen that before. Your Honour, there was also production in relation to references to advice given by Mr Corn in relation to defamation. And there's messages that we haven't seen before on 15 February at 4:58 p.m. Where Mr Lehrmann says to Mr Sinclair doesn't want any money, and then the next message a few seconds later is reckons defamation is a definite. We've never seen that before. Those two messages from our review of MFI 1 in particular are significant from our perspective, and we're concerned about without being...
Mr Lehrmann, would you mind just sort of stepping down at the moment while I deal with this issue?
We're concerned that we're only seeing these now. In answer to my question earlier, Mr Lehrmann, for the first time, raised financial resources in relation to the payment of lawyers. And these two messages, particularly in connection with the lawyer he had at the time and defamation...
I don't have a copy of these messages, so...
They're coming...
So
the two defamation messages are 33470.
I can't follow this.
Do you want to have the page references down the bottom?
I don't have page references.
I can...
In any event, you say that there's been insufficient, there's been inadequate production pursuant to the orders that I made on the 8th of March 2023.
Yes, in relation to at least those two categories from what we've read. I think Mr Collins will ask a few supplementary questions arising from these messages. But we're concerned from our perspective, particularly in relation to Order 5 last Wednesday on the 8th, the description to Ms Sinclair as to what happened that we haven't seen before was highly relevant to the arguments.
I haven't seen, all I know is I thought this order, I made it by consent, was in some respects silly, but the applicant agreed to it, but I did put non-privileged in because I just thought it was absurd to require people to produce privileged documents. I think all I can do, if you're concerned about proper production in the light of the material that's been produced this afternoon, is direct an affidavit be filed by the solicitor prior to the 23rd. So be satisfied what steps were taken to comply with the orders and why this wasn't picked up, if in truth these documents are relevant. Now, that'd be the only thing I would propose to do at the moment. I haven't seen them yet. I suppose I should look at them, and I haven't got the notice to produce of the 10th and 13th of March, I think. So if there's common ground, they should, perhaps in the next little bit while the cross-examination is going ahead, the applicants might form a view as to whether this was just an oversight or they think that they weren't required to be produced, or perhaps that could be answered now. Can that be answered now?
Your Honour.
Was that an oversight, or was
Yes,
it?
I got an email at 3:28 from my instructor noting that reviewing this, there's two messages that were an oversight and should have been disclosed, and they are the two that my learned friends raised, which is message number 94652 and 946.
Your solicitors instructed you it was an oversight?
Yes.
Right.
Yes.
Well, where do we go from there?
Only, Your Honour, that because Mr. Lehrmann obviously was a prolific messenger, that Your Honour has set aside the call we made for the entire document, but we wish to reconsider amongst ourselves a more limited call in relation to particular dates, being extracts from this document, because it seems to us that in the context of some of the matters that Mr. Lehrmann raises as being relevant to the reason why it was not reasonable for him to commence proceedings, there are extensive messages from Mr. Lehrmann on these occasions evidencing his state of mind.
Well, no, I'm not going to require production of messages which are self-evidently not relevant to the issues on this application. What I will do, however, we've all been around long enough to know that people genuinely make mistakes when they're answering notices to produce.
There's no criticism of my work.
Exactly. And what I would do is ask, as experienced solicitors acting in this matter, the solicitors to make sure, given the orders that were made on the 8th, that everything in what I'm marking MFI 1 exhausts the documents which fall into those categories. I think in the circumstances I should have an affidavit sworn by the 23rd by someone, in effect like an affidavit of discovery, saying that all documents responsive to those categories have been produced. I'm sure that the issue will be resolved then.
Thank you, Your Honour.
And it's now arrived, belatedly. Yes, all right. Well, the bundle of documents paginated, sorry, it starts at 21. Is there any reason why it starts at page 21 rather than page 1?
That's a page reference from Ms. I stand to be corrected. I think that's an internal page reference from Ms. Saunders' affidavit. The relevant page is at the bottom, 463, which is the existing court book reference. So if Your Honour goes to the court book at 463.
Oh, I see. And there's a B and A. I see. Well, we should be able to identify it by reference to that then. Yes.
What we've sought to do is to reproduce the documents that Your Honour's already seen and to
No,
interleave.
that makes sense. That makes sense now that I follow it. So I'll mark the bundle of text messages as this will now become MFI 1 on the application. And I'll no doubt someone will want to tender it in due course. Right, well, can we have Mr. Lehrmann back, please, Court Officer? I was reminded that at 9:30 a.m. Is the full court welcome to Justice Jackman. I'll need to attend that, so I won't be able to sit between, say, 9:30 and 10:15. Yes, thank you, Ms. Emma.
Thank you, Your Honour. Mr. Lehrmann, before the break, you recall that I took you through text messages between yourself and Mr. McGowan,
Yes.
12 o'clock on the 15th of February, in which the two of you were discussing the fact that the news article was defamatory
Yes.
and the likelihood that the 10 broadcast would be defamatory if I'd identified you. You remember that?
Yes.
And you gave evidence also, having looked at the text messages, that you spoke to Mr. McGowan, Media John, at some point after those text messages about catching up that evening.
Yes, that's my recollection.
Now we can see from the text messages that have just been produced, a message sent at 2:46 p.m. on the 15th. So that's at page 471A.
I don't have a copy, Mr. Enbom.
Or
471A.
yes, well, I'll give the copy. I'll give the MFI one to the witness, and perhaps give me a.
Thank you, Your Honour.
If I could have the other copy, please, Mr. Associate.
Sorry, Ms. Enbom, please repeat what page am I at?
471A. The text message at the bottom of the page.
Yes.
Give you a moment to read that.
Yes.
Can you see there, Mr. Lehrmann, that it was in fact Media John who told you that Rick Corn was available to advise you?
Yes, I see that.
Now, if we fast forward to later in the evening, turn to page 476. See at the top of the page the message that I took you to before the break. It's a message from you to Media John asking him to get here.
Yes.
So by this point, you've spoken to Media John about the defamatory nature of the publications. That was at around 12 noon.
Yes.
Had a phone call with him to arrange catching up this evening.
Yes.
And Media John has messaged you to tell you that Rick Corn has been arranged to give you some advice.
Yes.
Where is that?
That's at page 471A, the message at the bottom.
No, I understand that. I thought you were referring to something else
No, that was
after
my
471 capital
That was
A.
my summary of the evidence that had been given.
Yes.
And then you'll see, Mr. Lehrmann, if you move down the page 476, it's page 476.
Yes.
All of a sudden, you refer to at 10:37 p.m. So it's message 94971. You refer to two lawyers.
Well, it's 11:37 p.m.
Yes.
Yes. Yes, it is, Your Honour. I'm sorry.
Yes.
You refer there to having two lawyers.
Yes.
And it was put to you earlier by Dr. Collins that Talia had recommended a defamation lawyer to you. And you said that wasn't true.
No, yes. Yes.
Mr. Lehrmann, if it wasn't Talia who recommended the defamation lawyer, was it Media John?
No. No defamation lawyer was recommended.
Did Media John get in touch with a media lawyer for you?
Not to my knowledge.
Is it a coincidence that you have referred to having two lawyers, one being a defamation lawyer,
Yes.
after you've spoken to Media John about the defamatory nature of the publication?
Yes.
You text him and then you've had a conversation with him.
Yes.
And Media John was the person who you, from as early as March, you were using him to plan your media campaign.
In part, yes.
You say it wasn't Media John who found a defamation lawyer for you.
There was no defamation lawyer.
And so you maintain that you invented the existence of a defamation lawyer.
That's the evidence I've given to
Well,
Dr.
he's
Collins.
answered this
yeah.
question a variety,
I don't have any further questions then, Your Honour.
several times. All right, well,
That leaves the question of the additional documents that were produced, as to which I reserve my position to ask.
no, I was going to come back to you now, Dr. Collins. You go ahead.
Just a few questions, Mr. Lehrmann.
Sure.
Have you still got that bundle in front of you?
I do, yes.
Could you go
so
to
not the
page-
MFI document?
You know, MFI 1, the new bundle.
Oh, sorry, yes.
If you go to page 471, capital A, please.
Yes.
Very last message on that page, 94616, Miss Embom just asked you about that, and I think you agreed that it was Mr. McGowan who put you in contact with Mr. Corn.
Well, no. The message as read is Harry is going to send me the number.
Yes, thank you. Would you go over the page, please, to 471B and look at the third entry, 94619? You see that?
Yes.
So the next column says contacts.
Yes.
And then in the final column, Rick Corn.
Yes.
That suggests, doesn't it, that someone has sent you Rick Corn's contact details at about 2:58 or 3:58 it would be on the 15th of February?
Yep.
Does that refresh your memory about who contacted whom?
Yes, well, but it still would. It appears that Harry sent me the contact. Yes. Oh, you're asking whether I contacted Rick? Yes. Apologies. Yes.
So, is this what happened? Harry Hughes sent you Rick Corn's contact details.
Yes.
Him having first been introduced to you, not in the physical sense, by
Yes.
By Mr. McGowan, and you then received the contact details and called Mr. Corn
Yes.
to make a time to see him.
Yes.
Thank you. And then if you look at 94623 on the same page, you see at 3:01, which is 4:01 p.m.
Yes. Yes.
Heading to him now, he's cleared his Arvo for me.
Yes.
Does that help us to identify that you met with Mr. Corn some short time after 4 o'clock on the afternoon of the 15th of February?
That appears correct. Yes.
Thank you. And then if you go over the page, please, to 471 capital C, second message 94644, you see that?
Yes.
It's at 5:56 p.m. So a couple of hours after the last message. I'm still with Warwick Corn, who has accepted to be my lawyer. You see that?
Yes.
That was an accurate message, was it, that you sent to Miss Sinclair?
Yes.
Within a couple of hours of meeting with Mr.
Yes.
Corn on the 15th of February, you had formally retained him to be your lawyer.
Yes.
Now, did you discuss the terms of the retainer with Mr. Corn?
Yes. Yes.
He said to you he didn't want any money?
Yes.
And that was because he was being engaged on a very informal basis?
Pro bono basis.
Pro bono basis, because there was nothing to be done at the time.
Yes. Yes.
Now, did he tell you that defamation was a definite goer, or defamation was a definite?
I didn't quite hear that question. I'm sorry, Dr. Collins.
Did Mr. Corn say to you prior to the broadcast of the project on the 15th of February that he reckons defamation is a definite?
No.
Didn't say those words to you. Go please to page 471D.
Yes.
See the first message at 94651 is a instant you to Greta Sinclair at 5:58 p.m.
Yes.
Doesn't want any money.
Yes.
So that's an accurate reflection of what Mr. Corn had said to you.
Yes.
Yep. And then 14 seconds later, 5:58:17, you've texted Greta Sinclair reckons defamation is a definite. I suggest to you that that is what Mr. Corn said to you, and that's why you sent that message to Miss Sinclair.
I disagree.
Just let me understand this. You've faithfully represented what Mr. Corn said to you at 4:58:03 and fabricated what he said to you in the next message at 4:58:17.
That's correct.
Now, in the meeting with, sorry, one more question. Did Mr. Corn say to you, after the project had gone to air, that you were part of a bigger political hatchet job and you were a pawn?
No, he did not say that. No.
Go to page 473, capital A, please. See the second message, number 94766.
Yes.
That's an instant message from you to Greta Sinclair at 7:39 p.m. on the 15th of February.
Yes.
And the message you sent was, I'm a pawn, Rick says, as part of a bigger political hatchet job.
Yes.
Just to you that is, you were faithfully setting out in that message to Ms Sinclair what Mr Corn had said to you.
I disagree.
Fabricated that part of the conversation.
Yes.
In the meeting with Mr Corn, so you were in his office for about 6 hours, I think you said, maybe longer.
Yes.
Was he taking notes?
I don't think he was, no.
Quite sure about that. Go to page 475, capital A, please. We'll look at the fourth message, please, 94881. You see that?
Yes.
You see that's a message you sent at 10:02 p.m. To Greta Sinclair.
Yes.
And the message is, Rick keeps taking notes, though.
Yes.
See that? And the next message, very professional.
Yes.
Your evidence to His Honour that you were fabricating that Mr Corn was taking notes in a meeting.
Yes, as I've said to you earlier, Miss Sinclair was very distraught. I was presenting a brave face.
What possible difference could it make to tell her that Mr Corn was taking notes 4 or 5 hours into a meeting?
That I had my house in order and everything was going to be okay.
Mr Lehrmann, I just want to suggest to you that you wrote that because you were sitting in a room with Mr Corn for many hours and he was taking notes.
No, he wasn't.
Now, earlier this morning, I asked you some questions about, if you go, just to refresh your memory, if you go to page 476, see about halfway down the page, message 94969. That's a message at 11:36 p.m. on the 15th of February from Talia Robertson to you. Tomorrow won't be good. Rein the shit in. You recollect I asked you some questions about that this morning?
Yes.
And that resulted in a call for further documents, which we've now received.
Yes.
So I just want to put to you the context in which that was said for your response. Would you go back to page 475, capital B, please?
Yes.
And look at the third item on that page, 94928. You see a message there from you to Talia Robertson at it's like 10:42 p.m.
Yes.
And your message is anything happening.
Yes.
Be able to assist His Honour in what that query related to?
It would have been in relation to media.
Because you had her monitoring the media for you?
Loosely speaking, I suppose, yes.
Okay. And I'll take you through it quickly. The next one, 94929, Talia Robertson responds, nothing on news.
Yes.
Next message, 10:43, you to Talia Robertson, yeah, no naming. See that?
Yes.
And then at the bottom of the page, 94933 at 10:48, you to Talia Robertson said any contact now about goes through him. Is that what he'd said to you?
Sorry?
Is that what Mr Corn had said to you, that any contact now goes through him?
I believe that, yes, because he had carriage of the matter. Yeah.
So that was an accurate statement of something Mr Corn said to you, that's your evidence?
Yes.
Okay. And then top of the next page, 94934, we see Ms Robertson telling you at 10:52 p.m, do whatever your lawyer says to do.
Yes.
Then the immediate context for the message at 10:36 appears to be on page 475, capital F. The second message, 94958, is at 11:32, so 4 minutes before
yes.
the message I asked you about this morning. Talia Robertson to you, send me Harry's new number.
Yes.
That's Harry Hughes.
Yes.
I'm not going to read this out, Mr. Lehrmann, but you see the next message at 11:33 p.m.
Yes.
See your response to Ms. Robertson.
Yes.
2 messages further down, 94961, 11:34 p.m. Ms. Robertson's response to you.
Yes.
No, I'm at home and you guys need to keep it clean enough, exclamation mark, exclamation mark.
Yes.
And then the next message appears to be the one on 476 that I asked you about this morning. Ms. Robertson saying to you, tomorrow won't be good, rein the shit in.
I don't have on 475F.
476.
Oh, sorry.
9496.
Yes. Yeah.
Go to page back to 475A, please. In fairness to you, given you the context of the message about Rick taking notes. At the top of the page, 475A, message 94878 at 10:01 p.m, you to Ms. Sinclair having a scotch.
Yes.
And that was having a glass of scotch in Mr. Corn's office.
Yes.
94879 at 10:01 p.m, you to Greta Sinclair going through it all. You see that?
Yes.
That's what you were doing at 10:01 or thereabouts p.m. on the 15th of February in Mr. Corn's office. You were taking him through your account of what had happened back in March of 2019.
I would have been, yes.
Going through it all.
Yes.
And then we get to the message, Rick keeps taking notes though. You see that?
Yes.
That refreshes your memory, doesn't it? That Mr. Corn was taking notes as you were taking him through all of your account of what had occurred in March of 2019.
I don't recall seeing him take notes.
When you said Rick keeps taking notes, though, you were concerned that he was capturing matters in writing, weren't you? That's why you said though.
No, I wouldn't say that. No.
Why'd you say that Rick keeps taking notes, though?
I was presenting a face that the situation was under control. And it was a very professional setup that was occurring, and I felt safe in having him.
Whereas on your evidence, the real position was it wasn't professional. You were sitting in a lawyer's office drinking scotch and you wasn't taking any notes as you poured out your heart as to what you say had happened back in March 2019.
It was a traumatic time.
No, to answer my question, is your evidence that what was happening in Mr. Corn's office was not professional at all? You were sitting there drinking scotch and he wasn't even taking notes.
He had been engaged and I was giving him my version of events.
And he wasn't even taking notes?
I don't recall seeing him take notes.
You were drinking scotch as you did it?
Is there a law against that, Dr. Collins?
I'm asking you to portray to His Honour what was happening in Mr. Corn's office on this day that you say is a very traumatic day in your life.
That is what was happening.
No notes were being taken?
My recollection, no.
The reason you said at message 94882 very professional is because you would expect a professional to be taking notes as you gave your account of events from the 23rd of March 2019.
No, that reference was suggesting that I felt comfortable with his advice and services that he was offering.
So look at the next message, would you please, Mr. Lehrmann? 94883, about 17 seconds later, 10:02.
Yes.
You said to Ms. Sinclair, but, I think it's meant to be but I feel comfortable knowing it's confidential.
Yes.
That was a reference to comfort that the notes that Mr. Corn was taking would be kept confidential.
No.
Nothing further.
Examination. I've got just, matter for you. I mean, I have a matter at 4:15.
Of course. I should have attended MFI 1. I'm sorry, having now cross-examined on the document.
I'll take it. What I was going to suggest, I was going to stand it down now because I have to deal with something urgently. In the intervening period, perhaps the parties can get together and work out what parts of MFI 1 they say should be the subject of a confidentiality order, that is necessary in the administration of justice for that material to be suppressed and subject to a non-publication order. I want to remind the parties that the overriding principles of open justice, and unless it is necessary in the interests of justice for the administration of justice to suppress or make suppression or non-publication orders, they should not be made. Necessary, as the High Court reminds us in Hogan, being a strong word. Having said that, there is some material I could see could properly ground a suppression order. I'm going to stand it down while I deal with the other matter, because I don't want to receive this into evidence and it be available to people without finally determining the issue of the confidentiality order this afternoon. So someone's presumably got... So I might send you out. Perhaps if you step down, Mr. Lehrmann. Your cross-examination is now finished. You can speak to your counsel if you wish, but and give instructions. The issue of the confidentiality order, though, can be subject to discussion now, and then I'll come back, and I'd like to also resolve the issue about what parts of the, now that we've had evidence from Mr. Lehrmann, a lot of the, what I might describe as the froth and bubble we went through this morning concerning objections to a lot of that hearsay material led through his solicitor, maybe goes away. So I'd like to resolve what part of that material is going to evidence. So the only evidentiary matter we need to deal with then is Mr. Corn, and in your case, as I understand it, and then we respondents' cases when we meet again.
Short cross-examination of Mr. Spillins. There's still some short cross-examination of Mr. Spillins.
All right, well, if you step down, Mr. Lehrmann, and if you could call the next matter, please.
NSD 431/2020, Haswell and another, and the Commonwealth for case management and interlocutory hearing.
Please the court, I appear with my learned friend Mr. May for the applicants.
Is there any appearance on behalf of the respondent?
I understand Commonwealth Counsel is here. I saw Miss Gleeson of the outside the court.
Well, the matter's been called. If Court Officer, can you please ask counsel for the respondent and the...
Yes,
Oh, I see. Yes.
Oh, sorry. Please call Ms. Gleeson. I appear for the Commonwealth.
Yes.
Gleeson, G-L-E-E-S-O-N.
Yes, Ms. Gleeson.
Please the court, we've relisted the matter urgently and we've set up an affidavit of Craig Richard Alsop, affirmed today's date, which I read.
Any objection to that affidavit?
No objection, Your Honour.
All right, well, note that the affidavit of Craig Richard Alsop of 16 March 2023 is read, and I'll accept Exhibit CRA 1.
Your Honour will recall this matter is a class action concerning 7 communities relating to PFAS contamination. By way of context, the matter commenced shortly before or around about the same time as the Commonwealth settled 3 earlier cases concerning PFAS for communities of Williamtown, Oakey and Katherine. At the first case management hearing in April 2020, the court was told that there was a hope that the Commonwealth was prepared to proceed early to mediation, and the Commonwealth consented to orders readying the matter for mediation, which ultimately occurred in mid-2021. That was the first mediation. As part of making trial orders in September of last year, Your Honour ordered the parties to attend a further mediation. That was not opposed by the Commonwealth, and we proceeded on the basis that they were preparing to attend.
When was that order made?
September 2022.
Yes.
2nd of September. A lot of effort has gone into preparing for this second mediation, which has been fixed for the 21st of March, that is next Tuesday, before Mr. Jacobson of King's Counsel, who was the mediator of the earlier matters. Among other things, the applicants made arrangements to fly the applicant, Ms Haswell, who lives in Perth, to Sydney. And we've presented a whole lot of documents, which I won't go into for obvious reasons, to the Commonwealth, including a short position paper. We were told, Your Honour, on the 27th of January in connection with a security for costs application brought by the Commonwealth, that they were intending to spend at that point in time $700,000 preparing for this mediation and had an expectation of spending a total of about $1 million on both the mediations put together. So it came as a bit of a surprise to us to learn 2 days ago, for the first time, that apparently the Commonwealth has not got approvals, whatever that means, which I take to mean instructions, to make or receive offers at all at the mediation. Quite how they propose to spend all that money without any instructions is an entire mystery. And we were further told, as Mr Alsop recounts, that the Commonwealth needs a month from today to get approvals, whatever that may mean, which takes us to about a week out from the initial trial before Your Honour in this case. This is not, Your Honour, the conduct of a party who is taking the court's orders seriously. We are not going to turn up on Tuesday and go through some solemn farce in front of Mr Jacobson with a respondent who is telling us that they don't even have instructions to resolve the matter one way or the other or at all. It would be a total waste of time. This, Your Honour, is a so-called model litigant. It proffers zero explanation and it proffers zero apology to us for breaking the court's orders, in a sense, because it's saying it can't participate in good faith and it's not going to attend a mediation with authority to actually resolve the case. We don't know if it's some bureaucrat who's holding things up. We don't know whether the Minister for Defence, the Assistant Minister, Mr Thistlethwaite, Minister for the Environment, the Attorney General, we do not know who is holding this up because they have not told us. All we are told in vague terms is that the approvals, whatever they might be, may be done possibly by the 17th of April, a week before trial. It's totally unsatisfactory, Your Honour. And Your Honour needs to direct the Commonwealth to comply with its obligations, to comply with Your Honour's orders and to turn up at the mediation with instructions. Nobody is above the court's orders.
I'm not going to direct someone to comply with my orders. My orders are there. But as I understand it, an application is going to be made to vary the order. I understand the circumstances in which the matter is relisted, but is the appropriate course for me to hear from the Commonwealth as to their application to vary the order?
Well, Your Honour, it's, in a sense, it's my application because they've forced my hand. They've, in effect, told me they're not going to turn up on Tuesday and participate in good faith with authority. And so we have done all that we can do. We rung Mr Jacobson. He's got 1 day between now and the beginning of May, which is the 4th of April. But we want to have a productive discussion. We don't want to go through some kabuki dance next Tuesday. So we want a variation, Your Honour, of the order requiring them to turn up on the 4th of April, Mr Jacobson's only other date, and turn up with authority. I mean, it should go without saying, but apparently not for this model litigant, Your Honour.
All right, thank you. Yes, Ms Gleeson.
Your Honour, can I start by just adding to some information that my learned friend Mr Edwards has given you? There are in fact 3 dates that Mr Jacobson has available between now and the commencement of the trial. My instructing solicitor made inquiries this morning. In addition to the 4th of April, there is also the 11th and the 13th of April. Aside from that, I can confirm what is contained in Mr Alsop's affidavit, and that is that, number one, the Commonwealth is not in a position on Tuesday to make or to respond to offers that might be made at a mediation.
Why am I finding that out now?
The only thing that I can say, Your Honour, is that my instructing solicitors were informed on the 14th of March 2023 and took steps as soon as they were informed to inform...
What date were they informed?
The 14th of March 2023.
2 days ago.
Would Your Honour just excuse me for a moment? No, I withdraw that, Your Honour. I'm told that my instructing solicitors were advised on the 10th of April 2023.
April. That Friday, last Friday.
Yes, it was late on the Friday that they were informed of that matter, and paragraph 11 of the affidavit of Mr. Alsop points out when it is that Ms. Stevenson first informed the applicants. I don't have any instruction on this, but I infer that what occurred was that some instructions were then sought about when the Commonwealth would be in a position to make offers at the mediation, so that some arrangement could be made to reschedule the mediation. Your Honour, the position...
Was there any explanation given as to why the Commonwealth was not in a position to participate in the mediation in good faith, in compliance with the order that I'd made? Last year?
Your Honour, I cannot speak to what transpired on the phone calls that are deposed to in Mr. Alsop's affidavit above and beyond what's in the affidavit. I am in a position to tell Your Honour, firstly, the work that has been done to prepare for the mediation, and secondly, the reasons why it is that more time is required to obtain approvals.
Sure.
Turning first to the work that has been done, my learned friend has given some indication of the dates on which the orders were made to prepare for a mediation. The evidence completed at some point in December. From that time, the Commonwealth has been working to finalise a brief for approvals since the close of evidence. That has involved intensive work from, firstly, a council team of 5, including myself, a team of solicitors at KWM and a team at Defence. The team at Defence then has to liaise with other departments who have interest in the outcome of these proceedings so that they can all inform on the brief that ultimately needs to go to the Attorney-General so that he can be informed of the integers that go to settlement and make a recommendation and an approval of the amounts that might be offered at settlement, if any, at mediation, if any. It has not been for want of work that brief has been prepared, but it has taken a matter of some months to do that. The reasons for that, Your Honour, are because, as my learned friend has indicated, this is a case involving 7 bases.
When was the brief provided to the Executive Government?
On my instructions, it's with the Executive Government at the moment, as in it is with Defence, and it is then being progressed.
No. When was it provided? You said I just want to understand the chronology of what has occurred. So when was the material provided to the Executive Government in order for the Executive Government to start the process of giving instructions?
Well, the brief that was prepared by the legal practitioners was finalised firstly in the first couple of weeks of February, Your Honour. But it has then gone through a consultation process within Defence, working with Defence's legal advisors.
So it was provided to the Commonwealth at the beginning of February?
Yes. I believe it was within the first couple of weeks of February, Your Honour. It has then gone through a process of review within Defence and with other departments in order to analyse the material, and it was an extensive amount of material, Your Honour, in relation to each base, so 7 bases with an extensive amount of material going to all of the usual integers that go into making recommendations for settlement.
Given the material was provided to those instructing your solicitors in the first couple of weeks of February, your solicitors were under the impression until late on the 10th of March that they would be properly instructed for the mediation that would be occurring on the 21st.
That's my understanding, Your Honour, on the information available to me.
Solicitors behind you, don't you?
Yes. Yes, that is the case, Your Honour.
All right. Well,
Can I turn, Your Honour, to what needs to be done in order to facilitate the approvals? Because that's effectively, the Commonwealth is where it is. It has a brief, it's been prepared, it's going through the process of obtaining approvals. It's just a matter now of understanding the position of the Commonwealth in relation to what needs to be done to get it to a stage of final approval. My instructions are that there's approvals that need to go through Firstly, the Office of Legal Services Coordination and then the Attorney General's Department. That gets refined to a brief which goes to the Attorney General. In the period...
What was the middle step there before it goes to the Attorney?
The Office of Legal Services Coordination, Your Honour.
They provide for the AG's department, do they? Yes.
They're within the Attorney General's Department, but it's the delineation between the Office of Legal Services provision and then going towards the direct advisors of the Attorney.
Is there utility in your, I infer, no need to confirm this one way or the other, but it's not my first rodeo. No doubt certain advice is contained in the brief. No doubt that involves a decision-making process one way or the other by the responsible government officers, including, in this case, the Attorney. Now, it seems to me there are two ways of proceeding. One is, now that has been explained, to proceed with the mediation on the 21st on the basis that the applicants on one side can't enter into a bargain which can be enforced on that day because it would be conditional upon court approval under Section 33V in any event. And you say to me you can't enter into any bargain because even if it did involve the making of an offer from your client, would be still subject to approval by the Attorney. But you can still have a discussion on the 21st as to parameters for settlement, if I could describe it that way. That's one option, it seems to me. The other option is to defer it completely. I must say my inclination would be to allow it to go ahead on the 21st, even though one couldn't commit the Commonwealth to a final position until the executive government has gone through the processes it needs to do in order to deal with the matter.
That's the Commonwealth's preferred course, Your Honour, and it was communicated to my learned friend solicitors and it's recorded at paragraph 15 of Mr Alsop's affidavit. There's utility in my submission in addressing a few matters that will be at issue between the parties and might move the parties closer to an agreed basis for settlement. The first is obviously that there are legal issues of principle that can be discussed between the parties and that are in dispute. The second is that there are factual issues. There are obviously factual issues that go to liability. There are also factual issues that go to the size and the composition of the class in each of the base areas. And there are various integers that might go to a number that might ultimately form the basis of an offer for settlement, and they're discussions that the parties can meaningfully have. The last matter, Your Honour, is whether or not is investigating possible mechanics for distribution of the settlement sum. Your Honour, we're informed, for example, by the judgments Your Honour gave this morning as to two options for distribution. They are matters which, in my respectful submission, can be meaningfully and helpfully addressed at a mediation on Tuesday with Mr Jacobson's assistance, and all of those matters will go into my clients and my instructing solicitors being able to inform the Attorney of the ultimate basis on which settlement offers can be made. There's a real advantage both to the applicants and the Commonwealth in addressing some of these matters at a first stage of a mediation with the knowledge that it will assist the Commonwealth in being able to formulate offers that are then made at a resumed mediation.
All right, well, yes, look, I understand. Thank you. Mr Edwards, I understand your concern, particularly given the pendency, and your solicitor's concern given the pendency of the hearing date, but isn't the best course to proceed on the 21st in the hope and expectation that it will not be a kabuki dance? There could still be discussion. I mean, the reality is, and I am just inferring this from my knowledge of how the Commonwealth settles other cases. If and I don't know whether this is the case or not, I stress, but if the proposal is an amount be paid, which is the subject of a Section 33V application. And you can have discussions about that in the broad without committing the Commonwealth. Then isn't it better to have those discussions to see how far, if any, you're apart prior to and taking it as far as you can with Mr. Jacobson, with Mr. Jacobson not concluding the mediation, but he can then await what the final position of the Commonwealth is and then conduct some Henry Kissinger-style shuttle diplomacy.
Ron, this is not also my first time at the rodeo, nor is it my friend's first time at the rodeo, because it's a second mediation. Everything my friend says would possibly make sense if this was the first time the parties had met on the subject, but it isn't. And I'm obviously not going to reveal to Your Honour what happened at the first mediation. But
for all I know, the advice previously given to the Commonwealth would be that we can't reach a firm view as to the prospects of success until we've seen the completion of all the evidence and had the opportunity of considering it, which occurred post-December.
For all Your Honour knows, that might be the situation, but there's a whole lot of other alternatives as well, for all Your Honour knows. And what we are particularly troubled by is that what we are told is very carefully worded. They're not going to be in a position to make or respond to settlement offers. So at the best, if I choose and am instructed to make an offer on behalf of my clients, we're going to meet with deafening silence or a talk fest, which is not going to advance things, Your Honour.
Well, I mean, I would assume by respond, they would say they're not in a position to enter into a conditional agreement in relation to it at that time because it's beyond the authority of anyone at the mediation to be able to commit the Commonwealth in the circumstances. I think my inclination, Mr. Edwards, although I'm grateful for you and Mr. Alsop bringing it to my attention, is really to allow, I mean, there's highly experienced people on all sides, including you and including the mediator, to let it go ahead on the 21st. If it becomes apparent that it is, in truth, a complete waste of time, and that waste of time can be can be conveyed to me in some way that doesn't breach settlement privilege, then maybe I should do something about it. But I don't think I should vary. I don't think I should vary my orders. I think I should allow it to go ahead, but make it clear, and the transcript can be sent to Mr. Jacobson, that my preference would be, if he considers it's consistent with his role, just to not conclude the mediation, but can allow it to continue in April to the extent that he can, and hopefully he can entreat those within the Commonwealth to the extent that reality is the solicitors probably have very little ability to expedite what's going on within the department.
Why they're telling Mr. Alsop, Your Honour, that they're not even in a position to accept or exchange offers. So it's just a one-way street. It's just a listening, information gathering exercise. You're not even able to accept or exchange. That's in paragraph 11A of Mr. Alsop's affidavit. That's what he was told.
Just so I understand, sorry, let me ask Mr. Does that mean that you can't even discuss parameters of settlement? Or does that mean that you can't, when it says accept or exchange offers, you can't provide an offer capable of acceptance, or you can't accept an offer made?
Yes.
I mean, it would be a waste of time to turn up if you can't even discuss ranges of settlement and what you're likely to, and what might be something within a range, which it's not committing you, but which may or may not be ultimately the subject of approval.
I don't think I can tell you, Your Honour, that we could discuss matters that were in a range in such a way as to indicate some position as to in-principle agreement about what that range might be. What we can do, and what is of use, is to talk about the integers that go into a settlement sum. Things like Who's in the class? How do we categorise the people in the class? Things that will ultimately go to how it is both parties reckon the number when they make an offer. Can I add also, Your Honour, there's obviously a word missing in paragraph 11A. There's nothing preventing the Commonwealth from receiving offers and considering them. There's nothing preventing that. My learned friend seems to treat us in the front that he's forced to make offers. It's my learned friend's case. If my learned friend wants to make offers at mediation, then the Commonwealth will of course receive them. The only issue that's currently facing my client is that the Commonwealth cannot make offers and is unlikely to have instructions on that day to accept any offers that are put. But for my learned friend to suggest that it's a waste of time to discuss how it is a settlement sum or even the construction of a range is to be formulated is in my respectful submission a difficult position to maintain. That those are exercises that the parties would have to undertake anyway, unless this was a mediation proceeding on the basis of a pure horse trading exercise. And Your Honour, this case is too big for that. This case requires a considered examination of some of the integers that go into formulating a settlement sum before the parties could ever reach agreement. And there's real value in my respectful submission in that exercise being undertaken on Tuesday.
Well, I must say it is unsatisfactory we're in this situation, that we're not having, in effect, the Commonwealth being in a position to either accept or reject offers until so shortly before the initial trial.
I accept
particularly in
what Your Honour says.
circumstances where I ordered this mediation in September last year.
I accept what Your Honour says. The only thing I can say is that it has not been for want of effort, but it is the situation in which we find ourselves, and I accept that it is unfortunate.
What is the Commonwealth's position as to when it's going to be in a position to accept or exchange offers?
The present estimate is, and it's an estimate, is the 17th of April.
Month away. Are your solicitors and the understanding in that February would be enough time in order to obtain instructions if for a mediation, if it's going to take another month from now?
Your Honour, I'm not able to give an explanation as to why it has taken the time that it has taken, other than to say that work was done to a timetable that would have allowed for there to be instructions, and as matters have transpired, there was more work than anticipated. That is all I can say.
I mean, the reality is I'm faced at the moment where I don't know how many weeks set aside in my diary. I've got people screaming for hearing dates. I've already had to cancel a medical procedure in order to fit people in because I can't hear people in relation to another case. I mean, unless I do that. And yet, you've had the evidence from December, and we're now in the 10th of March, or the 16th of March, and I've got no instructions. So I don't know what I'm supposed to do. I mean, I had ordered a mediation to occur well in advance of this time, because I knew I'd need to have access to these dates if the matter settled. Now, can you just remind me, Mr. Edwards, is the Wreck Bay matter listed at the same time as this one?
The Wreck Bay matter is, Your Honour, and the mediation in that case
failed.
Proceeded and failed. But there's obviously a massive difference between that case running concurrently with this and this case settling, because then the Wreck Bay case would take, what, a couple of weeks or something without all these other sites, at most. But what Your Honour should do, in my respectful submission, is accede to my application, give them a couple of extra weeks till the date that Mr. Jacobson says he's got, and make them turn up and do it. We can't go into this on an unequal basis where they're hamstrung and where I'm expected to be the only person talking, in effect, at a mediation. It just isn't fair.
Well, Mr. Edwards, you don't have to do anything you don't want to do. If they're not in a position to participate actively, you can. But you and Mr. Jacobson, Ms. Gleeson, and those that instruct you are sophisticated litigators. I think the best course is for me to allow what's occurring on the 21st to continue to occur, for Mr. Jacobson to form a view as to when he should reconvene, after people can speak more frankly to him, including perhaps the Commonwealth can speak confidentially to Mr. Jacobson than I can. So I can't receive information that Mr. Jacobson may well be able to be apprised of. So I'm inclined. Now, I don't want you to feel you're in a situation where you have to, in effect, bid against yourself, but you must have a position on settlement which you would regard as one which would be consistent with your duties to form a fair that would amount to a fair and reasonable settlement in the interests of group members. I'm not sure whether that's been communicated or not. There may be other things that can be discussed on that day. If following the mediation on the 21st, it appears that there cannot be in the opinion of Mr. Jacobson, there cannot be a reconvening of the mediation in sufficient time for the mediation to be completed in advance of the initial trial, then I'd expect the proceedings to be relisted, and I'll just consider what should flow from that.
I must say, Your Honour, I'm very troubled by the course that my friend proposes. Well, I mean, Mr. Jacobson told Mr. Alsop, and on affidavit, he had one day, which is the 4th of April. My friend mentions a couple of other days that were apparently communicated, it's not in the evidence, this morning, both of which are before the day that she can give an estimate that her client might be able to give instructions.
I would hope that this, and I would expect the Solicitor for the Commonwealth to make it clear that what can be done to expedite the decision-making processes should be done. But the fact is, it's out of the control of Ms. Gleeson, it's out of the control of those instructing them. No doubt there's things that can be done behind the scenes to try to expedite things. But it's not as if I can make an order requiring the impossible, because it'll just mean that the Commonwealth will not make an offer because they won't have gone through the necessary approval processes to do it. It is not like a private litigant in that regard. That's the reality.
Not going to cavil with Your Honour's ruling, but the reality is that I'm being put in a position where I'm being told I have to turn up to a mediation not on equal terms with the Commonwealth, where they don't even have authority to accept an offer. They're just going to take anything I give, go away and think about it, and maybe come back, maybe not. That is not a mediation, Your Honour. And I should not be forced to turn up and say, well, here's my bottom line. Here's the amount that is fair and reasonable in the interest of group members. That's not a mediation at all. What they are proposing is a travesty. It's a farce.
Well, Edwards, if I'm going to allow it to you, your good sense and the good sense of the mediator for whatever occurs on the 21st to be done in such a way that does not cause prejudice to your client and the group members, but seeks as best one can to seek to advance the possible settlement of this case, because at the moment I can't see anything else that I can do which will likely increase the prospects of settlement. I'm not going to make some sort of self-executing order that if they don't turn up to the mediation, I strike out their defence. I'm not going to make an order that doesn't reflect the realities in which we find ourselves in. The fact is, you want, no doubt, the matter to settle. No doubt the Commonwealth wishes the matter to settle, provided a appropriate settlement can be struck. All I want to do is to do everything I can to get to that end. If you think it's inimical to settling the case for you to adopt a particular course on the 21st, then I perfectly understand that. I'm not asking you to do something which you perceive to prejudice your client's position. But I'd like Mr. Jacobson and you and Ms. Gleeson and whoever else is attending the mediation to do what they can on the 21st to advance this. I would request Mr. Jacobson not to conclude the mediation on that date and do whatever he can as a highly experienced mediator and former judge of the court to assist in facilitating the position of the Commonwealth being communicated as quickly as possible.
That's Your Honour's ruling. There's nothing more that I can say. Other than that, our friends have not, and it seems cannot, commit to whether they will ever be in a position to properly participate in a mediation. And Mr. Jacobson has no other dates, he tells us. So it's almost guaranteeing this matter runs to trial unless they give us some actual commitment to when they can turn up and have a proper mediation. And they should do that, and they should do it now.
Well, Mr. Jacobson could be informed of those things. If Mr. Jacobson believes he has insufficient time prior to the initial trial to be able to further these discussions to a state where there is a real exchange between the parties, then no doubt shortly on or after the 21st, that'll be communicated to me, and I will order you to go to mediation with someone else. But there's no point me ordering a mediation, you to go to another mediation until the Commonwealth has gone through the approval processes necessary for them to make an offer. That's the reality of the situation. And what I'll propose to do, because it has been necessary, it seems to me, for this matter to be relisted at no fault of the applicants, my current disposition was to order the Commonwealth to pay the costs of today, subject to anything Mr. Gleeson wishes to say.
I don't wish to be heard against that, Your Honour.
Well, I propose to leave my order in place. I propose to order the parties, in the event that the opinion of the mediator is such that a further constructive mediation cannot be concluded in front of Mr. Jacobson KC on or by the end of starts on the 8th, doesn't it? 8th of
May, I think, Your Honour.
what date?
Your Honour is asking about the initial trial.
Yeah, what day does it start?
I believe it's the 1st of May.
1st of May. On or by 20 April 2022, then the matter is to be relisted. Further orders concerning the completion of the mediation and the Commonwealth to pay the applicant's costs of today.
Please, the court.
Thank you. And court officer, if you could please go to the matter. You're excused, by the way. Take the hand. Sorry. Yes, Mr. Wybrow. Any re-examination?
Mr. Lehrmann, in your evidence when you were being cross-examined by Dr. Collins, he asked you a question about whether or not you received an email into your Hotmail account.
Yes.
You remember saying that you did in fact receive the relevant email?
Yes.
When did you become aware that you had it?
Approximately the week following the airing of the project, later in that week.
Dr. Collins also asked you some questions about various notes that were extracted off your phone or photos you'd taken of various notes.
Yes.
Do you remember that? Could you, if you have the exhibit book with you, go to, the brief 456.
Yes.
There.
Yes.
And you were asked questions about various names and dot points.
Yes.
And you said, in part, it was in relation to you making notes about media and things of that nature.
Yes.
Could you turn over to the following page, 457?
Yes.
Can you see a reference on that page to somebody called Vivian Tom? Yes. What were those notes about?
I object. This doesn't arise, Your Honour.
Examine about these notes, Your Honour.
Yes, I think if you were cross-examined about the notes, I think clarifying questions in respect to the same notes is within the ambit of Section 39.
You see the reference to Vivian Tom?
I do.
What were those notes about?
They were pertaining to the criminal matter and information that the former Inspector General of Intelligence had reviewed the CCTV footage.
As you recall looking at those now, did they have anything to do with your desire to speak out or go to the media or anything?
No.
You asked a number of questions about that aspect of these notes, about desire to go to the media, speak out or things of that nature.
Yes.
You asked questions relating to a reference to a potential PR consultant.
Yes.
Did you, in fact, at any stage prior to the conclusion of your trial, give a statement or a public statement?
No.
Did you go to the media?
No.
Did you hire a PR consultant?
No.
Why not?
Because Mr. Corn's advice was consistent that I was not to speak or commence any defamation proceedings until the conclusion of the criminal matter.
They're my questions, Your Honour.
Yes, thank you, Mr. Lehrmann. You're excused to go back to the court. Have the parties managed to work out what needs to be redacted from MFI1?
Yes, Your Honour, I've spoken to my learned friends. I understand the agreed position is that the personal phone numbers should be redacted. It's necessary on the basis of Section 37AG1C of the Act. But we don't seek that anything else be suppressed.
Yes. Is there a copy of that?
But not with the redactions marked.
No. But I was going to say, is it possible to get a copy of that with the relevant redactions, blacked out, sent through to my associate. I will tell you that I'll mark that as Exhibit A on the interlocutory application and Exhibit uploaded with the other evidence which has been read. A. Thank you. I should say, now, have you given some thought as to the terms of the order? For example, I have to give a duration. And on what basis is this put? Is this put on the basis of the safety of a person, or is this put on...
In my submission, it's on the safety of the person, on the basis of necessity to protect the safety of a person.
That'll have to be in the basis of the order, has to be in the order.
Yes, yes. Your Honour asked about duration. In my submission, it should be permanent.
Someone in 100 years can't get access to it? That's silly.
Ms. Grisanti is saying 10 years, and that's appropriate in my submission.
I think I'll make it for a period of 5 years, but give liberty to apply to extend it if for some reason someone wishes to extend it.
One remembers it.
If Your Honour pleases, and the ground of the order would be formally Section 37 AG 1C of the Act.
You could write out, if you could write out the terms of the order that you seek and give it to everyone else to make sure they're happy with it. Someone said it's when parties agree on an order where the court should be most vigilant, but it does seem to me that's a sensible order, and I'm satisfied it's necessary to make such an order.
I'm sorry, Your Honour. We'll send up a proposed order when we send the...
Well, I might have you sit outside with a pen and paper and do it and give it to my associate immediately upon my adjourning, and then send the redacted version out, because evidence in open court shouldn't be kept not accessible any longer than is necessary. Now, I go back then to the evidence that we dealt with, the affidavit of Mr. Fillons of the 1st of March, the 10th of March, 14th of March. I rejected 13, 14, 15 and 16 and 17. I made section 136 limitation respect of 18 and rejected 20 to 23, and I made section 136 limitation respect of the second sentence of 32 and second sentence of paragraph 42 was not read, as was paragraph 17 not read. So could I have a copy of the affidavit with those parts redacted, which were rejected, and with where I've made section 136 limitations, section 136 in the margin, please, and that provided to my associate. Now, in respect of I presume you did reject initially in the 14th of March affidavit, paragraph 4, but I presume that's not pressed now.
Not pressed.
So that's, I'll regard that as not read, and the balance of that can go in. Does anyone else wish to be heard in relation to any of
I
that?
think just to confirm, my learned friend, that paragraph 5 is in the same category.
We don't read paragraph 5 now.
Yes. All right. Well, I note paragraph 5 is also not read. Well, that means that the
Your Honour, I
affidavit...
notified objections to paragraphs 10 to 18 on the grounds of relevance.
Into 18? No, I can understand why that material is relevant. I propose to let that in.
Also, I notified an objection to paragraph 20 on the grounds of relevance. I'm not quite sure what's made of paragraph 20. Emails from Dr. Collins instructing solicitors accepting service. Service was accepted in our proceedings on the 8th of February.
Yes, I don't think paragraph 20 goes to anything.
We
Right,
don't.
what, paragraph 20?
Paragraph 20. Your
Paragraph
Honour.
20 is not read.
Yes, I wish to cross-examine Mr. Svillens, Your Honour.
Collins, would you come in? We'll get this dealt with today, if you wouldn't mind entering the witness box.
Oath.
Could you read?
I swear by Almighty God that the evidence I shall give will be the truth, the whole truth, and nothing but the truth.
Yes, thank you. Take a seat, please.
Formally identify the affidavit and ask for no. Sir, could you tell His Honour your full name and your professional address?
Paul Victor Svillens, 68 Pitt Street, Sydney.
And your occupation? And we referred to a number of affidavits that you sworn, but in particular, did you swear an affidavit dated 14 March?
I don't need to trouble you to do that. The material is in. Yes.
I have no further questions.
Thank you.
Perhaps that I know who Mr. Svillens is, Your Honour.
So do I.
Svillens, do you have access to your affidavits? Is the court book?
No, I don't have, if it's in there.
Yes, it's in the court book, your 3 affidavits. Do you mind turning to your affidavit of 1 March? Tab 5, which is at page 66.
Yeah, yes.
In relation to paragraph 2, you've sworn that all of the information that you deposed to in the affidavit was given to you on 1 March 2023. Do you see that?
Yes.
And your affidavit was sworn that same day.
Yes.
Is that because you showed Mr. Lehrmann a draft and he approved the content of the facts on that day?
Can't remember either. I think it must have.
It just seems like a lot of information to have obtained on 1 March. Is it?
Well, it was a work in progress, but by the time we reached this document, I think Mr. Lehrmann would have had it in front of him.
And he checked it so that you could swear to the paragraph 2 matter.
Correct.
Thank you. Now, since you've sworn that affidavit on 1 March, do you still say that all of the content is true, having regard to all of the documents you've seen since 1 March?
Sorry, where does he say it's true? He says his belief.
Yes, you still
he
believe
believes what
it's correct.
on the basis of material said to him. So you ask him to comment on the underlying truth of the representations.
I'm asking if he no longer holds the belief in relation to some of the matters because of documents he's seen since 1 March.
Yes.
And when did Mr. Lehrmann first approach Mark O'Brien Legal to be retained in relation to the publications, the subject of these 2 proceedings?
I can't say that. It was by Mark O'Brien from our office, so I don't have any knowledge.
You've deposed to the fact that at paragraph 15, at paragraph I'll just find where it was. At 43, thank you. That you first met with him on the 12th of December.
Correct. What paragraph, sorry?
43.
43. Yes.
I want to suggest to you that, in fact, Mr. Lehrmann retained Mark O'Brien Legal either on the 5th or the 6th of December.
Or
5th or 6th, which was a Monday or a Tuesday.
retained? No.
You recall...
well, sorry, I don't know. I can't tell you the precise date. I'm sorry.
I'll just show you.
When I say that, I'm not sure when we had a formal retainer agreement with Mr. Lehrmann, whether it was before that meeting or afterwards. I can't tell you that answer.
And you're not sure when he first approached Mark O'Brien?
No.
I want to show you a document that might refresh your memory. I'm showing you an article published in the Daily Mail on 7 December 2022.
A client of yours, I understand.
I wasn't sure if it was...
Chrysanthus as well.
Might be using a bit of inside knowledge here, Your Honour. Having a look at that article on 7 December 2022, do you see the paragraph? The first paragraph says Bruce Lehrmann has hired a top defamation lawyer as his hit list of media outlets comes into focus.
Yes.
And it says including the ABC and Lisa Wilkinson. You see that?
Correct, yes. I see that.
Over the page, there is what appears to be, in the second paragraph, a quote from you where you say, "We're acting in the matter."
Yes.
And it says you told the Daily Mail on Wednesday morning, and I just want you to take it from me, 7 December was a Wednesday.
Right.
Does that help refresh your memory as to when Mr. Lehrmann approached Mark O'Brien Legal?
It does, but I don't think that I had even spoken to Mr. Lehrmann at that stage, but I'm not sure.
But you were acting?
Well, if I'm quoted correctly, which I must be, then yes.
Having regard to the fact that this is your client that's
But
quoted
I still have to stand corrected as to whether or not we had a formal retainer agreement at that stage. I can't tell you about that.
But you accept he must have approached Mark O'Brien Legal at some point before the 7th of December.
Oh, I'm correct. Oh, yeah.
Now, the article also states that one of the people on the hit list was my client, Lisa Wilkinson. Do you see that?
Yes.
You accept that you understood very early in your interactions with Mr. Lehrmann that he intended to sue my client, Lisa Wilkinson?
One, I can't recall, and secondly, I don't know whether that's necessarily right. That this is before we had the meeting with Mr. Lehrmann on that date, and as I say, I don't even think that I had even spoken with Mr. Lehrmann. If I did, it would have been very brief. So I don't think either any person from our firm had met with Mr. Lehrmann prior to the meeting that's referred to in my affidavit. So I don't think that's correct.
Do you have any idea if Mr. Lehrmann was the source of this article?
No, none at all.
Now, you give evidence that you first met with him on the 12th of December.
Yes.
And that, in fact, letters of demand were sent to a number of parties on the 16th of December.
Yes.
And those letters of demand were sent to a number of parties, the first being Network 10. Is that right?
It was Network 10 and the producer of the project.
And then another letter sent to Samantha Maiden and News Life Media and another company?
As the one letter, yes, yes.
And there was a third letter sent that day to another media company for a different publication, not the subject of these proceedings.
I think that's right, but I thereabouts, around that time, certainly.
Now, you understood at the time you sent the letters that it was very urgent to commence proceedings on behalf of Mr. Lehrmann?
Yes.
And you understood that because of the expired limitation period in relation to the publications and subject of these proceedings?
Yes.
And you understood that any delay at that time could prejudice the availability of an extension of time to your client?
Yes.
You were in the Dukedore matter, weren't you?
Self, yes.
Where our client issued a letter of demand on the 26th of September 2019, the day after you were retained. Do you remember that?
It was quick.
And then proceedings were commenced a few days later?
Yes.
Now, you received a request, and I can take you to it to remind you of it. It's at Court Book 85. That's the letter that you referred to that was sent to Network 10, or the Executive Vice President of Network 10, and Christopher Bendel, the Executive Producer. You see that on
Yes,
16th
correct.
September?
Correct.
Sorry. And then you received a response from Thompson Gear at page 97.
Yes.
And noted that Thompson Gear informed you that they acted for Network 10 and Mr. Christopher Bendel.
Yes.
And asked for a longer period of time to extend to your letter of, to respond to your letter of demand.
Yeah, because it was Christmas, New Year.
And you, in response on 98, consented to that extension of time, but only on the basis that the extended period would not be relied upon in opposition to an extension of the limitation period. And you did that because you understood that there was a need for your client to commence proceedings immediately against those parties.
Promptly.
And there was nothing, was there, in any of that correspondence which suggested to you that my client, Lisa Wilkinson, was aware of or consented to that extension of time and the agreement that came with it?
That's correct.
Now, in your experience as a defamation solicitor, you're aware of many matters, aren't you, where criminal allegations are made by the media and there's no criminal process?
Yes.
And you've been involved.
Sorry, could we just clarify what's meant by criminal allegation? It's a very broad.
How is this going to assist me?
Your Honour, there's a question of reasonableness. Mr. Svillens is one of the most experienced defamation
I
solicitors.
don't need opinion evidence in relation to this issue.
Your Honour, what a reasonable defamation lawyer would have said to Mr. Lehrmann at the time, within the limitation period, we say could be relevant?
I don't think I need the solicitor for the applicant to give evidence concerning that.
In relation to, sorry, going back to your affidavit that I was asking about, sorry to switch back.
I thought you were asking him a couple of questions.
I was, Your Honour. I think I said 15 minutes. I said 15 minutes. In paragraph 6E of your first affidavit, you said that Mr. Lehrmann was employed until the end of March 2019. Do you see that?
Yes.
It was actually until the 5th of April 2019, wasn't it, when he was terminated? Now, having now seen the documents produced on subpoena?
You'd have to take me to the document. If the document says that, then I'm happy to accept that.
Now, in relation to paragraph 10 of your affidavit, you've referred to information that Mr. Lehrmann gave you about text messages he received from friends asking whether he was the individual, the subject of the allegations.
Yes.
I want to suggest to you that now that you've had an opportunity to review the text messages on 15 February 2021, there are no such text messages.
No, I disagree.
In fact, he wasn't asked anything to the effect of are you the individual, the subject of the allegations?
I agree with that.
Yes.
But I disagree with the earlier
second
question. The earlier question.
Right, so I'm suggesting to you that you have not seen any messages to Mr. Lehrmann from friends asking whether he was the individual, the subject of the allegations.
Correct.
Those are my questions, Your Honour.
Yes, thank you, Mr. Stevens. The only other witness, as I understand it, in your case is...
Was keeping the powder dry was Mr. Corn.
Yes. And we'll hear his evidence on the 23rd. I would prefer to start at 10:15 on the 20th.
Yes, I just wanted to confirm instructions. Happy to start then, but that is going to be the evidence for the applicant on his extension for limitation period time. We're not proposing to call Mr. Corn now in light of that evidence.
Yes. All right.
Oh, sorry, I apologise and thank my learned friend. There are medical records.
I'm quite happy. If you want to give some reflection to anything you wish to tender between now and the 23rd, I won't hold you to that at the moment. And then deal with your evidence. As presently advised, do you propose to cross-examine any of the respondents' witnesses?
No. As presently advised.
As presently advised, yep. So that'll mean after Mr. Corn, we can very shortly then move into addresses. If the parties, Dr. Collins, my practice is I only want one set of submissions from each side. No supplementary submission, just one set of submissions. So if you all want to put in a submission prior to the 23rd, updated by reference to the evidence which has thus far emerged, I realise you'll have to supplement that orally in respect of anything that emerges from Mr. Corn's evidence, then I'm happy for that to occur. My inclination is to make an order that Mr. Corn, if he's giving evidence, put on an affidavit by a particular date. Unless you particularly want him to give the evidence via voce.
Not from my perspective, Your Honour.
Assisted by an affidavit.
Well, perhaps you could put on that affidavit by stumps on Tuesday?
Absolutely, yes, we can do that, Your Honour.
Make an order that any affidavit by Mr. Corns be filed and served by 5 p.m. on, say, the
22nd.
Expectantly at my 21st of March. And I'll stand this application over part heard to 10:15 a.m.
Finally, Your Honour, I'm instructed to call on some notices to produce by Network 10 and the second respondent, Ms. Wilkins. Two.
We have documents. There's privilege claim in relation to that material, and we've prepared a privilege schedule, which I'll also hand up.
Have you seen this privilege schedule, Mr. Wybrow? Or is Mr. Olsen dealing with this?
Sorry, I didn't hear you, Your Honour.
I was just saying, are you dealing with this or Mr. Olsen?
No, well, I haven't got the notice in front of me.
Have you seen the privilege schedule?
We have, and we don't wish to be heard about the privilege objections.
Well, if the then I think I will. If there's no issue concerning privilege, then I'll solve the need to produce the privilege materials to the court.
I think it's all privilege material.
Oh, is it?
Yes.
All right. Any reason why I can't then, since there are no non-privileged materials produced and you don't challenge the privilege claim, can I just return this back to...
No reason, Your Honour.
Right, well, I'll note that the if for some reason the fact that there is no non-privileged documents is relevant, then you can tender the notice of producing on the 23rd. And I'll return those documents, yes.
So, Your Honour, we're in the same position. So we received a notice to produce. We have the documents in court in a sealed envelope. All of the documents, the subject of the notice, are subject to a claim of privilege. Our learned friend has had a schedule of the privileged documents, and as I understand it, accepts that the privileged claims are well founded.
Right. Well, then that'll be noted on the transcript, and I don't require them to be produced. Right. Is there anything further we can usefully do this afternoon?
Unless Your Honour would like us to read our material, subject to the further material.
Well, I'd like him to close his case first.
We haven't been notified of any objections to our material. I'm not sure if there is any.
Now, I'll also make an order that the affidavit I referred to earlier about verifying production of documents in accordance with the order I made on 8 March 2023 by a solicitor for the applicant also be filed and served by
4 p.m. on the 21st.
4 p.m. on the 21st. So having made those orders, if there's nothing further, then yes, so if what I'll ask you to do, Mr. Olsen, you go outside and haven't already done it, and prepare an order and just discuss it with your opponents for the confidentiality order. Because I propose, and can your solicitors go back to now and provide me with appropriately redacted versions of the affidavit, the affidavits that have been read, and also appropriately redacted version of the document which is now Exhibit A, which was formerly MFI1. If they're provided to my associate, then those documents will be loaded on the court file. Yes, sir. All right, thank you very much. I now adjourn.